Good morning. Welcome. Delighted to see you here today for this event where the Religious Freedom Institute and many of our partner organizations commemorate the 30th anniversary of the Religious Freedom Restoration Act and the 25th anniversary of the International Religious Freedom Act. And let me start by noting the most important thing. There's coffee and water over here. There'll be lunch served in the middle of the day. And this is a day where people will be coming and going. And so it's perfectly fine to make your way over there, grab another cup of coffee, and move around just a little bit. Well, 30 years ago, with large bipartisan support, the House and the Senate passed the Religious Freedom Restoration Act. The principal co-author of that piece of legislation was Chuck Schumer. And Senator Schumer said this at the time: "Tell to millions and millions of Americans that religion is a luxury." He was saying that sarcastically. You're telling them it's a luxury? I think we get the reaction that we've had universally here on the floor from the most liberal to the most conservative member. Quite simply, we cannot allow this to continue, meaning elites telling us that religion is a luxury or a not necessary part of life. Then he went on to say, "The founders of our nation and the American people today know that religious freedom is no luxury, but is a basic right of a free people." And that sentiment was expressed by many others in his party, Steny Hoyer, Nancy Pelosi, and others, and by many Republicans as well. And it really kicked off a period of time in the 1990s where there was a bipartisan effort on human rights legislation and religious freedom legislation. On the international front, there were human rights laws passed targeting the violations in North Korea and Sudan, the first elements of what later becomes the Global Trafficking in Persons Initiative. And these are largely led by non-governmental constituencies of religious folk and their allies from the right and from the left, pressing for fundamental dignity, for religious freedom, and for human rights. And one of the crown jewels of that era, of course, we're celebrating today the 25th anniversary of the International Religious Freedom Act. So there's a tremendous amount of energy in this time period around these things. Let me just set the stage with one comment about why these laws are so important. Our mission statement at the Religious Freedom Institute talks about 4 things, and these 4 things are illustrated in these laws. We try to achieve a broad understanding of religious freedom as a fundamental human right. In other words, something that is inherent to people as they search for truth all around the world, both as individuals and in their collectives. Second, it's a cornerstone for successful society. And when you look at the work of people like Brian Grimm and others, and you look at the statistics, you see that on indicators of freedom, economic prosperity, low levels of social hostility, that successful societies are characterized by religious freedom. Religious freedom is also an individual and a collective or social form of flourishing. It's important to recognize that religious freedom is not just the individual right to worship, but it is a public and a private right. It's something that individuals do, but also that collectives do. In fact, Nathan Berkeley from our team led an important study on the way that we have to protect the religious freedom, both of individuals, but also of religious institutions, meaning houses of worship, religious medical associations, orphanages, foster care, and the like, that all of those entities, which are made up by the faithful and do good work, that they're indispensable for a free society. And then last, that religious freedom is a driver of national and international security. And those who framed the International Religious Freedom Act understood that places with high levels of religious persecution and high levels of religious repression not only were violating the rights of their citizens or their neighbors, but that those were the places that were most likely to give birth to radical forms of extremism that turned to violence in those situations of oppression. So IRFA was needed, RFRA was needed. And today we're going to hear about, first of all, why these were so vital for U.S. foreign policy in the 1990s, and second, the many different ways that they're a part of the social fabric of our country today. Let me just say a few words about the way that the program will work. We'll start this morning with some remarks by Greg Baylor of the Alliance Defending Freedom, and then Greg will be followed by a panel that'll come up right after his talk here. And we'll proceed very briskly without a lot of chitter-chatter between the things, and then there'll be a break. We'll follow the program and the times there. At lunch, I'm delighted to say that we'll have Frank Wolf and Nina Shea here for a less structured discussion about their many years of work on behalf of religious freedom. And then in the afternoon, we'll turn our attention to the International Religious Freedom Act. We're delighted that you're here today. Would you help me in welcome Greg Baylor of Alliance Defending Freedom?
Thank you, Eric, and thank you all for coming today. I'm grateful to the Religious Freedom Institute for envisioning this event, for making it a reality, and for inviting me to participate. The Religious Freedom Restoration Act certainly is worthy of celebration, and I hope that everyone in attendance will come away with a greater appreciation of and understanding of this indispensable protection of religious liberty, our first and most foundational freedom. My task during these next few minutes is to frame things, sort of set the stage for this morning's panel discussions, which I'm sure will be fantastic, given the wonderful folks that you have enlisted to participate in those conversations. I look forward to hearing their experience and their insights about RFRA. But my aim for these next few minutes is for you to better understand three basic things. First, what RFRA is and how it works, what RFRA is and how it works. Second, the circumstances in which it was enacted, specifically, as Eric mentioned, the incredible bipartisan support and the support that went along various religious and ideological spectrums. Haven't seen anything like that since. And then finally, the third thing that I'd like to convey in these few minutes is how that consensus, how that amazing consensus, frankly fell apart during the following 30 years and leaves us in the state that we are today. So those are my three objectives, and let me move on to them. So, RFRA, what is RFRA? Well, put simply, it is a federal statute that restrains the power of government to interfere with religious exercise. A federal statute that restrains government's power to interfere with religious exercise. That's it, broadly speaking. We'll talk about the details in a minute. I think to understand the substance and the origin of the Religious Freedom Restoration Act, it is necessary to understand the Free Exercise Clause backdrop. So, of course, the Free Exercise Clause is a piece of the First Amendment to the Constitution. And its text essentially says, Congress shall make no law prohibiting the free exercise of religion. Now, 2 quick points to deal with before they get stuck in your head. It said Congress, right? The court has interpreted the Free Exercise Clause to restrain not just the federal Congress, but state and local governments as well. Second, the word prohibit. It is not necessary to violate the Free Exercise Clause to actually categorically prohibit somebody from exercising their religion. The courts have said that mere interference with or burdening someone's religious exercise is sufficient to raise free exercise questions. So, Congress shall make no law prohibiting the free exercise of religion. So here's the scenario. Suppose government sort of interferes with somebody's religious exercise. That person makes a complaint, typically to a court, and says, hey, court, help me out here, right? The government is interfering with my ability to exercise my faith. They're compelling me to do something that's against my religious conscience. They're making it harder to accomplish my religious goals. So they go to the judge, and then the judge is like, all right, what do I do now? He reads the text, she reads the text of the Free Exercise Clause, and does it provide an obvious answer? I'm not sure that it does. I mean, I suppose you could read the text to mean no prohibitions. Congress shall make no law, and that the religious claimant always wins. Well, we know that can't be the answer, right? I mean, imagine the scenario where someone has a religion where they believe it's necessary to sacrifice other human beings to pacify the wrath of the gods. That can't be the outcome, right? And it's because of circumstances like that one. I know it's an extreme example, but I think it illustrates the point. It's because of circumstances like that one that we don't have a religion always wins approach to the free exercise clause. When you have scenarios like that, judges inevitably develop tests. They develop tests. They identify the things that they're going to think about, the things that they're going to consider when they're deciding who wins, the religious claimant or the government. So, before I identify the test that's key to really everything that we're discussing today, let me back up and make an observation about two main ways that government can burden religion. Two main ways that government can burden religion. So government can target religion, right? They can say, we really don't like Hindus and we're going to pass a law that prohibits them from practicing their religion. We don't like Roman Catholics, we're going to pass a law that prohibits them from practicing their religion or some aspect of it. That's kind of an easy case, right, under the free exercise clause. And the courts don't really struggle too much with that sort of law or regulation that targets religious exercise. Now, thankfully, that is rare in our country. It happens sometimes, but it's relatively rare. The vast majority of the circumstances in which government interferes with or burdens religious exercise, it's not targeting, but it's simply applying a generally applicable neutral law. No one's out to get religion. You read the statute, it doesn't talk about religious exercise or whatever, and it's a law that applies to everybody. So religion is not being singled out. So the court, when it's dealing with targeting, it's easy. When the court's dealing with what I'll call incidental burdens, I don't mean they're incidental in the sense that the burdens are small. I mean they're incidental in the sense that they're not really intentional, right? They come as a byproduct of a statute that applies broadly to lots of people. What did they come up with for a test? Again, religion can't always lose, religion can't always win. How do you put them in the categories of wins and losses? In a 1963 case called Sherbert versus Werner, the Supreme Court developed a test that came to be called strict scrutiny. So, in our scenario, the person whose religious exercise has been interfered with comes to court, complains. What happens? The judge turns to the religious claimant and says, tell me how bad this is for you. Tell me the ways and the significance of the government's interference with or burdening of your religious exercise. If it's something slight and not very weighty, the court's going to say, the case is over, okay? You just haven't come up with enough. But suppose the person does say and proves to the court's satisfaction that this burden is weighty enough, that is substantial enough, and that such that something more has to happen. Okay, suppose that scenario. In that scenario, the judge turns away from the religious claimant and turns over to the government and says, you have a job. You have to justify this burden on the person's religious exercise. And they don't just say that, it's actually more specific. In the Sherbert test, they said government has to successfully answer two questions in order to justify that burden. The first one is, what are you guys getting at? What's your objective? What's the goal of this legislation? And what's the goal of applying it to this person who's come into court to complain? They want to know how weighty that interest is. And in the words of the test, and later in the words of RFRA, they use the word compelling. Is it a compelling state interest? And of course, not all interests are compelling, but again, the distinction between compelling and non-compelling is a matter of some debate, as we will probably see during the discussion time. So suppose the government is successful and says, yes, this is a compelling interest, it's life or death, it's national security, whatever. There's another question that the government has to successfully answer. And that question is this: hey, government, again, this is the judge asking the question, is there some other way that you can accomplish this objective? Is there some other way that you could advance the compelling state interest that you've identified? If they can't answer both of those questions to the court's satisfaction, then the religious claimant wins. The religious claimant gets an exception from this law that applies to everybody, is not targeting religion. So that's strict scrutiny. It's these three questions, right? So things were pretty good. People were satisfied with this test. They weren't always satisfied with how it was applied. Sometimes it wasn't applied in a way that was sufficiently respectful of religious freedom, at least in my judgment. Things dramatically changed in 1990. Changed in 1990 in a case called Employment Division versus Smith. Employment Division versus Smith. This was a case about Native American church members using peyote in their religious ceremony, religious sacrament. By the way, the amount of peyote they take is not strong enough to act hallucinogenically. But peyote does contain mescaline, which in this case came out of Oregon, was illegal under Oregon law to possess or to use. So they got punished, they got in trouble, right, with the state of Oregon, the two claimants in this case, for celebrating their sacrament using an illegal substance. And they went to court to make the free exercise argument, right? You're substantially burdening our religious exercise by criminalizing our exercise of our sacrament. And they expected the court to turn to the government and say, what's your objective? And is there some lesser way, less burdensome way of achieving it? They expected that to be the analysis, right, that the court undertook. Guess what? The court didn't use that analysis. They did not deploy strict scrutiny. They said, not only does this person lose, not because of an application of strict scrutiny, they lost because they changed the test, right? So when you're talking about, not targeting, when you're talking about incidental burdens on religious exercise, laws that are generally applicable, facially neutral, if there's a burden on religion, no matter how big, doesn't matter. We don't do strict scrutiny. We don't ask the magnitude of the burden. We don't ask about compelling interest. We don't ask about least restrictive means. The only question the court asks in a case like that is whether there's a rational basis for the government's action. Translation, religion loses. It's very difficult to win a case when the only burden or the only hurdle that the government has to get over is establishing that there's a rational basis. So this is not good. This is a problem. It's a problem because religious claimants lose a lot. It's also a problem because the vast majority of cases, religious liberty cases, are generated not by a law that targets, but rather by a law that incidentally burdens religious exercise. So the reaction among a lot of folks in the religious community, the civil liberties, civil rights communities was shock, dismay, but resolve. There was resolve to fix this. Obviously, you could fix it by waiting for the Supreme Court to reverse itself maybe decades later. That didn't seem very satisfying. You could amend the Constitution, tough thing to do. So the solution was to create a statute, right? To create a statute that reinstates strict scrutiny as the test for incidental burdens on religious exercise. And Congress thought it had, the authors of this bill in the Congress thought they had the authority to do this under Section 5 of the 14th Amendment, which gives Congress the power to enforce constitutional rights. So June 1990, Smith decision comes down. Within 7 weeks, a bill is introduced in the House. H.R. 5377, 99 sponsors in just 7 weeks. Why did this happen? There was a remarkable coalition, the Coalition for the Free Exercise of Religion, that coalesced quickly in response to the Smith decision. It was remarkable in terms of who its membership was, who led it and who was participating in it, all across the spectrum. The chair of the Religious Liberty Coalition was the Baptist Joint Committee. Professor Doug Laycock, then at the University of Texas, was a principal legal advisor to the coalition. You had the ACLU and the NAE, National Association of Evangelicals. You had left of center Reformed Jewish organizations. On one hand, you had the Southern Baptist Convention on the other. You had Christian Legal Society, you had Sikhs, Hindus, Muslims, Scientologists, everybody, more or less, was part of this. And the support was equally bipartisan. The sponsorship, if you look at the numbers, scores of Democrats and scores of Republicans in the 101st Congress and in the 102nd Congress. In the 102nd Congress in 1991, or actually the hearing in 1992, I think that was kind of the main event in the legislative history of the Religious Freedom Restoration Act. And one of the most compelling scenes was when Nadine Strawson, the president of the ACLU, gets in front of the Congressional Committee and testifies in favor of the Religious Freedom Restoration Act. And up comes after her Mike Ferris, who was then with the Homeschool Legal Defense Association, later Executive Director, President, Chief Counsel of Alliance Defending Freedom, my organization, many years later. So you have Strawson and Ferris, Republicans and Democrats, Christians, Jews, Sikhs, Hindus, Muslims, secular organizations, all supporting the Religious Freedom Restoration Act. So 101st, 102nd, didn't pass though. Why not? Does anyone know? Does anyone know why it didn't pass? Like what the hiccup was, what the problem was? Anybody? Yep, that's exactly right. Yes, that's exactly right. If everybody didn't hear that, the primary concern or hesitation about RFRA came from the U.S. Conference of Catholic Bishops and from the National Right to Life Committee. They were concerned that, number one, that Roe was about to go, right? The Planned Parenthood versus Casey case was on the docket. There was hope among the pro-life advocacy community, pro-life individuals, that the Supreme Court would do what it eventually did many years later, which is to overturn Roe. And folks were looking ahead, understandably, and thinking, okay, what'll be the next argument about where there's a right to abortion in the law? And there was a concern expressed by the bishops and by National Right to Life that RFRA might be it. And so they proposed amending the bill in order to make clear that that was not a way that RFRA would be used. So I think it's somewhat ironic in hindsight that you know, those were the primary, I don't want to say opponents, but people who had concerns about the bill. Well, some adjustments to the bill were made. Planned Parenthood versus Casey did not turn out the way that many had hoped. So the fear of RFRA being needed as a abortion right source kind of went away. And also President Clinton was elected. There was more openness on the part of candidate Clinton and then President Clinton than there was on behalf of President George H.W. Bush. So in the 103rd Congress, it finally becomes law. 170 co-sponsors in the House, 170 co-sponsors in the House. And as Eric said, Chuck Schumer, who was not a senator but a congressman back then, and Chris Cox, a conservative Republican from California, were the primary sponsors. In the Senate, 60 senators. Again, scores of Republicans, scores of Democrats. The lead sponsor, one of the lead sponsors is one of the three Kennedys after whom this room was named, Ted Kennedy, and his partner was conservative Republican Orrin Hatch from Utah. They were the prime co-sponsors. In the House, unanimous voice vote to pass this bill. Goes over to the Senate, they do take a roll call there, 97-3. Passes 97-3. And on November 16th, 1993, President Clinton signs the Religious Freedom Restoration Act. And it does what strict scrutiny did under the Free Exercise Clause. It asks these three questions: substantial burden, compelling governmental interest, least restrictive means. It gives you a cause of action. You can go into court, you can sue, you can use it as a defense, and if you win your case, you can get attorney's fees, which is a good thing for those of us who litigate RFRA cases, if we win. So that was RFRA. My last point is about how the consensus quickly broke down. I mean, this tremendous moment where there was widespread agreement about the value of religious freedom and about the necessity of something and the wisdom of something like RFRA. In 1997, the Supreme Court decided a case called City of Bernie versus Flores. What was at stake there? Well, the argument was that Congress, when it enacted RFRA, and when it invoked Section 5 of the 14th Amendment, that piece of the Constitution that gives Congress the power to protect constitutional rights, that Congress went too far. It went too far, right? But only with respect to the states and local government, right? Because there's different standards about the federal government regulating itself and the federal government regulating states and localities. So the court essentially struck down RFRA as applied to the state and local governments. So RFRA no longer restrains, to this day, state and local governments. So that was a serious blow. The RFRA Coalition, there were many organizations that were part of it. By this time, I was involved in the movement, and there was a desire to get the coalition back together, get the band back together, and fix the concerns that Congress had about congressional authority. Well, there was some success with that. Democrats and Republicans were still supportive of something called the Religious Liberty Protection Act, but ultimately it did not pass. And I think it's fair to say, I know that the story's a little bit more complicated than this, but the essence of why it didn't pass is because folks on the left end of the spectrum saw how the Religious Freedom Restoration Act and religious freedom arguments more generally might be used to defend against the application of laws forbidding sexual orientation discrimination and later gender identity discrimination. So it was this conflict, the beginning of this conflict, right, between LGBTQ interests and religious liberty on the other hand, that I think it's fair to say was responsible for the failure of the Religious Liberty Protection Act. The situation was salvaged to some degree. Congress did pass a law called the Religious Land Use and Institutionalized Persons Act, which are important areas, but they don't touch on the sort of hot-button cultural issues that would have been in the Religious Liberty Protection Act. So I think, that's the primary illustration of how this wonderful, harmonious consensus kind of fell apart. I think another evidence is the Equality Act. You probably know the Equality Act is a proposal that would essentially add sexual orientation and gender identity to a series of federal anti-discrimination laws. Title II about public accommodations, Title VII about employment, housing, recipients of federal financial assistance, and so on and so forth. And I think it's fair to say, I think everyone would agree that that proposal would inflict burdens, serious burdens on certain folks' religious exercise. So what did the drafters of the Equality Act do? They said that the Religious Freedom Restoration Act will not be available as a defense to any claim brought under the Equality Act. So this is sort of a remarkable thing, given back when the coalition was happening, one of the mantras of the coalition was no exceptions. There was pressure to carve out the military. There was pressure to carve out prisons. There was pressure to carve out this, that, and the other thing. And the coalition stayed unified and said no exceptions. And here we are with a gigantic exception if it ever became law. So pushback, serious pushback, and a dissolution of that consensus. Let me close by quoting President Bill Clinton and what he said in his signing remarks in November of 1993. We all have a shared desire here to protect perhaps the most precious of all American liberties, religious freedom. Usually the signing of legislation by a president is a ministerial act, often a quiet ending to a turbulent legislative process. Today, this event assumes a more majestic quality because of our ability together to affirm the historic role that people of faith have played in the history of this country and the constitutional protections those who profess and express their faith have always demanded and cherished. What this law basically says is that government should be held to a very high standard, a very high level of proof before it interferes with someone's free exercise of religion. This judgment is shared by the people of the United States as well as by the Congress. We believe strongly that we can never be too vigilant in this work. I confess I think it's sad that that sentiment is not more widely shared today, but I think that reality ought to give us resolve to continue protecting not only the Religious Freedom Restoration Act itself, but the religious freedom that it is designed to protect. Thank you very much.
We're going to proceed right to our first panel, and then as you see at the end of this panel, there's going to be plenty of time for some Q&A with our panelists. So I'm going to ask them to go ahead and come up right now, and then there'll be a 15-minute break at the end of this panel. Let me just remind you, we'll hear from each of the three, and then what will happen is there'll be a chance for Q&A. And when that time comes, what I'd ask you to do is to, our moderator, Ariel Del Turco of the Family Research Council, raise your hand, she'll call on you, and if you'd stand, identify yourself and your affiliation, and then ask a brief question so that lots of people can participate today. I'd appreciate that. Without further ado, let me turn it over to my good friend, Ariel Del Turco, to lead this panel.
Thank you, Eric. Well, good morning, everyone. As Eric mentioned, my name's Ariel Del Turco. I'm the director of the Center for Religious Liberty at Family Research Council. And it's an honor to be kicking off our panels today. Greg gave a great overview of RFRA, the history and the background of the statute and why it's important. So I'm excited to be digging in a little bit deeper with our panelists here today. And as Eric mentioned, we will have a significant amount of time for questions and answers after with our panelists, so please raise your hand and you will be called on after they present. So I'm just going to briefly introduce our panelists before allowing them to give their opening remarks. First, we will have Cassie Doolin. She is the Director of Government Affairs and Counsel at First Liberty Institute. We also have Jenny Bradley Lichter, who is Deputy General Counsel at the Catholic University of America. And last but definitely not least, we have Howard Slew. He is the founder and General Counsel at Jewish Coalition for Religious Liberty. So to start off our panel, I'm going to hand it to you, Cassie.
All right, thank you so much, Ariel. Well, good morning, everyone. It's great to be here. As Ariel said, my name is Cassie Doolin, and I am Director of Government Affairs and Counsel at First Liberty Institute. We are a pro bono religious freedom law firm, and we have had the privilege of fighting and winning RFRA and IRFA cases across the nation. And I'm excited to be here today to talk to you about IRFA. Our other panelists will follow up on Greg's excellent presentation and share a little bit more with you about RFRA. But as Greg touched on, there was another statute passed in the wake of Employment Division versus Smith and then Bernie called IRFA. So today I'm going to talk about three things. That is what IRFA is, how it relates to RFRA, and why it is vital for the U.S. to protect it. And I'd like to start with two brief stories. The first is the story of the Christian Fellowship Missionary Baptist Church in the 5th Ward of Houston, Texas. In the 1970s, the 5th Ward was the highest crime area in Houston. Locals say that people shot first and asked questions later. But for Pastor Quentin Smith, that danger was just evidence to him of how much the people in that area needed Jesus. So he and his family started the Christian Fellowship Missionary Church in the 5th Ward. Partnering with other local churches, they began ministering to drug addicts and alcoholics and even gang members. They ran vacation Bible schools, opened a food pantry, and set up a faith-based youth center. And Pastor Smith actually told me that one of his favorite things to do as a pastor was to give away bicycles to kids at Christmas time. The church's decades of ministry eventually transformed the 5th Ward, and property values soared. And the Houston Housing Authority took notice of this and began an aggressive gentrification plan. They first put pressure on Pastor Smith to sell the church, and when he said no, they threatened to use eminent domain to condemn the land and bulldoze the church. Pastor Smith said that a housing authority representative came to his church and said, from the pulpit, I'd like to buy the property, but if you don't sell it to me, eminent domain will get it. So what could the church do? Is there a law that could protect them in this scenario? I'll answer those questions in a moment. But my second story is about John Ramirez, who was a death row inmate scheduled to be executed by the state of Texas. And in preparation for his execution, he sought to have his Southern Baptist minister touch him and pray over him out loud as he was executed. Two forms of religious practice with a long history in the United States, and that many other states allowed, and even Texas had allowed until very recently. But Texas said no. So what could John Ramirez do? Is there a law that could protect his religious freedom in a scenario like this? I'll tell you how those stories ended when I concluded, but I will give you a sneak peek of the ending now, because both stories have happy endings in terms of how religious liberty was protected, and it's all because of RLUIPA. So I'm going to tell you now what RLUIPA is and how it relates to RFRA. And as Greg excellently explained, RFRA was enacted in response to the Supreme Court decision of Employment Division versus Smith. And it was very clear that RFRA applied to the federal government, but it was less clear that RFRA applied to the states. So the Supreme Court heard a case called City of Bernie versus Flores, asking whether RFRA could exempt a church from local zoning requirements. And the Supreme Court said no. The court found that applying RFRA to the states would exceed Congress's Enforcement Clause powers under Section 5 of the 14th Amendment. So after Bernie, Congress's goal of protecting religious liberty nationwide was substantially hindered. So Congress held a series of hearings on protecting religious freedom after Bernie versus Flores. And the hearings revealed that local governments were regularly using land use laws to create no church zones. They used zoning laws, landmarking laws, special use permits, occupancy permits, and even eminent domain to discriminate against and even bar houses of worship, religious institutions, and religious schools from certain jurisdictions. The congressional hearings also revealed that persons in government institutions, such as prisons, jails, and mental facilities, are often denied the ability to practice their faith. Some prisons were barring Jewish inmates from wearing yarmulkes, denying Catholics access to communion, and shutting down evangelical Bible studies. Some prisons banned kosher food, confiscated sacred texts such as the Bible or Quran, and, in one extreme instance, violated the seal of the confessional by bugging inmates' confessions to their priests. And it's so appropriate that our hearing today is in the Kennedy caucus room. I smiled when I walked up and saw that, because in response to these congressional hearings, Senators Orrin Hatch and Ted Kennedy introduced a landmark bipartisan religious freedom bill called RLUIPA, the Religious Land Use and Institutionalized Persons Act. And RLUIPA received support, just as RFRA did. It received the support of a diverse coalition of civil rights groups. Everyone from the American Civil Liberties Union and People from the American Way to CLS and Family Research Council. The bill passed Congress unanimously, and President Clinton signed RLUIPA into law on September 22nd, 2000. I provided to you guys a handout of RLUIPA's statutory language, but the top line summary is that RLUIPA protects religious freedom as it relates to land use regulations and institutionalized persons. And that's the big idea behind RLUIPA. But since we have a lot of policy aficionados in the audience, I'll dive a little deeper into the bill's language. And in a 2021 case, the Supreme Court actually called RLUIPA the sister statute of RFRA, because both statutes aim to ensure greater protection for religious exercise than is available under the First Amendment. So sections 2A and 3 of RLUIPA are very similar to RFRA, and as Greg so excellently explained, creates a strict scrutiny test, saying the government cannot substantially burden the religious exercise of a person without a compelling interest that is achieved by the least restrictive means possible in the areas of land use regulations and institutionalized persons. And section 2B has a very unique and cool section that is called the equal treatment section, because it requires the government to treat a religious assembly or institution equally as well as a non-religious assembly or institution. I just call that non-discrimination, but hey, whatever works for Congress. Section 2B also prohibits discrimination against an institution on the basis of religion and prohibits totally excluding or unreasonably limiting religious institutions and jurisdictions. Section 4 contains a cause of action, and Section 5 says our LUPA should be construed broadly to the maximum extent permitted by the terms of the Act and the Constitution. Section 6 says our LUPA does not affect the Establishment Clause, and Section 7 actually amends our LUPA to give our LUPA a broader definition of religious exercise. And that definition, which is in Section 8, says religious exercise covers any exercise of religion, whether or not compelled by or central to a system of religious belief. So that's what our LUPA is and how it relates to RFRA. And the last question I want to address today, my third point, is why it is vital for the U.S. to protect our LUPA. And I'll answer this question by going back to the stories I told at the beginning. It is vital for the U.S. to protect our LUPA, to protect the free exercise rights of the Fifth Ward Church, of John Ramirez, and of many, many others. Because in the Fifth Ward case, they came to us at First Liberty, and we filed a lawsuit against the Houston Housing Authority, explaining that our LUPA, along with Texas's RFRA, protect the church's right to religious land use. And after a court hearing, the Housing Authority realized the law was definitely not on their side, and so they voluntarily ended all eminent domain proceedings against the church. And the church stands to this day ministering to the residents of the Fifth Ward to the glory of God. Inmate John Ramirez appealed his case to the U.S. Supreme Court, and First Liberty filed an important brief explaining that our LUPA protects Ramirez's right to clergy touch and prayer at his execution, a historical religious practice, and that our LUPA's strict scrutiny standard required Texas to prove it has a compelling interest in refusing to grant this particular exemption to this particular inmate under this particular set of facts. And Texas had failed to do that. But in March 2021, the Supreme Court agreed with First Liberty's arguments and issued a landmark our LUPA victory, with Ramirez winning 8-1. The ruling put state and local governments on notice that, under our LUPA, they cannot issue arbitrary rules that restrict religious freedom. And it also ensured that Ramirez could receive spiritual comfort and guidance in the final moments of his life. So our LUPA mattered for the Fifth Ward Church, it mattered for John Ramirez, and it matters for the clients that First Liberty represents every day, from pastors to prisoners, as well as for churches, synagogues, mosques, faith-based homeless shelters, after-school programs, food pantries, religious schools, and so many others. Our LUPA protects Americans' religious freedom. And to ensure religious freedom flourishes in America, it is vital that the United States protects our LUPA. Thanks, Ariel.
Thank you, Cassie. Jenny, go right ahead.
Thank you. Good morning, everyone. Thanks for being here to talk with us about RFRA and religious freedom. So again, the theme of our panel is 30 years after its enactment, why is RFRA still so important? How does it continue to protect people of faith and religious organizations? And why do we all feel so strongly that we want RFRA to continue to endure despite occasional threats to eviscerate it? So again, just kind of quick review that RFRA protects a sphere of religious exercise that the government essentially can't touch, right? So as Greg talked about, in this way, it's unlike the Smith approach to First Amendment jurisprudence, which actually tolerates burdens on religious liberty, as long as the law in question is facially neutral and generally applicable, right? RFRA is, in a way, an even better tool for religious organizations. It offers more protection because it tolerates burdens on religious exercise only in the really very rare cases when compelling the action or the omission of that particular person or entity by the government is necessary for good order in some way. So that's the theory. I'm going to talk a little bit more about kind of the real-world impacts of RFRA through the lens of my own experience as a religious liberty practitioner in and out of the government. 30 years on, how does RFRA continue to shape our legal landscape, in other words? So first point, RFRA shapes actions taken by the executive branch. It really does. The administration in which I served as a DOJ official and then a senior policy official in the White House, the Trump administration, was very oriented towards maximizing religious freedom. So we were not often in a position where we were running right up against RFRA guardrails and being sued because of it. But that's in part because as a team, kind of across the board, our legal approach and our analysis was shaped by RFRA ex ante, right? The lawyers in the Trump administration had all been raised on RFRA, essentially, right? I went to law school, and many of my colleagues in the government went to law school, as many of us did who are lawyers, in RFRA's world. That's the only world we knew, so we were very aware of RFRA and what it required. The DOJ really led the way in the previous administration, as you probably recall, to ensure RFRA compliance across the entire executive branch. In October 2017, Attorney General Sessions issued a really interesting and I think still really important memorandum on religious liberty protections in federal law. I often recommend that memo to younger people or to law students who are kind of just getting to know religious liberty law. It's a really fantastic primer, and to my great delight, it's still available on the Department of Justice webpage, so you can look that up and read it if you want just kind of a really good deep dive into religious liberty law. Several of the 20 principles in that memo specifically addressed RFRA and essentially laid out that kind of interpretive canon that government lawyers were expected to be using when they litigated RFRA cases. Some of those principles were pretty straightforward and I think relatively non-controversial, but some of them restated the law in a way that I think for some people was a little bit of a paradigm shift, right? So the government was very careful not to be doing anything new. We were saying what the law is, not what it should be. But it's important to remind people, including government litigators, of things like RFRA does not permit the federal government to second-guess the reasonableness of a religious belief, right? The government should not be in the business of going into court and saying to religious litigants, you are wrong about what your faith requires of you, right? That is something that the Attorney General took off the table in the previous administration. He was right to do that. That is what RFRA requires. Another very important point, especially in the wake of many years of litigation over the contraceptive mandate, which you all remember, RFRA applies even where what the religious adherent is asking for is an exemption from a legal obligation that would otherwise require them to confer benefits on a third party, right? This is the so-called third-party harm argument that's pretty significant in a lot of RFRA litigation. So I think the Attorney General did a great service to the government and to the religious freedom community by reminding everyone of those principles. We also put in place some process protections in the government in the last administration, requiring litigators across the DOJ to submit any brief raising a novel religious liberty question, to submit it to Main Justice, to kind of the Religious Freedom Brain Trust, to review that brief, to make sure not only that the government's litigating position was appropriate, but also that the arguments we were advancing in court were appropriate, again, and consistent with those principles we just laid out. I had the great privilege and the fun of performing that task for a while when I was at the Justice Department, reviewing the briefs that were coming in from all over the country and talking through with our litigators how we wanted to be litigating religious freedom cases. We launched a religious freedom task force. That was actually a RFRA 25th anniversary action when we held a big summit in the Department of Justice Great Hall 5 summers ago. A couple of other quick marquee RFRA-related actions in the previous administration that I'll highlight before moving on were the settlement of that contraceptive mandate litigation in 2017. That was explicitly driven by the administration's recognition that the rules promulgated and the litigating positions taken by the executive branch up until then violated RFRA. That was the basis for that settlement. The Trump administration also granted waivers to South Carolina, Texas, and Michigan so that they could continue to contract with faith-based foster care providers, despite the then operative non-discrimination provision in HHS regulations, which seemed to render faith-based providers ineligible. The department's rationale in granting these waivers, and again, they were very clear and explicit about this in their publicly available letter to the governors of those states, was that requiring compliance with that non-discrimination provision would be inconsistent with RFRA. In other words, they were basically saying, we have to do this, RFRA requires it of us. Even in the previous administration, invoking RFRA was not an automatic win, however, so one example of a RFRA defense that the Trump administration vigorously opposed was a case in Arizona in which an immigration advocate was charged with harboring illegal aliens. That's the legal term, as you know, no offense meant. And as part of his defense, he made a RFRA claim. Basically, my faith requires me to render aid to these folks as they're making their way across the desert. He said prohibiting him from doing that was substantially burdening his religious exercise. The administration did not think that was a very good RFRA argument. So I think we can just put a peg in that, but an interesting question here about what happens when religious freedom runs into other key policy priorities, even in a very religious freedom forward administration. That brings us to where we are now. We do not currently have a very religious freedom forward presidential administration, I would say, and I don't have any information about their internal communications, but I will say I strongly suspect that the existence of RFRA and the success of RFRA claims in recent years in court has shaped their rulemaking behavior too. That's certainly how it seems to me. In my view, this administration has been more solicitous of religious liberty rights than was the Obama administration, and I think that's really interesting, and I do think that's because of RFRA. I think you can see that in the way they shape some of their key rules, their rulemaking activity. This is not to suggest they're getting it all right. That is not my view, but I do think their attention to identifying and addressing these concerns says a lot about the prominence of RFRA rights and the success of RFRA claims, and the contraceptive mandate cases in particular, which I suspect haunts everybody on that side of the aisle, probably. So a few examples of this: the HHS grants regulation, NPRM. This is taking down that bad non-discrimination provision I mentioned a few minutes ago. This NPRM, the department takes seriously its obligations to comply with federal religious freedom law, including the First Amendment and RFRA. It will continue to comply with these legal obligations. The department is fully committed to respecting religious freedom laws. And then they go on to lay out, they're proposing a religious exemption, which doesn't work very well, but it's a good start, right? And they'll get a lot of comments kind of pushing them in the right direction. The Pregnant Workers Fairness Act proposal from the EEOC, for which I think the comment period is still open, so there is still time if you want to comment on this. Again, they flag religious entities might have a defense to a PWFA claim under the First Amendment or the RFRA, and then they engage with what that ought to look like, and they ask for help. They solicit comments on kind of figuring out how to put together a workable religious exemption there. The contraceptive mandate NPRM, yes, another one, issued in February, in which HHS proposed rescinding the exemption for moral objections, but they say, however, given the large number of entities that have religious objections to contraceptive coverage and the fact that RFRA, in some circumstances, might require religious exemptions from such coverage, they got the message after many years of litigation. The departments are retaining the religious exemption. That is a huge win. That's a huge win. These are the same people who fought for years and years during the Obama administration in their previous jobs to try to make religious organizations provide free abortifacients and contraceptives. Huge win that they're not even going to try. So that is all many, many thanks to RFRA and to the many excellent litigators who push RFRA forward and make it clear that RFRA is very strong protection for religious organizations. Second, RFRA preserves space for faith-based institutions to follow their missions. At Catholic University, where I currently work as a lawyer, we are very well aware of our rights under RFRA. Although we haven't had to litigate against the government in the handful of years since I've joined the university, Catholic University did litigate over the contraceptive mandate, as did much of the Catholic world. RFRA is super important for us in our internal decision making, and it's an important thing for any religious institution to have in our back pocket. I'm going to just kind of zoom out, speak at a general level, so I'm not revealing any privileged conversations with my on-campus clients, but here's just a few examples of times when the existence of RFRA and the possibility of invoking it if you needed to is certainly front of mind for faith-based institutions as they make operational decisions. So, example, again, the contraceptive mandate NPRM. One problematic element of it is the proposed treatment of free contraceptives for college and university students. So right now, if an institution of higher education is exempt from the mandate because of their religious beliefs, their health insurance issuer is functionally exempt as well. That's the way the law is currently set up on this. But the Biden administration is proposing, they said, we would like comment on what challenges or concerns might exist if an objecting religious college or university student health plan sponsor had a separate and independent obligation to provide contraceptives to students, despite the objections of the organization. My particular religious institution of higher education took them up on that invitation, and we submitted a comment conveying that we would be very concerned indeed, actually, if this is where the final rule lands. I actually think they won't go this route because I think they will get a lot of comments in addition to ours explaining to them patiently that this would be a RFRA violation. And again, I think that years-long litigation is going to convince them that they should not impose that requirement. But if they do, any religious college or university with a religious objection to providing free birth control to its students will feel very confident about its chances of prevailing in litigation thanks to RFRA. Final example, and then I'll wind down. Bostock, the Bostock universe. Although Justice Gorsuch and the majority that he was writing for left open the question of whether and how their new interpretation of sex discrimination would apply to religious employers, he explicitly flagged that several religious liberty protections would be relevant to any future analysis, including RFRA, which he described as, quote, a kind of super statute. As far as I'm aware, this is a promotion for RFRA. I don't remember seeing that language, but it is fantastic. Thank you, Justice Gorsuch. This is a silver lining in an otherwise tough decision. Being able to point to that flag firmly planted by the Bostock majority is very important for religious employers, particularly because Justice Gorsuch went on to note expressly that RFRA might supersede Title VII's commands in appropriate cases. That is the litigating hook that religious organizations will use when they have to litigate over this, and they will. These problems are coming. Catholic Relief Services is the tip of the spear on this, and I'm sure many of you are following this case. They are currently in federal court defending a suit brought by a current employee who's in a same-sex marriage. CRS made things harder for themselves by initially providing health benefits to that same-sex spouse and then turning around and saying, sorry, that was a mistake, we actually don't do that. We can't give you health benefits. We will give you some extra money so that you can go out and get your own. But the employee brought federal and state discrimination claims anyway, against CRS, which raised several defenses, including RFRA. The district court rejected CRS's RFRA argument, saying, this court finds as a matter of law that RFRA restricts the government rather than private parties, and so CRS cannot assert RFRA as an affirmative defense in this case, and that litigation is ongoing. This question about whether RFRA can be invoked when the government is not a party is a really important open question about RFRA's application, particularly moving forward when a lot of religious freedom activity is going to be in the employment space, which means the litigation will be between private parties very often, right? So as we sort out what Bostock means for religious institutions, this key question is one to watch about RFRA. 30 years on, all of a sudden, this gap in the way the law was written is going to become really crucial for religious organizations. So I'll stop there. I'm happy to talk further during Q&A about all of this. But bottom line, RFRA continues to be deeply significant. I hope it survives and thrives for many more years.
Thank you, Jenny. That's a really interesting inside scoop into how RFRA affects not only court cases, but presidential administrations. So Howard, over to you.
Sure. And I'm going to talk about the ways that RFRA uniquely affects religious minorities. And we've been talking a lot about the case called Smith, Employment Division versus Smith. So RFRA is uniquely important to religious minorities because Smith was uniquely harmful to religious minorities. In fact, Smith makes a lot of predictions about the future, and I think the only thing that Smith got right is that it would uniquely harm religious minorities, which the case itself says. So as we've mentioned a lot of times, Smith withdrew First Amendment protection from laws that are generally applicable and religiously neutral, but still burden religious faith. And Smith said in those cases that religious Americans should rely on the political process rather than the Constitution. The court recognized this would harm religious minorities, and it said that its ruling, removing the constitutional protections, would place at a relative disadvantage those religious practices that are not widely engaged in. So in other words, religious minorities. This is true for two main reasons. First, Smith removed protection from laws that incidentally burden religion. As Greg said, incidentally doesn't mean minorly, it means as a secondary effect, not as its primary purpose. So it should be pretty obvious that a legislator who's passing a law is more likely to burden a minority faith that he hasn't heard of or doesn't understand than a majority faith. For example, a legislator is much more likely to burden a Jewish holiday like Sukkot, which is currently going on right now, than a much more well-known holiday like Easter or Christmas. Second, Smith instructed religious minorities to rely on the political process. Well, religious minorities, being smaller by definition, are less likely to be able to prevail through the political process. In practical terms, this means that RFRA and its state analogs and RLUIPA are the primary defense against these types of laws for religious minorities. And this is not just theoretical. There's a law review article that looked at religious liberty litigation in the 10th Circuit called Sex, Drugs, and Eagle Feathers, an empirical study of federal religious freedom cases, and it found that indeed religious minorities are the most likely to rely on RFRA and RLUIPA. Justice Alito, in a recent case, Fulton, pointed out that under Smith, without RFRA, things like circumcision, wine for religious sacrament, and ritual slaughter required for eating meat would not be protected by the First Amendment. And just think about that for a second. I think most Americans would assume that a religious practice as vitally important as circumcision is to Jews would be protected by the Free Exercise Clause, but it's not. If a state were to say, we are passing a law prohibiting circumcision for medical reasons or for reasons of a child's autonomy, and it has nothing to do with religion, it applies to everyone, the Free Exercise Clause under Smith would arguably not protect it, but RFRA would. So in these vitally important cases, RFRA is the first line of defense for religious minorities. RFRA has been used in a lot of different instances by Jewish plaintiffs. It's been used to ensure that Jewish plaintiffs had a right to visit friends and family in hospitals without violating the Sabbath. It's been used to overcome restrictive zoning laws that were trying to prohibit the building of synagogues and other important communal structures like ritual baths. RFRA and RLUIPA are often invoked by Jewish prisoners in order to obtain access to things like kosher food, prayer books, prayer shawls, phylacteries, tefillin, wine or grape juice for the Sabbath and holidays. And recently, RFRA was even used to get cheesecake on a holiday called Shavuos, in which many Jews believe you're supposed to eat dairy. One of the topics that I was also asked to talk about was a white paper that I wrote for Heritage discussing how RFRA could be a tool that's used to protect against anti-Semitism. I wrote this paper with colleagues of mine from Jewish Coalition for Religious Liberty, Professor Josh Blackman, and Rabbi Mitchell Rockland. So in this paper, we talked about two unique ways in which RFRA could protect against anti-Semitism. One of those ways is the more common and traditional thought of version of anti-Semitism, which is when somebody purposefully wants to target Jews because they hate Jews for being Jews. And they can pass a law that seems religiously neutral, and on its face doesn't target Jews, but they know actually will, and they can do this out of animus. And an example of this is something called an Erev. An Erev, Jews believe that it is generally prohibited to carry outdoors on the Sabbath. But if you put a string around the community, generally hung from lampposts and utility poles, that you can make it such that you are allowed to carry outdoors on the Sabbath. So somebody who doesn't want Jews to move into their community can say, oh, we're going to pass an ordinance that says nothing can be hung from lampposts and utility poles. You can't have flyers, you can't have strings, you can't have anything. On its face, under Smith, that is unchallengeable under the First Amendment, and it would effectively bar Jews from moving in. It would be, you can't carry keys outside on the Sabbath, you can't carry baby supplies, you can't carry anything. It makes it extremely difficult. There's no Jewish community of any real size in America, at least Orthodox community, that doesn't have an Erev. Most of New York, most of DC, all these areas are covered by Erevs, and they enable Jews to live there. And there's actually been a lot of high-profile litigation about Erevs. And in a lot of those cases, we've been fortunate. I mean, it's a strange way of using the word fortunate, but we've been fortunate that the people who passed the legislation have been open about their intention of keeping Jews out, calling Jews an infection and a cult and all kinds of other, despicable terms. And courts have been willing to use an exception to Smith that says, oh, if a law is generally applicable on its face, but was in fact motivated by animus, will act as if Smith wasn't in place. It's from a case called Lukumi Babalu I. But if people were a little bit smarter and they didn't go on the record and say terrible things and admit they were passing the law to target Jews, well then we would need RFRA to defend us. And in fact, there are other lower profile cases which don't have such explosive language in them where RFRA was used. A lot of those cases don't even get to litigation and are settled, but there seems to have been cases where an attempt to block Jews from moving in through banning an Erev have been defeated by pointing to RFRA. There's another type of case where it's not that the people hate Jews for being Jews, it's not a case of pure animus, they just hate religious people they see them as anachronistic or something like that, or not fitting in with the zeitgeist, being contrary to their progressive political ideals, whatever it is. And there are examples like that where somebody might ban circumcision because they see it as archaic, they see it as not in line with the way they want to view the world. They could ban ritual slaughter of animals for eating because they see it as cruelty to animals or something like that. They ban religious head coverings because they see religion as anachronistic and not fitting in the public square, all sorts of other reasons. So we postulated, this was in our mind, our bigger innovation is that these should also be viewed as anti-Semitism. That even though these people are not motivated by hatred of Jews for being born as Jews, for the happenstance of having a Jewish mother, but they still hate Judaism and those people who practice it. So RFRA would also protect us in those cases, because those laws would also be generally applicable and religiously neutral under Smith. They would also be insulated from First Amendment protection, but RFRA would still, give Jews a way of challenging such laws. And a final thing about RFRA in general and what it's done for religious minorities is that it may have somewhat ceded the possibility that RFRA will be less important in a positive way, right? One of the planks of Smith was that it's just too difficult for courts to apply strict scrutiny to free exercise claims, and that if they do apply strict scrutiny to free exercise claims, it will be some kind of a disaster and chaos, and this will be a major problem. Well, courts have applied strict scrutiny to RFRA-type cases, to First Amendment cases that are generally applicable for 30 years now, and they've shown they can very much do it. There has not been chaos as the result, and it's possible that when Smith finally does get overturned, it will be because RFRA has undermined all of its predictions about how difficult this is, except one, the harm that it would cause to religious minorities. That's good.
Thank you, Howard. That's such an important reminder that RFRA has been used successfully to defend so many religious minorities and their rights as well. So we are going to open up to questions soon, but because I am the moderator, I'm going to take that privilege to ask the first question. And while I know we're religious freedom advocates, which means we're afraid of conflict, I'm going to bring it back to something that Greg touched on briefly in his introductory remarks, which was this increasing conflict between LGBT interest and religious freedom. And that clearly has an effect on RFRA because many of RFRA's opponents point to that. They point to the argument that, RFRA just enables discrimination, et cetera, et cetera. I would love to hear your response to that. And when we see RFRA colliding with LGBT interest, what should happen in those cases?
Sure. So this came up to a degree in the case called Fulton, which had to do with a foster care agency that didn't want to certify same-sex couples as the ideal place for child rearing. And as we mentioned, the way that these statutes work, the way that the First Amendment works, for these purposes, it's not that different, is first, the religious person has to show that they have a religious interest that would be substantially burdened by the statute. And for these purposes, we're going to assume that is the case. Then the burden shifts to the government to show that it has a compelling interest in enforcing these laws. And I think it is certainly the case that at some level, the state does have a compelling interest in prohibiting discrimination. But Fulton looked at this case and said, that is well and good, but we have to look and see how does applying the law to this particular person further that interest. Not is there a generalized interest in anti-discrimination, is there a particular interest in applying it to this specific individual, and if we don't apply it to this individual, would it totally undermine the state's interest? And given that there's plenty of other foster care agencies, not just this one, given that applying to this agency would actually reduce the number of foster parents rather than increase them, it is not really going to further the state's compelling interest to apply it to this individual. I think that framework will apply in a lot of other cases. We're not going to look and see, does the state have a compelling interest in protecting gay people from discrimination? Sure, it certainly seems to. But that does not mean that every individual who asks for an accommodation would fatally undermine that interest, would undermine that compelling interest. In fact, in most cases, it won't. There's going to be a small enough number of people who are asking for accommodations that the state can say, we have this interest that courts will recognize in prohibiting discrimination, but at the same time, we can grant accommodations without destroying that interest.
I think that's very well said. And it's interesting because the court actually dealt with this situation somewhat in a case that came to the Supreme Court this last year, 303 Creative. Now, what was interesting is that our friends at ADF brought this case and they asked the court to look at the religious liberty implications and to look at even possibly overturning Smith. But the court declined to take up that case, that part of the case. They said, we don't want to deal with the religious liberty claims that the 303 designer is bringing. We just want to look at the free speech implications. But even under the free speech implications, under the free speech analysis, the wedding website designer still won. I think most of the people in this room know, but just in case, this was a case where a wedding website designer did not want to be forced by the government to make wedding websites for couples who were having a same-sex marriage, having a same-sex wedding. Instead, she said, my religious beliefs won't allow me to do that. That would be communicating a message that violates my religious beliefs, and that's just not something I can do. And what the court found is that the government may have a strong interest in having non-discrimination ordinances or policies or laws or regulations in place, but they still have to prove that they have a reason that they need to apply it to this specific person in this specific set of facts at this specific time. And in Lori's case, they said, no, this would, not only does the government not have a great reason, but just because there are other rights that are protected by this ordinance, that doesn't negate her free speech rights in this case. And I think that analysis applies as well in the free exercise context, even though the court declined to take it up. But it will be interesting to see if the court has any appetite for taking up Smith at a later date. As Howie said, the Fulton versus Philadelphia case, the court was asked to look at that, and the court declined to do that. And it was very early in the tenure of Justice Barrett. It was one of the very first cases she heard when she came to the court, and I think she just wasn't quite sure what to do with it. She and Justice Kavanaugh had a concurrence to the opinion, and they said, we're not sure that Smith is the right solution, but we're also not sure what to do. To me, the answer is simple. As Howie said, courts know how to do strict scrutiny, so we could return to that. But at that time, the court was not quite ready. So we'll see if they are ready and interested at a date in the future.
Thank you both. We will now open it up to audience questions. So if you have a question, please raise your hand.
Good morning. My name is Parshan. I am one of the co-chairs of the Zoroastrian Youth of North America, here with the Federation of Zoroastrian Associations of North America. Thank you for this panel. It's been super illuminating. We are a very, old but small religious community, and to us, this discussion is so important. Especially, I was particularly interested in taking your takes on how can RFRA apply to some of the protections that we just haven't had. One of the things, for example, in California, that's where I'm from, we have many temples, and several of them, one of the things about our temples is that we need to have fire inside the temples to be able to practice our faith. And we have zoning laws that have stopped several of our temples from being able to have those fires. So my question is, I was hearing applications of RFRA in these situations. Would that be the sort of case and situation where we can apply and say, thank you, LA County, but this is our religious freedom and we need to have our fires, so don't stop us from having fires inside our temples. So I'm curious, how vastly and how widely can we apply RFRA in these sort of situations? And I ask it also because we've had these issues every time we've held one of those conferences, and we have international congresses. Not so long ago, one in New York, even earlier in LA. Again, we have these issues consistently where, and if there is an issue that pops up, then who do we go to, right? Thank you.
Well, as Jenny just graciously said, First Liberty might be your answer. We are a pro bono law firm, and we represent people of all faiths. And this would probably fall under our LUPA, the Religious Land Use and Institutionalized Persons Act, because it does specifically deal with zoning. And that is an issue that we've seen Interestingly, even in California, right now we're representing a small Orthodox Jewish congregation who want to meet in a home because on the Sabbath they're prohibited from driving a car, so they want to meet locally within walking distance. And in Beverly Hills, we are fighting to represent their rights and to ensure that they're not zoned out or that the government comes against them. So yeah, under our LUPA, I think that would definitely be something that you'd want to bring, and I'd be happy to talk to you afterwards.
Any other questions?
Hi there. Thank you so much to all of you. My name is Hank Hom. I'm a policy staff officer for the Air Force Chief of Chaplain's Office, and there's something interesting going on in the Air Force right now. I think emboldened by the overturn of the COVID mandate for the military members, a lot of our young airmen have tried to test exactly RFRA, what it can do, religious accommodations can do for them, and what I would consider other agendas. Namely, we have had a flood of beard waivers for religious accommodations. And most recently, most of those accommodations are based on a religious view that's, I wouldn't even call it a minority religion. It's the religion that most recently that have come through has been the religion of agnostic theism. And their belief is one based on bodily autonomy. And because of their belief on bodily autonomy, they'd like to wear a beard while in uniform and while serving. And so we've got a ton of these coming through, and I'm kind of afraid, in much the same way that people who abused, REI's return policy, causing REI to no longer accept returns, I'm afraid that this is going to damage RFRA's application in the military. Do you guys have any guidance on how we can better accommodate, but at the same time go through that strict scrutiny? And yeah, any kind of help would be grateful.
So this is becoming a big issue, I think, in a lot of different ways. And to self-promote a little bit, I just recently published a law review article in the Texas Review of Law and Politics that touches on this. I think we're going to really have to look at sincerity more going forwards. We can't look to see, is someone's religious belief accurate? Does it accurately portray their faith? But we can look to see, are they sincere in their religion? It's a difficult test, certainly, and we should be solicitous and we should be deferential. But there are cases that have found people are insincere in their profession. There's a case, Quantance, where somebody invented a church of marijuana on the eve of trial. They hastily inducted the other defendants into this church and then claimed that their god was a marijuana leaf and they had religious obligations to sell and smoke it. The court was able to conclude, I believe it was then Judge Gorsuch who wrote the opinion, that they were insincere in their faith. There are other examples like this where there is concrete evidence surrounding the case that says you don't really believe what you claim to believe. I think this is going to have to come up in some of the cases Greg mentioned earlier on, issues about people claiming religious rights to abortion. I think there is going to be issues there. And sincerity is essential, right? It wasn't just agnosticism. I think during COVID, a lot of people were claiming Odinism as their religion, and they didn't want to, people in fact called me and pressed this claim, and not as a judge, merely as someone who was being called and asked to help out. My sense was that they were not sincere, and they were just looking to something. Or, there's other examples like the, Pastafarian people who, there's indications, or Church of Satan, who there's indication that they are not sincere and they are acting to mock religion. So I think that is going to be an avenue to look at is sincerity or lack thereof.
I think we had a question at the front.
Nathaniel Hurd from the Religious Freedom Institute. Question for Jenny. The ideal is that the executive branch does not promulgate rules or regulations that violate RFRA. And so I'm wondering, drawing especially from your experience in the executive branch, what can the executive branch do to ensure that before a rule or a regulation is promulgated, that it's RFRA compliant? Is it an executive order? Is it a presidential memorandum? What are the mechanisms for doing that? And then the second question is, Are there things that Congress can and should do to ensure that when the executive branch, that basically you must do these things, it must meet these tests, or you must take these actions or steps to ensure that a potential rule or regulation is RFRA compliant before you promulgate it? Thanks.
Yeah, good question. So Congress does put in place requirements, basically procedural hoops, many procedural hoops that rulemaking has to jump through, everything from like the Paperwork Reduction Act to the potential impact on small businesses, right? There's all sorts of things that if you look at the back of a proposed rule, you will see kind of paragraph after paragraph where it's just like, here's our analysis going to this point, here's our analysis going to this point and to this point. And technically, if an administration doesn't do all of those required analyses, basically check the boxes, that is grounds for saying that regulation is procedurally invalid. We did that in the previous administration as to this HHS grants rule, this super broad non-discrimination rule. There was one little procedural checkbox that the Obama administration, in their hurry to get it published in December or January, right before they left, had failed to do. So we issued a notice of non-enforcement, basically, pretty early on, and said we've realized this is procedurally invalid and it's vulnerable in the courts. So we're just going to say we're not going to enforce it. So so Congress can do that. Is the answer to the second part. As to the first part, I think there was at some point kind of an overarching requirement like you're talking about. I don't remember the mechanism for it, whether it was an EO that was taken down in the meantime, but in other words, yes, even within an administration, you can say, we are prioritizing religious freedom in rulemaking. And the previous administration did do that. That was one of in addition to reviewing briefs centrally at DOJ, we were also reviewing every rulemaking for religious freedom compliance. Not every administration prioritizes that, and in an administration that didn't want to do that, even if there was kind of a congressional requirement on the books that you have to do a RFRA analysis, checking the box is not that hard to do. But it's worth having that requirement there because, again, it gives litigants, it gives First Liberty and ADF and Beckett a tool to come back in and say, you didn't even attempt to comply with this, right? Like, we see your RFRA analysis and it's garbage, basically. And then you can bring that to a court and try and argue to a judge, like, this is a basis for invalidating this rule. So that is certainly worth thinking about. I don't know how possible it would be to do it at the congressional level right now, but in a future Republican administration, I think that's something that probably will be done again across the board.
And I think we have time for one more question. Up at the front.
Hi, I'm Patrick Stefan with the U.S. Army Chaplain Corps for the Chief of Chaplains. So my question goes back to the First Amendment and the explicit rejection of matters of conscience. It was a protection of religion itself, right? And so I'm wondering, in your perspective, what differentiates a religious claim from a mere conscience claim? So back to Hank's question here about bodily autonomy. What actually makes something a religious claim for the courts? And do you ever think, after kind of based on Kennedy versus Bremerton School District, they'll go back to the historical purpose of protecting religion as a means of defining that? Does that make sense?
Yes, I think I see what you're getting at. So I think the answer is currently, typically, when we talk about conscience rights, they're rooted in religion, right? That's both, I guess I would say, normatively and descriptively. I think typically when people use the language of conscience, they're talking about a claim that's rooted in religion. And I think that's the way that jurisprudence has generally developed. Now, interestingly, again, to go back to the contraceptive mandate situation, there is a distinction that was made in the rulemaking done by the Trump administration between moral objections and religious objections, right? And that was to respect the fact that RFRA protects religious objectors, but it doesn't protect people who say, as a matter of natural law, I oppose contraception and abortion, right? So there were two different rules kind of framed for, this one is required by RFRA. We are also, and Moreover, we are also going to respect moral objections that are not rooted in religion and give those people exemptions as well, because we think in the Trump administration that's the right thing to do. They were specifically thinking of the March for Life organization, for example, which is not a religious 501c3, but obviously is built around an opposition to abortion, right? And that is why you see in this administration, they're bifurcating those two things and saying, we're gonna take down that moral exemption, which we believe we are not required to provide, right? It's not rooted in religion, which, as you say, that's what's protected. We do recognize now that we do have an obligation to protect and respect religious objections, right? And we're gonna continue to provide those exemptions. So when you talk about conscience, you're right, it's interesting because that could fall in a little bit of a gray area, right? Again, typically I think people are making claims rooted in religion, but they're not always. And so for the sake of the work that you all are doing when you're kind of trying to adjudicate or piece out what kind of a claim is this person making, what kind of exemption are they asking for, I think that is something you could poke at a little bit in addition to the analysis that Howie was laying out, where you don't come in and say, that's not a thing, I think you're making that up, but you say like, oh, tell me more about, when did you come to this belief and what are the other kind of like indicators that this is something you really believe in. You could also be poking at like, tell me more, what does this need to have a beard rooted in, right? And feel out if it's based in religion or based in something that we would call maybe like a moral analysis instead of a religious analysis.
And in this case, you could just ask the person, right? A judge could say, is this a religious claim or a moral claim? And then judge their sincerity, right? Judges do judge whether people are lying or being sincere all the time. And you should be deferential, but if you ask someone, is this a philosophical or moral claim that you're bringing or a religious claim, and just see what they say and then see if you believe them.
All right, our time is up. That is going to conclude our panel. Please join me in thanking our panelists.
All right, good morning, everyone. Let's launch into our second panel, this morning devoted to the Religious Freedom Restoration Act. I'm Nathan Berkeley, the Communications Director with the Religious Freedom Institute. And we're going to look at RFRA now, kind of looking ahead into the future in three areas. We're going to look at it in the context of the courts, in the context of the Equality Act and Fairness for All, and then in relation to medical conscience rights. So our first panelist addressing the courts will be Mark Rienzi. Mark is the president of the Beckett Fund for Religious Liberty, and he's also a professor of law at Catholic University of America and a visiting professor at Harvard Law School. Next, to discuss the Equality Act and Fairness for All, we'll hear from Sarah Parshall-Perry. She's Senior Legal Fellow at the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation, where she focuses on civil rights, constitutional governance, regulatory policy, and the proper role of the courts. Sarah previously served as senior counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education. And finally, addressing medical conscience rights, we'll hear from Louis Brown. Louis is the executive director at Christ Medicus Foundation. And Christ Medicus promotes religious freedom and pro-life principles in healthcare. And Louis also served as a political appointee at the U.S. Department of Health and Human Services. So first, to look at RFRA and the courts. We heard about that in the first panel. We will hear a lot more from Mark Rienzi now to look at how RFRA applies and what we should expect in the future in that area. So Mark, over to you.
Thanks, Nathan. Okay, there's the mic. First, thank you for inviting me to be here. It's an honor to get to be on this panel and to be at this event and to be hosted by RFI. So I appreciate you all putting this together to put a focus on a really important law and a really important piece of American civil rights, the American civil rights approach, which is RFRA. I want to talk about a few different things. Let me start with what RFRA really does and how that's working in the courts and why it's working so well in the courts. And then let me say a little bit about what I think we can expect to see in the future and what are some of the challenges and threats that we see in the future. So first, RFRA, of course, is an important response by Congress to a mistake by the United States Supreme Court in 1990 when the Supreme Court gave free exercise of religion a rather narrow scope of protection, or at least appeared to do so in the Smith case. And I think it's an important piece of our history, and one that we should keep reminding ourselves and each other of, that RFRA was passed with broad bipartisan support. Bill Clinton, in the 1996 debates, said that signing RFRA was one of his proudest accomplishments of his first term. And there's a reason that everybody was able to rally around RFRA, and people of all different religious beliefs and people of all different political persuasions could agree, and that's that RFRA makes a lot of sense. If we're going to be a pluralistic democracy, if we're going to live with people of different beliefs and different views in this country, then we have to figure out, how do we get along, and how do we do it when somebody's got religious beliefs that don't match with what the majority, the governing majority, tells them to do. And RFRA sets forth a pretty simple default rule, which is that most of the time we should not force somebody to violate his or her beliefs unless we've got a really good reason to, right? Absent a really good reason, our default response to our neighbor having different beliefs about religion or sex or marriage or God or anything like that ought to be to live and let live, right? To say that our government ought to let my neighbor and me, even if we have different beliefs about really important things, coexist in peace, and each go earn a living, and each interact with our government, and each be part of society. RFRA does that by striking what Congress at the time called, correctly, a sensible balancing test, which is to say that the government can, of course, sometimes override somebody's religion, but it's got to be that they've got a compelling interest. They've got a really important interest and no other way to achieve that interest. Here's the good and bad news, depending on what you think about big government. In a world of big government, it's almost always the case that the government can achieve its goals without overriding somebody's religious beliefs, because the size of the government toolkit is massive. Federal governments, state governments, local governments, legislatures, the bazillion alphabet soup agencies at the state, local, and federal levels, they have a lot of tools in the toolkit. And so that means most of the time, in a RFRA regime, they can achieve their goals without forcing someone to violate their religious beliefs. So let me start with what I think were the two biggest RFRA fights we've seen, at least at the national level. They both related to the contraceptive mandate, and they were the Hobby Lobby and Little Sisters of the Poor fights, which I had the great honor and pleasure of representing both of them. The federal government decided in 2011, the Obama administration decided that HHS should impose something that Congress never imposed, which is a mandate that most employers buy contraception and abortion-inducing drugs for their employees. Now, this had been proposed in Congress many, many times, and Congress had never actually passed it. But the administration used the Affordable Care Act, the broad authority given under the Affordable Care Act, to say, okay, great, we're going to impose something that Congress never could pass. And we're going to make employers buy contraception and abortion-inducing drugs and sterilizations for their employees. If you had started out at the beginning and said, okay, the United States government wants to get contraception to people, you would never have gotten to the thought, let's call the nuns, right? Like, it never would have occurred to you to say that the way the United States government shall get contraception to people is to enlist Catholic nuns. But somehow, through the government's contortions, they ended up being in the position of saying, well, we need the help of the Little Sisters of the Poor. We need to force Hobby Lobby, even if it violates their religious beliefs, to provide these drugs, right? That was the claim. That was always a terribly weak argument, because of course the United States government can get contraception to anybody it wants to, right? Of course they can get contraception to people. Title X gives free contraception to millions of people every year. The federal government gives it out directly. The federal government funds state and local governments that give it out. It's actually not that expensive anyway. Employers are generally quite happy to pay for it, because if you give people birth control and they have fewer babies, guess what? Fewer babies. They don't need to get vaccinated. They don't need to be on my health plan. People won't miss work, right? Many employers are perfectly happy to pay for that all day long. And with the Affordable Care Act, they enacted a law that created this whole separate system so that if you didn't like the health plan offered by your employer, they built a brand new system that's just one web page away for you to go get health care over there. So the notion that the United States government needed to make nuns give out contraception was absurd. Well, that's the kind of conflict that RFRA is made for, right? RFRA, when it's working well, forces the government to say, wait, before I force that person to violate his or her religious beliefs, can I achieve this goal some other way? And most of the time, the answer is, of course you can, right? Like the US government puts mail in a little box outside of your house every day of your life, right? Like if they wanted to put contraception in your hands, if they wanted to put it in your mailbox every day, they could. There's nothing that stops the US government from giving it out. And in fact, it's a decade late, but a decade late, the Biden administration, at least in its most recent proposed rule, sounds like they too may have come around to the idea that they can do this in other ways. And to be clear, I think there's many problems with the latest proposal from the Biden administration on the contraceptive mandate. From a pro-life point of view, I think it's bad, all that. But on the question of can we achieve this some other way without nuns, they seem to be acknowledging that of course they can. If things had worked right, they would have acknowledged that a decade ago and not dragged the country through this fight, right? The truth is, there was political juice in the fight. That's why the Obama administration wanted to pick a fight in 2012 over contraception. That's why they wanted to pick this whole fight, not because they had difficulty getting people contraception. Okay, when RFRA works properly, RFRA gets those things resolved, ideally out of court, right? When RFRA works properly, government agencies know that it is their obligation under the law to work around people's religious differences. I mentioned Little Sisters and Hobby Lobby, but I should point out, most of the winning RFRA cases, most of the times that RFRA is deployed, it is for minority religious beliefs. And I should be clear, right? The Little Sisters of the Poor's view on contraception is a minority view. It is not the most common view in the country right now. But many times RFRA protects religious minorities. So let me just give a few examples of cases we've worked on. The Lipan Apache tribe in Texas wants to have Native American religious ceremonies using feathers that were molted by eagles. The United States government says you're not the right kind of Native American Indian tribe. You are not a federally recognized tribe. Therefore, we will put you in prison if you have your powwow and your dances with these eagle feathers. That's an absurd rule. And after Hobby Lobby was won, that church won their case based on Hobby Lobby. Sikh soldiers who want to fight in the military while keeping their articles of faith, so a turban and growing a religious beard, have had to fight for their right to serve their country on equal terms without giving up their religious beliefs, and they have won their cases under RFRA, right? RFRA has said to the government, well, can you show me that you've got a compelling need to force that recruit to shave the beard? Can you show me that it has to be done this way? And when the government is put to its proofs, it often ends up that, of course, they don't need that, right? They've got changes to all sorts of rules. If you ever see go look at pictures of old admirals in the Navy. Old admirals in the Navy tend to have beards down to here. So the idea that you can't be on a ship with a beard is kind of crazy. But the government would insist on it to the point of excluding Orthodox Jewish sailors and Muslim sailors and Sikhs. So it helps minority members of different faiths. Native Americans, we've got several cases for Native Americans. One called the Slockish case, where the federal government with the state of Oregon redirecting a highway. There were several different ways they could have gone, but the one they chose went over a Native American burial ground and an ancient Native American altar. For years, the federal government has been arguing, well, that just didn't burden your religion at all, right? It's our property, no burden at all. It's an internal government program, they said. Or the Apache in Arizona who are fighting now over what's called Oak Flat, right, where the federal government wants to sell this sacred piece of Native American land so it can be blown up by a foreign copper company so you can get copper from underneath it. Native Americans are using RFRA, arguing that, well, it's a burden on my religion when you destroy my sacred spot. And so RFRA provides important protections in all of those places. It is valuable. I'll point out in those Native American cases, and maybe I'll wrap up with this point. In those Native American cases, the government's making two arguments that should concern everybody. One is they're arguing, well, it's just an internal government program, right? Government's just saying, all of this is just my turf, it has nothing to do with you. If that sounds familiar, that was the same argument the government used in Hobby Lobby. It's just my internal contraception regime. Same argument they used in Fulton versus Philadelphia. It's just my internal foster care system. Governments, of course, want to say everything is internally theirs, and therefore they don't have to respect your civil rights anyplace else. That's a bad argument. It always loses. except for against Native Americans. It tends to beat Native Americans. That's a problem. We should be concerned. Second thing the federal government argued in the Native American cases recently is they said RFRA can't control over a later enacted statute. And let me just point out how dangerous a position that is for the federal government to be taking in a case. If you think of the fights over the Respect for Marriage Act a year or so ago, what was everybody told about why they don't need to worry all that much about it? It was, well, you still have your RFRA rights. Well, at the same time that people are saying that, they're also, the Biden Solicitor General's office is going to federal courts and saying, actually, RFRA doesn't apply at all to later enacted statutes. That's not what RFRA says by its terms. That's not how it should be interpreted or applied. And if the Biden administration were to win that claim, it would be very dangerous. It would undo a lot of settlements that have been made. So that's one thing for people in Congress, I think, to keep an eye out for. I'll stop there.
All right, thank you, Mark. So we'll turn now to look at the Equality Act and Fairness for All and how these far-reaching anti-discrimination measures or proposals intersect with RFRA and religious freedom. Sarah, over to you.
I have to laugh because Mark never needs notes. It just flows off the tongue. He's talked about an ideal situation and what RFRA is designed to do. I'm going to give you a little bit of clarity into what we're actually facing right now. And my remarks are going to focus on sort of that intersection between civil rights and civil liberty. And civil rights is now the new cudgel that is being used against religious Americans. We've seen arguments for the expansion of civil rights protections that are not traditional exercises of civil rights. On a chilly day in April 2015, U.S. Solicitor General Don Verrilli stood before the Supreme Court justices, delivering an impassioned plea for constitutional recognition of same-sex marriage in Obergefell versus Hodges. At one point during questioning, Justice Samuel Alito leaned down and asked a question of Verrilli. If the Obama administration's contention was that traditional marriage laws recognizing only man-woman marriage were analogous ultimately to racial segregation, as Verrilli had argued, wouldn't schools that defined marriage traditionally be in the same category as those like Bob Jones in the 1990s, who lost their tax-exempt status? They had lost theirs, so what would happen to the tax-exempt status of religious universities or colleges if they opposed same-sex marriage? And the Solicitor General stumbled, as we all know now, and said, I don't think I can answer that question without knowing more specifics, but it's certainly going to be an issue. I don't deny that. I don't deny that, Justice Alito. It's going to be an issue. Well, 8 years hence, we realized exactly how prescient he was. Even as the government argued for a constitutional recognition to same-sex marriage, the tension between that advancement of marriage equality and religious liberty had already surfaced. And in retrospect, obviously, we recognize that that was, in very many respects, sort of the tip of the spear. In modern America now, we've seen the political branches at the state and federal level essentially pitting culture against religious liberty. And if 2 terms at the Supreme Court have shown us anything, it's that anti-discrimination law is that new cudgel. We talked just briefly about 303 Creative. Cassie mentioned that. That was, of course, a state anti-discrimination provision. Legal expansions specifically for those choosing to self-identify, predominantly according to sexual behaviors, orientation, or gender identity, into territories that are well beyond those that we've traditionally recognized in civil rights law, require adherence to a certain set of specific views concerning the nature of human existence. They promote substantive claims on sex, humanity, marriage, identity, biology, that require full-throated endorsement by everyone, even for those whose religious objections might render the views anathema. So this isn't really about wanting a certain wedding cake or a certain foster agency or a certain bathroom, because there are always other cake shops or foster care agencies or even bathrooms. We're well beyond tolerance and live and let live, which is, as Mark mentioned, the ideal situation. We are now looking at something more akin to collectivism, and it's about endorsement of an official government viewpoint. It's about submission, and for religious faithful individuals, the Hobson's choice of adhering to the government's unofficial perspective or facing legal judgment. The infusion of sexual and gender identitarianism in state and federal anti-discrimination law, even worse, renders toothless, in my view, hard-fought gains of the civil rights movement post-Brown versus Board of Education. Heated debates, a resistance to segregation, marches on Washington, MLK Jr.'s stirring speech led to an eventual adoption of the Civil Rights Act in 1964, but that has been clownishly hijacked by men claiming a civil right to use the women's bathroom. The Human Rights Campaign, for example, has cleverly drawn unflinching parallels between LGBTQ campaigners and African Americans, using the buzzwords of anti-discrimination law and likening the struggle of pre-Civil Rights Act segregated blacks to decry religious bigotry. Instructing kindergarten students about gender identity, promoting chemical castration for vulnerable minors, stealing women's athletic titles are not civil rights battles. They're exercises in what I would call government-sponsored bullying. They illustrate precisely why we need RFRA. Let me talk a little bit about the anti-discrimination laws at issue here, those which have been used most closely as this cudgel I've talked about. I talked a little bit about Colorado's Anti-Discrimination Act. It made multiple trips to the Supreme Court, as we remember, not just with Lori Smith and her pre-enforcement challenge to the Anti-Discrimination Act, whether or not that would compel her to create expressive messages violating her particular set of beliefs, but also for Jack Phillips in the Masterpiece Cake Shop series of cases. Title IX of the Education Amendments of 1972, we all know, is in the dock right now. We are waiting for a finalized rule from the Department of Education, which has since been bumped not once, twice, but thrice. We are looking essentially now at spring of next year before that rule is finalized. But in addition to weakening protections for religious institutions, it also, unfortunately, proposes and infuses a certain view on human sexuality and gender identity, requiring those religious institutions to prove that they are just religious enough. But there's a trio of legislative proposals at the federal level about which I'm most concerned. Chief among them is the Equality Act. That is the most devastating of the three. It proposes an unprecedented expansion of civil rights law, redefines public accommodations, and utterly eviscerates religious liberty. The first version of this legislation, introduced all the way back in 1994, prohibited discrimination in employment based on sexual orientation. Well, in time, the Supreme Court ultimately answered this question anyway in Bostock versus Clayton County. But the 1994 Act did not apply to religious organizations. Safe enough. However, today's iteration is an animal completely different. It would prohibit discrimination on the basis, again, of sexual orientation or gender identity and expression, granting it protected class status alongside race, sex, and national origin in the Civil Rights Act of 1964, even though the Supreme Court has consistently used the standard of immutability in its equal protection and civil rights jurisprudence, identifying those characteristics which have been, as the justices reminded us in Frontiero versus Richardson, those delivered by accident of birth. The Equality Act would apply across multiple sectors of American life, including employment, housing, education, financing, even credit markets, jury service, and it would prohibit allowing anyone from even arguing a religious liberty violation under RFRA because religion is, and RFRA is, explicitly exempted. Now, a fun fact about RFRA, as Mark mentioned, it applies to all statutes previously enacted prior to RFRA or after RFRA's enactment, unless, and here's the catch, explicitly eliminated by statute. Hence, the Equality Act's elimination of RFRA protections. Anyone who accepts so much as a federal dollar of funding would be subject to those provisions, including religious charities or organizations that participate in government programs, making something like Fulton versus City of Philadelphia a very common sense victory, nothing but a pipe dream. Fairness for all has been billed as the Equality Act's kinder, gentler alternative. But the bill parses out a series of piecemeal religious protections for organizations that have to meet various slim conditions. It shields some churches, but the buildings can't be used for commercial purposes, some marriage and family educators, so long as they don't discriminate on anything other than religious character and don't say anything about sexual orientation or gender identity, and some religious charities, but the charities have to get funds indirectly through a voucher system. It is a masterclass in death by 1,000 cuts. Worse, Fairness for All leaves individual objectors completely out of the loop. That's individuals like you and me, wedding service providers, scholastic athletes, religious citizens, educators, medical professionals are out of luck. The description that it expands religious liberty is patently false. Do no harm is the most recent, again, another attempt to soft soap what is very clearly a stinking pig, if I may be so bold. The Do No Harm Act was offered in April of this year, which seems to correct what the drafters saw as errors of judicial interpretation in Burrell versus Hobby Lobby and Bostock versus Clayton County. Now, why Bostock versus Clayton County, you say? That was clearly a decision that expanded the application of Title VII to include a prohibition on sexual orientation and gender identity decisions in employment. Discrimination in employment based on sex also included discrimination based on sexual orientation and gender identity. Well, in a very roundingly hopeful statement by Justice Gorsuch, who wrote the opinion, he said that because RFRA had not been made as a claim at the Supreme Court level, they couldn't address it, but RFRA he described as a super statute that even in appropriate situations could excuse the duties of anti-discrimination law. We don't want a Supreme Court justice saying that between anti-discrimination law and RFRA, RFRA wins. The Do No Harm Act prohibits RFRA's use against non-discrimination law, employment law, child labor and protection laws, healthcare, government contracts, services, and the list goes on. It allows RFRA only to be invoked when it rectifies the imbalance between too much liberty and too few civil rights protection. The freedom of religion and the right to practice thereof is not a take it or leave it right. It is a all or nothing right. And when James Madison argued to the Virginia legislature that religious exercise is precedent both in order of time and degree of obligations to the claims of civil society, he was cementing for all time the importance that religious liberty was to have. It is a right both fundamental and primary. The Supreme Court has consistently recognized the importance of religious freedom by holding that government burdens on the exercise of religion must adhere to a least restrictive means approach of achieving their compelling interest, the strictest standard under law. And for decades, presidents, Democrat and Republican, have reiterated the primacy of religion in Religious Freedom Day proclamations. I give you Barack Obama, who himself said that religious freedom is a, quote, universal human right and, quote, an essential part of human dignity. He said that America proudly stands with people of every nation who seek to think, believe, and practice the faiths that they choose. Without RFRA, of course, you could keep your religion free of government interference, but you just have to keep it behind your churches or synagogues or mosques' doors. RFRA provides a critical backstop against an onslaught of collectivism, and especially so within a context of new civil rights laws. It allows religion to do what religion has always done for millennia: inform the actions, beliefs, choices of everyday citizens absent government interference. RFRA allows the inherently American principles of liberty, pluralism, and limited government to flourish here as they do nowhere else in the world.
Thank you, Sarah. All right, Louis, over to you to talk to us about RFRA and medical conscience rights.
Sure. Great to be with you all. I haven't been in this room in probably 10, 12, maybe 12 years. And thanks to the amazing exemplary team at Religious Freedom Institute. They're awesome people, as most of you all know. The equal dignity of every person, especially the most vulnerable, is really the foundational belief upon which America was founded. Equal human dignity was the foundation of the Declaration of Independence, and this principle was imperfectly enshrined within the U.S. Constitution. And so if we think of an analogy, I'm going to choose human dignity as the crown jewel of our country. The crown jewel of America, human dignity, is protected by, in my estimation, 3 foundational human and civil rights. 3 shields: the right to life, the right of conscience, and the civil right of religious freedom. All other civil and human rights, at least in our country, depend on these three. If we fail to protect the right to life, or the right to exercise one's individual conscience, the right to freely think, believe, and act, conscience, or if we fail to protect the deepest part of a person, the right to freely exercise one's soul, to put faith into action, the shield protecting that crown jewel is damaged, and we risk the destruction of that crown jewel of human dignity in America. As we think of religious freedom, I want to frame it a little bit in a broader context, and I represent the Christ Medicus Foundation, a little bit of a Catholic context, and what I really believe is a universal context. Religious freedom is the right, as both Sarah and Mark mentioned, the right to pray, worship God, think, speak, act, live, work, conduct commerce, engage the public square, and ultimately to love God and neighbor consistent with one's well-formed and sincerely held religious beliefs. A free society cannot exist unless every person is free to live out one's religious beliefs about God, and it's not free unless we're able to live, breathe, think, work, act consistent with those religious beliefs. Religious freedom is, in America, empowered a religious conviction that slavery was a great evil. The right of religious freedom was the catalyst of the American abolitionist movement that swept into Congress, swept into the White House and the Union, and it ultimately struck down the evil of slavery. Religious freedom in America empowered thousands of religious hospitals and schools that educated and uplifted racial minorities when much of America, much of the rest of America, turned their back on these marginalized groups. I'm a personal beneficiary of that. Religious freedom was the engine powering the American civil rights movement into a multi-faith ecumenical movement, and this multi-faith ecumenical movement empowered the civil rights movement to destroy racial segregation in the South and to begin a still ongoing, we're not done, process of advancing racial equality and equal protection of the law nationwide. And so when we think of religious freedom and the Religious Freedom Restoration Act, we should be grateful for this foundational civil right and for RFRA, which I believe we should understand is a vital civil rights law that is a shield protecting the crown jewel of human dignity in America. When we think of religious freedom, when we talk about it, what's the story that we should tell? What are the visions that we should have? As Sarah said, we should think about Dr. King not far from here and the March on Washington in 1963. We should think of St. Catherine Drexel's establishment of educational institutions like Xavier University in New Orleans to educate African Americans and Native Americans. We should think of Mother Teresa's religious sisters, the missionaries of charity, who right here, not far away in DC, care for America's untouchables, persons who are left behind because of poverty, sickness, or social isolation, who are still just as valuable as anyone else. This is religious freedom. This is how we should think about religious freedom. The right to love God and neighbor consistent with one's sincerely held religious beliefs. And this is why, in its highest form, religious freedom is the freedom to love, is the freedom to love in truth. This exercise of religious freedom, ultimately expressed as love of God and neighbor, is the basis of the American healthcare system. This healthcare system was built on the moral and religious conviction of many faith traditions that families, community, the states, and the nation, our federal government included, have a religious obligation to provide medical care for those who are sick and suffering. The exercise of conscience and religious beliefs about human dignity and caring for the sick has been and still is the primary motivating factor for hundreds of thousands of medical professionals and hundreds of medical institutions throughout America that make up the backbone of the American healthcare system. When the federal government, particularly the U.S. Department of Health and Human Services or other federal entities, violate religious freedom in healthcare, and the government acts in this manner, it is stripping love, charity, and human dignity out of the healthcare system. When the government acts against religious freedom, they are stripping love, charity, and dignity out of our healthcare system. When the federal government punishes or disfavors sincerely held religious exercise in healthcare, again, we're stripping that love, that dignity out of our healthcare system. When the government punishes or disfavors religious exercise, it is wittingly or unwittingly removing love and human dignity as the driving factor behind healthcare and replacing it with a primary concern about tax dollars, financial profits, and ultimately results in the objectification of patients and consumers. The Religious Freedom Act that we're celebrating today has been so valuable. And as Mark talked about, the Supreme Court cases in Zuvik v. Burwell, the Little Sisters of the Poor v. Pennsylvania, Hobby Lobby, it significantly established that the federal government has real limits on cracking down on free exercise when it comes to healthcare benefits and really broadly the healthcare system at large. Undoubtedly, the Religious Freedom Act today prohibits human freedom, it protects human freedom in medical care, and it serves as one of the legal deterrents of the federal government, legal deterrents of the federal government more broadly, and it stops the federal government from coercing medical professionals, charities, healthcare institutions from making healthcare decisions and providing healthcare services that violate their sincerely held religious beliefs. Unfortunately, however, and this is part of it's an extension really of what Sarah was talking about, we're seeing HHS in effect implement much of aspects of the Equality Act in their regulatory actions over the last couple of years. Currently, the administration has done not enough to protect religious exercise. After the Supreme Court's Dobbs decision, HHS issued what I believe is unlawful guidance that said in some circumstances under the EMTALA law, Emergency Medical Treatment and Active Labor Act, hospitals must perform abortions under some circumstances. I believe this is a false legal interpretation and it runs all over RFRA. HHS has also issued what I believe is unlawful guidance that could coerce pharmacists to prescribe products that violate their religious beliefs about the sanctity of life. And HHS is also preparing to issue its new regulation under Section 1557 of the Affordable Care Act, what was intended to be the civil rights provision of that statute, that could, based on what we saw in the proposed rulemaking, it could mandate unethical and harmful procedures, and it could, Section 1557, the rule that may come out later this year, early next year, it could effectively abolish Catholic medical professionals and Catholic healthcare institutions from participating in healthcare together in America, altogether. To protect this crown jewel of human dignity in our country, especially in healthcare, we need to recover the extraordinary necessity and value of religious freedom as a fundamental human and civil right upon which all other civil rights depend. What our country needs is a new birth of civil rights, starting with religious freedom, particularly in healthcare, and spreading throughout America. And we need to recover the central importance of religious freedom as a key shield that protects the ongoing struggle for human dignity and civil rights in healthcare. Some thoughts about what legislators and staff should consider, consistent with the First Amendment, Free Exercise Clause, and consistent with the Religious Freedom Restoration Act. First, there's a real need to broaden and clarify the protection of religious exercise of religious medical professionals, patients, families, and consumers in healthcare. I think that should be done outside the RFRA context. I think RFRA is great as it should be, but an additional statute that clarifies those protections would be so helpful. Thank God for the church and the Weldon amendments, but too often they're blatantly disregarded, I believe, both by the Justice Department and HHS, at least under the current administration. We also need the Conscience Protection Act and legislation that extends upon the aims of that legislation that would protect the medical conscience rights of medical professionals, healthcare entities, and provide a private right of action to sue in federal court where those rights are violated. We also need legislation around prohibiting state governments from making decisions on the licenses of medical professionals and healthcare entities that violate their medical conscience and religious freedom rights. And we also desperately need additional congressional oversight, particularly of HHS and the Justice Department, to make sure that in their regulatory actions and the guidance that they're issuing and the statements that they're making, they are holding firm to the religious freedom commitments that our government has made to the American people in the Constitution and into federal law. So as we think about religious freedom, think about it as a shield that protects human dignity and that ultimately is an opportunity to restore civil rights and human dignity in America. It is a principle that undergirds the desire of every human heart to love God and to love neighbor, especially in our healthcare system. Religious freedom, the work that you do on religious freedom, is critical to protect life and human dignity, particularly for the poor, the vulnerable, the immigrant, the weakest and most vulnerable. It is critical protecting the freedom to love in truth in our nation. Thank you.
Great, thank you, Louis. So we'll open the floor to questions momentarily. If you're called upon, please identify yourself, give your organizational affiliation. But before we do that, I have a question for Sarah, and it actually relates to some of the comments that Louis just made on human dignity, and it relates to this concept of dignitary harm. So when people look at ongoing controversies around sexual orientation and gender identity, non-discrimination policies, sometimes framed as LGBTQ rights versus religious liberty, people will sometimes frame the LGBTQ side as kind of being undergirded by this concern for dignitary harms. Could you talk to us both in the policymaking side, but also on the sort of judicial interpretation side? What should we do with this concept of dignitary harm? What role should or should it not have in this context?
Yeah, I think that's a tremendous question because the Supreme Court has recognized the impact of dignitary harm. So there were two specific cases. One was post-Civil Rights Act of 1964 in a case called Heart of Atlanta Motel versus United States, and it was systematic subordination of an entire race of people. This was the Jim Crow South, where they were resisting desegregation, and they were completely eliminating the possibility for Black Americans to even use public accommodations. The Supreme Court recognized that the purpose of the 1964 Civil Rights Act, among others, was to eliminate and to vindicate that dignitary injury to the whole human person that these individuals were suffering as a result of being systematically subordinated. A few years later, in a case in Minnesota, Roberts versus US JCs, the Supreme Court went on to force the JCs to admit women, basically saying that they had made unfortunate broadcloth statements about the capabilities and the abilities of women to be able to participate fully in that organization, which previously had been eliminated only to men. We are not talking about systematic subordination of an entire class of people. We are talking specifically about whether or not you can get a specific cake from a specific baker when that baker says, it's a violation of my religious beliefs, but let me refer you to another baker who I think is equally good, who can provide this service for you. A case out of the Ninth Circuit last year that was a little bit under the radar, but is really sort of on the cusp of some of these breaking manifestations of what it looks like in anti-discrimination law to be up against that sort of expansion of perceived sexual self-expression. A case called Green versus Miss United States of America, individual who's transgender, biological male, identified as female, wanted to participate in the Miss United States pageant. They recognized that and said, listen, our governing bylaws indicate specifically that this is an organization for natural-born women. However, we know there's another pageant that will accept you, and they provided that reference. He had raised in court, she had raised in court, this individual had raised in court that there was a dignitary harm that that individual suffered because this individual is being prevented from participating in that precise pageant. But when asked by the court, and this is the Ninth Circuit, who many of you will recognize has a tendency to be a little on the outs sometimes in terms of the realm of common sense and rational legal credulity, said, you've only raised a dignitary harm. So your perceived dignitary harm cannot outweigh the First Amendment interest that this organization has. Now, the specific statement here went to the question of what messages an organization is willing to promote. But again, because we're talking about First Amendment freedoms, and so many of these fundamental principles, First Amendment principles, are interrelated with one another. What we believe is also what we communicate, right? And again, 303 Creative versus Elenis, even though she had not raised a religious liberty claim, Lori Smith's speech was based on what she felt about her religious conviction. So even when the First Amendment right to religious exercise is not directly implicated, many of these times it will inform an individual's perspective about the beliefs that they want to express publicly. So we're dealing with an expansive, I think, distinction between what post-Jim Crow era South looked like and what we're seeing now in terms of that expanded request for forcing someone to essentially violate their individual perspectives on their right to speech or their right to free exercise of religion.
Two other quick points about dignitary harms. One, the Supreme Court, dignitary harms are real, right? It can be hurtful if somebody tells you that your race, your religion, your sexual orientation, the thing you want to do, the thing you want to say. It can be very hurtful if somebody says that's, bad, impermissible, evil, awful, wrong, unacceptable. So I think that's true. But the Supreme Court has quite rightly never allowed that to override somebody's First Amendment rights. And it shouldn't, right? Because in a free society, part of being free means that you and your neighbors are free to have different beliefs about important things and to express them. Secondly, in the Lori Smith case, there was no dispute that if she had just said, I think same-sex marriage is wrong, that would have been far more direct than simply failing to make websites. Like, that would have been public and out there. But nobody would plausibly be able to argue that the government should be able to punish her for that speech, and they shouldn't be able to punish her for that speech. She should be able to engage in that speech. And then third, in all of these cases, the dignitary harms argument always forgets the dignitary harm on the Lori Smiths, the Jack Phillips of the world. If you want to read a good Ninth Circuit case, the Ninth Circuit recently got a Fellowship of Christian Athletes case exactly right on whether the student group should be allowed to be a recognized high school student group, even though they've got their Christian beliefs about sex and marriage. But if you want to read about dignitary harm, go read the opinions in the panel, in particular the panel opinions in that case, talking about how the school treated the Christian kids and how it bullied them and how it wrote their religious beliefs on the board and swore about them in language I won't repeat here. You want to talk about dignitary harm. The people who are on the receiving end of these cases tend to suffer quite a bit more dignitary harm than anybody else. So it shouldn't be a driving consideration in the First Amendment area anyway, and if it is, the shoe's actually on the other foot in many of these cases.
Excellent. Thanks to you both. So we'll open the floor for audience questions. Looks like we have one right in the aisle.
Thank you. I'm Kayla Toney from First Liberty Institute. My question is about the interaction between Title VII and RFRA. To give an example, I represent Valerie Klosterman, who's a Christian physician assistant who was called evil and a liar and then fired when she requested an accommodation from using preferred pronouns and referring patients for gender transition surgeries. Now, I know that Title VII protects Valerie because it allows her to request a religious accommodation. But since RFRA doesn't have a private right of action, my understanding is that it doesn't protect her. So I'm curious your thoughts on how possibly expanding RFRA to a private right of action, or if there's another way to use RFRA to protect medical professionals like Valerie.
So yeah, that's an unfortunately common kind of fact pattern these days, right? So a couple things. One, in Justice Gorsuch's opinion in the Bostock case, Justice Gorsuch clearly believes that both statutes can work together in the same area, right? And there were 6 justices on that opinion. So I think Title VII's protection for religious exercise works. RFRA, I think, could also work if, and this sounds like this may not be that set of facts, but if an employer is facing a Title VII claim, if federal law is any place being used against you, I think you could also raise a RFRA defense. But if this is simply somebody gets fired in a way that the employer wasn't respecting her religion, my instinct is under the current law, Title VII is the way to go. And the current Title VII, after the great win in Groff last year, is better than it was a year ago, right? And gives good grounds to say, explain to me why the employer can't work around this. Because that ought to be pretty hard for most employers to say they can't work around. But again, if it's a case where any aspect of federal law is being wielded against your client, then I do think you would have a RFRA claim, because I think you could say, even if the government is not a party to this case, some private party is wielding something the federal government did, and therefore RFRA would have to trump that. That's at least my quick thoughts on it.
Yeah, I'll just mention briefly for those who don't know specifically about the Groff versus DeJoy case, great First Liberty case. Cassie was very involved in that win, so kudos to that organization. You guys did a great job. Specifically, they abrogated TWA versus Hardison, which for many years had said, okay, if it's more than a de minimis cost to your employer, you can't get a religious accommodation, which is ridiculous. It appears nowhere in the statute, and other civil rights laws do not imply that de minimis standard. So the justices, I think, weren't quite sure what to do with it. They just knew that the de minimis standard of TWA versus Hardison was wrong. Religious employees are entitled to a statutory religious accommodation, but then on top of that, if there is an implicated federal right, then that RFRA claim on top of it would protect them. But it seems pretty patently obvious to me that one individual making a request for certain pronoun use because of her religious beliefs about the nature of human creation and biology would be anything more than a de minimis cost to that individual organization.
Other questions?
Hi, Anna Breiner. I'm a law student intern at RFI. It seems like a lot of the time, you've mentioned this, there are sufficient reasonable alternatives, right? I think of the Fulton case, nobody even approached CSS. There were over 25 other foster care providers. Same thing with 303 Creative. It was nobody had even approached Lori Smith yet. And so I think a lot of the time that's pretty palatable. I come from a rural area that's pretty religious, and I wonder, how does that work in communities where maybe there is a lot of religious zeal, right? And there really aren't reasonable alternatives, what you would propose there?
I don't want to be a gunner, but I also want all the questions. So one, I think it's important to note in cases like Fulton 303, most of the time the answer really is there's somebody else who's happy to do it and happy to get the business, and therefore the government's argument isn't that compelling. Occasionally, the lawyers on the other side of such a case will posit the kind of community you're talking about. Well, imagine there's a place where no pharmacist will sell the morning after pill, or there's a place where nobody's willing to perform abortions. Maybe then the government's interest is compelling. My gut reaction to that is always twofold. One, it's almost always has to be done in a hypothetical, because like even in the most conservative place, there are some liberals, and even in the most liberal places, there are some conservatives. So I think it's usually actually hypothetical, because most of the time doesn't happen that way. But two, imagine it did, right? Imagine there's a town where there's no one willing to perform abortions or sell the morning after pill. I have a really hard time getting to the idea that the government has a compelling interest in making that guy do it. Like, that's nonsense, right? Like, if the government's got a compelling interest, if it's really important that everyone be able to get that drug here, then, okay, government, it's compelling to you, do it. Or Planned Parenthood, it's compelling to you, do it, right? But the idea that it's really compelling, so compelling that I won't do it, but the other guy has to. That's a little too cute, right? Like, it just doesn't make sense that it's compelling enough for somebody else to be forced against their rights to participate, but not quite important enough for the government to spend a few bucks to make it happen. So, like, I just think in that rare circumstance, if the government really does think there's a compelling absence of bakers someplace in the Deep South to bake a cake for a wedding, for a same-sex wedding, then the government ought to offer some stipend to find some baker. I don't think it'd be all that hard.
Other questions?
Hi, this question's for Mark. You'd mentioned that the courts have a frequency of overlooking Native American claims for religious protection. How do they justify doing that?
These are usually out in the Ninth Circuit, which tends to, at least previously, have fairly bad religious liberty law. And they tend to do it by, I think there's a combination of a couple things that are going on really in the old cases. From the left, there's a little bit of we don't really love religion. From some people on the right, there's a little bit of the government's right and the government ought to be able to run its property in its own way. And the truth is, vast swaths of the western part of this country are technically the federal government's land, right? Like my Native American clients would say, yeah, but how'd you get that land, right? So there's an argument about that. But I think the way we got there was essentially judges giving a little too much deference to the federal government's view that it's my property, and if I'm doing what I want with my property, it can't possibly burden your religion. I just don't really think that's true, that we wouldn't accept that anyplace else, right? In other words, if in Yellowstone Park, the government wanted to prohibit me from wearing a T-shirt that said, one side or another, some debate, they couldn't do that. And the answer that it's my property wouldn't mean they hadn't burdened my free speech rights. Of course they'd burden my free speech rights. So I think it's that combination of stuff, right? The Native Americans are in a peculiar position because a lot of their sacred sites are on land that the United States government took, purchased, acquired somehow, whatever you want to call it. And so then it's not like me going to St. Patrick's Cathedral, which isn't the government's property. I think that's the driving thing. I don't think it should hold up. I don't think it will hold up over time.
Okay, we probably have time for one more question.
Well, I'm Hendon Torsak. I'm an intern here at the Senate. And in Alexis de Tocqueville's book, Democracy in America, he defines liberty as the ability to act under just and moral laws. So a question for all of you is, how does religion play into preserving our liberty?
Well, I can give you what I think is a very short answer to that. Religion is the ultimate exercise in liberty, the ultimate ability to act upon your sincerely held religious beliefs, which the founders thought important enough to articulate as the first fundamental freedom, indicates that that was the governing principle upon which the rest of our individual liberties were to be exercised. I think ultimately, there are principles in First Amendment law, right? My freedom to punch ends where your nose begins, right? Same thing in tort law. Listen, there is a harm principle that certainly transpires, but that freedom to believe is such a fundamental exercise of who we are as human beings that I think we have to begin with that premise and then move out from there as we understand what it means to be Americans and ultimately what it means to be humans who are living in a free society.
Yeah, I would say that I think de Tocqueville's been proven right on so much and really visionary. Religious exercise should be understood within the context of the natural law. There's no religious freedom right to commit murder. There just never is, there never will be. Religious freedom is understood within the context of human dignity, within the context of the natural law. So I think that's absolutely vital. And even for those that, that might not be adherents to a religion, the central importance to objective truth within society, to be able to say that truth matters and that there's certain realities within which we live, even just that notion. Last thing I'll say is there's a reason why one of the most oppressive countries in our time, the Chinese Communist Party and the regime there, is so concerned and so tyrannical against religion. You could say the same thing about Vladimir Putin and the Russian Federation. You could say the same thing with what we're seeing in Canada and in some ways in Australia. Human freedom is being squelched by oppressive governments, that are coming after religion, and there's a reason for that. And so religious exercise that is understood within the prism of human dignity and natural law is absolutely foundational to human freedom.
All right. Thank you so much to the panelists. We have a light lunch that's available, so please go ahead and partake in that. Join us back here at noon. We'll have Congressman Wolf in a discussion with Nina Shea, so please do that. And thank you on behalf of the Religious Freedom Institute for attending this event, and please join me in thanking these excellent panelists.
Well, thank you for staying with us through lunch today. My name is David Trimble. I'm with the Religious Freedom Institute. My voice is waning a little bit with fall allergies. Fortunately, I'm not the one going to do most of the talking. We are privileged today to have two giants of leadership in our midst that have, for decades, pointed the direction on international religious freedom. Continue to eat and enjoy your lunch. This is meant to be kind of an informal conversation over lunch, and as we hear from Congressman Frank Wolf and Nina Shea. Frank Wolf serves as a commissioner of the U.S. Commission on International Religious Freedom, USCIRF. He previously represented the 10th District of Virginia for 34 years in the U.S. House of Representatives. While in Congress, as we all know, he worked extensively to promote the human rights of people around the world. Congressman Wolf authored the International Religious Freedom Act of 1998, which infused religious freedom into U.S. foreign policy. He also created a special envoy at the U.S. State Department to advocate for religious minorities in the Near East and South Central Asia. Congressman Wolf was the founder and co-chair of the Tom Lantos Human Rights Commission, a bipartisan organization of nearly 200 members of Congress who work to raise awareness about human rights issues. He previously held positions as a distinguished senior fellow of the 21st Century Wilberforce Initiative and held the Wilson Chair in Religious Freedom at Baylor University. Nina Shea, a good friend, is a senior fellow of the Hudson Institute, where she directs the Center for Religious Freedom, an entity she founded in 1986. She was appointed by the U.S. House of Representatives to serve for 13 years as a commissioner on the U.S. Commission on International Religious Freedom, appointed by Frank Wolf. She's a lawyer by training. She undertakes analysis and strategic advocacy regarding foreign policy on religious persecution. She helped lead the Coalition for the International Religious Freedom Act. She was appointed as a U.S. delegate to the UN's main human rights body by both Republican and Democratic administrations. She has authored or co-authored 3 books on religious persecution, genocide, and the threat from blasphemy and hate speech bans. She produced widely publicized reports on extremism in Saudi textbooks. In 2011, she discussed her findings in Riyadh, which led to reforms. She writes in the Wall Street Journal, National Review, and elsewhere. Both Congressman Wolf and Nina Shea have been colleagues and mentor to me personally. Nina, I don't know that you are aware of this, but at some point, 10 or 15 years ago, I took exception on something you had said or a particular point of policy with our dear late friend, Ken Starr. Ken said to me, David, I wouldn't reach that conclusion quite so quickly. I think Nina's right. When Ken puts you in your place, you're put in your place. And my appreciation for Nina at the time rose even more. We're so glad to have these two with us today. In Congressman Frank Wolf and Nina Shea, we have one of the strongest voices within the walls of government, one of the strongest voices independent of government to defend international religious freedom over the last 3 decades. Our time is limited today, but I'm convinced we need to hear from Frank Wolf and Nina Shea again. I don't think I'm overstating the case when I say that we are standing on the edge of unprecedented levels of religious persecution worldwide, whether in Nigeria, China, Myanmar, Nagorno-Karabakh, the MENA region, or across Central Europe. Religious freedom is under attack. At home and abroad, people of faith are being driven from the public square, and what people believe about God, the family, and the human person is ridiculed and disparaged. Let's track back to 1998. The times were not entirely unlike these, perhaps in some ways not as severe, but nonetheless, the world needed an international religious freedom movement, and for the U.S. to lead the way. I've asked Congressman Wolf and Nina to take about 3 minutes apiece and set the stage with some opening remarks. Their thoughts about where we were then and what led us to the International Religious Freedom Act of 1998. Nina, I'll turn it over to you first.
Well, thank you, David. It's a real honor to be here. It's a privilege to be on the podium with former Congressman Frank Wolf, who is the godfather of the International Religious Freedom Act and the movement. I like to say that the U.S. is the indispensable nation in the world when it comes to advancing religious freedom. And with all its faults, all the problems, it still is. We heard, and it's because of the strength of our First Amendment. It's the acknowledgement in our Constitution and laws that it is an inalienable right, a God-given right, a right that's innate in humankind, and is not a privilege granted by the government. And that, in that sense, the International Religious Freedom Act of 1998 helped build the infrastructure for our projection of religious freedom, our defense of religious freedom worldwide in our foreign relations. And Frank Wolf did that. He was the initial sponsor. He seized the idea. And for actually 3 decades, more than 3 decades, he personally, in using his congressional seat and his powerful seat as an appropriator to advance religious freedom in foreign policy. But the act creates the infrastructure, the office at the State Department, the ambassador position, and we'll be hearing from former Ambassador Brownback later today. The USCIRF, the U.S. Commission on International Religious Freedom, which I had the honor of serving for over 12 years, thanks to Congressman Frank Wolf, again, who nominated me, and for the CPC list, a country of particular concern, a very important list of the world's worst persecutors. It puts a lot of pressure on those countries just to be named. And the annual report on religious freedom, which is, it has flaws, but it's an incredible compendium of religious persecution and rights abuses. And I commend to you, actually, the China chapter, which I had the occasion to reread this last week. It is very comprehensive. It's an excellent resource. So this is unique in the world. I don't think any other country, no other country has quite this infrastructure. Again, thanks to the Act, thanks to Frank's vision and determination. And it wasn't just introducing, it was also this deft political, legislative maneuvering on the very last day of the session back in 1998 that ensured its passage. Otherwise, it would have failed. It was doomed, according to the New York Times, in the only article that it wrote about the bill. It's invaluable. There are lots of areas where it can be improved, and I'll stop there. Maybe we can get into that later.
Thank you, Nina. Congressman Wolf.
Well, thank you very much. I want to thank RFI and David for having this event. It's very important. I want to thank all of you for being here. And I want to thank Nina for, so many years. Every time we call Nina, Nina gets involved. And so God bless Nina. So thank you for Nina. All over this world, people of faith are being denied the fundamental and inalienable human right to confess their faith according to the dictates of their conscience. I believe, personally, there's never been a greater need for action. Right now, there's probably more persecution, hard to believe it when you compare in the past, going on worldwide than any other time in modern history. The Pew survey says that 80% of the world's population lives in a religiously repressive environment. There's growing persecution, and yet, and Nina knows this well, the cries of the persecutor are being met with deafening silence, and many around the world, they feel abandoned. They feel abandoned and they feel doomed. In China, every group is being persecuted. You know this, you're all experts, but the Catholic Church, 91-year-old Cardinal Zen being prosecuted in Hong Kong. Protestant pastors being arrested, crosses being taken down. Cultural genocide in Tibet, not actual, but cultural genocide. Lhasa is no longer a Tibetan city. It's a kind of a dirty Chinese city if you've been there. Organ harvesting, Nina put a show on, I watched it a while back, of Falun Gong taking their organs out while they're still alive. And actual genocide by Uyghur Muslims, and I know that you'll probably hear today more about that. In northern Iraq, the Christian community is diminishing, and Yazidis are living in IDP camps. I've seen the camps, they're terrible camps, and 2,700 Yazidi women and girls have not been reunited with their family. And keep in mind, more biblical activity took place in Iraq than any other country of the world other than Israel. Babylon, Daniel, I've been to which is Nasiriyah, where Abraham came from, and we are ignoring them. In Egypt, Coptic Christians and other religious minorities are facing persecution and much worse. And anti-Semitism still appears in the Egyptian books, and yet the Jewish community in Egypt has gone from 50 to 60,000 down to three individuals, and they still have anti-Semitism in the book. In Pakistan, God bless you, Bas Bate, I'm glad you told me you're doing a book. Christians are being jailed for blasphemy, and Ahmadi Muslims suffer severe persecution and even death. In Nigeria, as Nina said, Boko Haram has committed genocide against Christians, and Fulani militants are committing genocidal activity. The recent report, 52,000 Christians and 34,000 moderate Muslims have been killed in the past 3 years, and yet we still give them almost $1 billion a year. $1 billion a year to a country that is in a CPC designation? What Nina said? In Nicaragua, I read a report this morning. The Catholic Church is being persecuted. The Catholic Church is being persecuted, and Bishop Alvarez, God bless him, has been jailed. Sisters of Mercy, Mother Teresa's group, has been expelled from the country. And I saw a report today saying that they don't know where Bishop Alvarez, if he's still alive at this moment. and yet there's not a lot of people talking about it. In Cuba, persecution of Christians is escalating, all, I might say, with the support of China. There's so much religious persecution in so many other countries, too numerous to mention, and there's growing, I would have to say, because I saw your program, there's growing domestic religious freedom problems right here in our own country. And I'm reminded, and I gotta say it, God bless him, of the late Cardinal Francis George, who predicted in 2010, he said, I expect to die in my bed, my successor will die in prison, and his successor will die a martyr in the public square. Is that alarmist? We hope so, but we just don't know. In closing, it is important to have a conference to educate people about what's going on, but I think you also need to come up with solid proposals of what can be done and how it can be done to deal with these problems. There are things that can be done that would make a big difference. But again, thank you, and thank RFI.
Well, thanks to both of you for those opening remarks. Our goal in this short time over lunch and in the two panels this afternoon is certainly to move towards articulating some solutions, some recommendations on what we can do. Frank and Nina, allow me to turn back the clock. Litigation in our courts, legislation in the states and on Capitol Hill. In both instances, that is born out of a cultural milieu. Culture leads to litigation, it leads to legislation. We see that over and over again. As we think back into 1998, what was going on? What were the conditions at the time that led to IRFA, the ascendancy of religious freedom and human rights under the Reagan era, oppression of the church around the world? What were those conditions? Help us to understand historically that time that led to the culminating enactment of this law. Nina, you first.
Yeah, well, this was after the Cold War and the collapse of the Soviet Union. And at that time, during the Cold War, there was a lot of awareness about religious persecution behind the Iron Curtain. And this was thanks to the ethnic communities here in the United States, the refugees from those areas and their families who really took the lead in this. And it was also President Reagan who saw religious persecution or religious freedom as the Soviets' Achilles heel. That's a quote from him. And he emphasized it, and he cared about it himself, the religious persecution behind the Iron Curtain. And it was horrific, with decades in prisons, gulags, people dying in gulags, in psychiatric institutes. And Frank was there. He visited Perm 35, I think you said. But after the Cold War, in the 90s, it dropped off the screen. People stopped hearing about it. The media stopped reporting on it. It wasn't in those same places. It wasn't in Poland anymore, but it was in other countries around the world, and including China. And thanks to Louis Brown for mentioning it this morning. It is, I think it's the biggest threat today for religious freedom because it is being, it's high tech, it's a modern version, it's comprehensive, it's all encompassing, and it's being spread. But there was China, there was parts of Asia and Middle East and Africa where people were imprisoned and still are, in Iran and Saudi Arabia for their religious beliefs, in many other places, and no one was really aware of it or talking about it. Sudan was our very big top issue. It was the first country I introduced in USERF to get CPC, to recommend CPC status, being on that short list. There were 2 million Christians from South Sudan that had been murdered, and 5 million pushed out of their country, remember, Frank? And no one was reporting on this at the time. And that was the first, I think, great victory of USERF. It showed its importance because it brought it to light and made it a recommendation for CPC. Now, this was at the time after Osama bin Laden had gone to Khartoum, been invited in by the government to set up and to start Al-Qaeda. And it was before they attacked us on 9/11, 2001. So most Americans didn't even know about Islamic extremism and Al-Qaeda. But those of us who were looking at Sudan closely understood what was happening. We were warned by some of the Catholic bishops there, Bishop Gassis, that it's going to come here. And I was incredulous. I didn't think that he knew what he was talking about, and I was humbled afterwards. But you know, it shows the link between our own national security and religious persecution abroad in those places where it's very, very severe. And that's what USERF basically does, and the State Department does, is look at the very worst places in the world and try to make sure our funds, our foreign aid is not being used to further this, as it often is. Frank mentioned Nigeria, where we give $1 billion a year in foreign aid, and we make no conditions on its religious freedom. I heard today that there was a massacre again today in Benue state in Nigeria. It's a 90% Christian state. They're being invaded by Islamist extremists. So, you know, the thing I would say is that we need to still reach out to the American people. I'm convinced that the more the American people hear about what's happening in the rest of the world, what the absence of religious freedom means, what persecution means today, what it looks like in a modern state of China, in a more brutal fashion, bloody, graphic fashion in Nigeria or wherever it's taking place, in these different systems, authoritarian systems around the world, we need to expose that. And the State Department, USERF, all of us should be out trying to reach the American public about that. And thank you for holding this conference today to do just that.
Frank, the conditions led you and a team of members of Congress, Tony Hall and Chris Smith, and Arlen Specter and others, to doggedly pursue the passage of this act. What was it that was driving you? What were those conditions like then?
Well, I agree with everything Nina said. President Reagan made the difference, certainly in my life, but in many other lives. And I think Reagan and Pope John Paul just literally changed everything. I think the combination of the two of them, and Margaret Thatcher too. I think, but President Reagan and Pope John Paul just crystallized this thing that you just. Also, I want to pay tribute to the Jewish community. The Jewish community helped get me active. They would come by and say, Mr. Wolf, when you go to Moscow, take this in, do this, do this. So the Jewish community, and I remember President Reagan addressed, there was a large rally on the mall. Thousands came, 85, 86, I forget the exact time. And so the Jewish community made a tremendous difference. Nina's right, it was China. China was doing things then. I mean, Congressman Smith, God bless Congressman Smith. Our Congressman without Congressman Smith would be no Congress at all, because he's the guy. But I remember he took Holy Communion from Bishop Sue. Bishop Sue was taken away and never, ever seen again. Maybe once in a black car going across the plaza. But Sudan, she was right. There was a coalition, bipartisan coalition. My best friend, Tony Hall in Congress, the Democrat, it was bipartisan. Up until the last few years, used to be a strong bipartisan coalition on Sudan. But Nina was right. Groups would go there, and that made all the difference in the world. The last thing is, there were people in the faith community. He was at Chuck Colson. God bless Chuck Colson. Father Richard Newhouse. Father Richard Newhouse was a giant. I once was with him, and he's a giant. He and George Weigel were together, and you had Carl Henry, the guy who started Christianity Today. Don Argue, who was head of the National Association of Evangelicals.
Southern Baptist.
Yeah, and in Congress, Dan Coates. There would be no bill had it not been for Dan, because at the very last day, as Nina said, the Chamber of Commerce was opposed to it. Madeleine Albright, God bless her, I liked her, so I'm not criticizing her, but she gave a speech at Catholic University opposed to the bill. It was stuck in the Senate, and Dan Coates, about 6:30, 7 o'clock at night, and Don Nichols saved the bill. So you had people in Congress that this was such a driving thing. So I agree. Thank God for Dan Coates and Don Nichols, who really at that end, because I don't think it would have passed if it had gone into the next Congress. The Chamber of Congress was opposed to this bill.
Frank, this rising up of this national faith coalition in America at the time intrigues me, because it's something that I think is a missing element today. And it almost seems like there was a swarming of momentum with the rally on the National Mall, as you said, the launch of National Religious Freedom Sundays that we discussed, where churches were holding services, you said, over a period of 10 to 12 years, advancing religious freedom. It appears to me that we need that type of national faith coalition in America again today to advance religious freedom.
Well, I agree. You have to wake up the church. There was a group right after the bill passed. There was a group established somewhere out in Chicago. I forget the exact town. All they did was have a staff to go around Catholic, Protestant churches, all different denominations, to have a religious freedom service, mainly on Sundays, but at different times, depending on the church group. And they would bring in at National Presbyterian. I'm a mainline Presbyterian. I go to Vienna Presbyterian Church. National Press used to have a big Sunday, bring in a Chinese dissident, a Sudanese dissident, a dissident from here and there, and they would speak. That's all gone. It's all gone. And so I think you really do, there's so many passages as a Christian, but there's so many passages in the Bible that tells you if we want to follow the faith that you should be. And Cardinal O'Connor, remember Cardinal O'Connor, Bishop Chapeau. I once did a meeting that I sent out to come to talk about religious freedom in my office, not to a lot of people. Do you know who came to the meeting? I don't even think I invited him. Cardinal Wuerl. He walked in the meeting. That's what you really need. You need...
And don't forget A.M. Rosenthal.
And A.M. Rosenthal. God bless A.M. Rosenthal. She's right. A.M. Rosenthal, the editor of the New York Times, was a giant. And Meg Grenfeld at the Washington Post. And God bless
But
him.
Abe, he wrote column after
He was
column,
really...
just pounding this issue after he became aware of it.
You're exactly right.
He said, I've been writing for decades as a journalist and editor of the New York Times, but I never really looked. I've been writing about human rights, but I never looked at religious persecution. It's terrible. And he didn't stop writing about it until he passed away.
Yeah, you're right.
But we certainly don't have that today in the New York Times.
So, Frank, you mentioned that at the end of the day, the bill almost didn't pass. And if it wasn't for the heroics of Dan Coates and others, it just might not have been signed into law. There were impediments to the bill. The Chamber of Commerce, for example. Even the State Department at the time challenged the bill going forward. So there were these impediments, and yet it seems like the coalition of faith and the movement, there was a movement that got it done. I want us to turn our thoughts now to the content of the bill for just a moment. In your opinion, Nina and Frank, what are some of the key provisions of IRFA that were included in the act that we utilize, but maybe we need to utilize better?
Well, one of the things that we talked about at the time that we knew was a missing element was making sanctions mandatory when a country was designated to be one of the worst persecutors. And we decided not to do it in order to make sure that the reporting was not fudged, that it wasn't distorted, that the State Department didn't want to shy away from reporting how bad it was in a particular country because we had that country as an ally and needed its support for something or other. And it would at least ensure factual reporting. And unfortunately, and I think there was another model, the trafficking in persons bill, if you recall, Frank, that did have that tie between designation and sanctions. So the bill went through without any mandatory sanctions. There were sanctions, that were possible but not required, even for the very worst countries. And unfortunately today, I think that some of those countries, and Nigeria is a prime example, the facts are not being reported, that it is being fudged. Anyhow, for climate change reasons is what the State Department has said. That's the priority, not religious freedom, and they want the cooperation of the government, so they're muting this, which I don't understand because we do give them $1 billion, they need us. We don't hesitate. We also want to have climate change agreements with other countries around the world that are on the CPC list, and we don't hesitate. So I think that was a consideration at the time, and it was maybe we made the wrong decision in the end not to attach that.
Interesting. Frank?
Well, I'm not speaking for USERF today, but I am on USERF, but they need a bigger budget. The budget of USERF is about what it was 25 years ago. Now, think of your own budget at home. Is your food budget what it was 25 years ago? So I think you need a permanent authorization to give them. Every time the government shuts down, they're going to lose people, and so they need a permanent authorization. Plus, the Congress has not been good in funding USERF, because USERF reports on all these. USERF says things that many people will not say in the State Department and in the business community. So I think you have to increase their funding. They're not lobbying on the Hill, but they report and they call things out. And I've been very impressed. It's been very bipartisan. We have 8 people on the commission, and we're together on most of these issues. So I think you have to give USERF more of a funding, more of a permanent authorization. And lastly, I think there ought to be, and I wrote it down, and if you lead me on, but I think there needs to be some strengthening of the CPC designation so it carries more weight. I would love to see a law passed that says that if you are a CPC country designated for 3 consecutive years, you cannot have a registered lobbyist working for you. Now,
That's interesting.
That's, to me, seems so reasonable that I did a press conference on Friday on the issue of Nagorno-Karabakh, where genocide is taking place, or maybe it's ethnic cleansing, I think you can determine. They got 2 of the biggest lobbyist firms in town. Now, we know the world neglected the Armenian people in 1915. Well, the world's neglecting the Armenian people in 2023, and ethnic cleansing is taking place, and we give the Azerbaijan government foreign aid. So I think you have to strengthen USERF and try to stop this lobbying for not for all countries, but for countries who have a CPC designation for at least 3 years. That would make a big difference.
So that leads us right into the final question for both of you. Really 2 parts. Has IRFA been fully implemented? And if not, what do we do? And Frank, you've suggested one or two ideas here, but let's further elaborate on that. If IRFA has not been fully implemented as intended, what do we do now? What are some things we can do that put some teeth into this bill and its implementation? Nina.
Well, yeah, I think that the budget is an important issue, and I think, the commissioners, not many people realize this, the commissioners are not paid. There's no reimbursement for their time. And it takes a lot of time to read everything that it's churning out and to edit it and to, read other things, to propose ideas within the commission. All of us have occupations during the day. We have other interests. We have to other commitments. So I think that would be important to pay a stipend like some boards do and some other commissions do. I think that there should be in the budget this funding for domestic travel so that the commission can go from place to place, holding hearings. We did that. I don't know if you still do that, Frank. We did that for a few years, going to LA for the Iran and holding hearings on Iran for the Iranian community, for example. And trying to raise awareness, create a media event in those other places to get out of the beltway, as we say. So I think that is important. I think that a bill that would make mandatory in some way sanctions, I think Frank Wolf had a great idea just now about 3 years on CPC, then you lose certain licensing privileges from the government here. So I think that's the big one. And I think that there should be also, I'm concerned about a revolving door between USERF staff and the State Department, because I always saw USERF as kind of a watchdog, or at least it would be a vanguard to raise issues. But if the staff is looking for a permanent job that pays even better, and they want more security, they want to go to the State Department, they will not want to take on that role of being a cutting-edge, visionary organization that maybe is critical to the State Department. So I think that there should be some revolving door limit on USERF.
Frank?
Well, I agree, and I think what Nina said, and having been a commissioner longer than anybody else, she probably has a better understanding of it than anybody. I wrote down a couple of things that you could do to have, not just to talk about it, but to really make a big one: ban China lobbying and prohibit lobbying for any country that has a CPC designation for 3 years. 2, establish, and I wish I had more time to talk about this, but a bipartisan group of former Hill staffers with experience on the Hill to basically be your lobby firm. Former staffers who are former appropriation staff, House and Senate, bipartisan, let me just say former Foreign Affairs Committee, former Government Operations Committee, former judicial, to be your ears here, and for all of you to be the board of directors for RFI and Alliance Defending Freedom and the different groups, have it rotated to be the 12 board of directors to say, here's what we want you to do. But they'll be your ears and your eyes, because many of you can't do this because, one, funding, but secondly, 501(c)(3), tax status, you don't want to get in trouble and lose the thing. So that's the second thing. 3, you have to wake up the church. There's a lot of things that can be done to wake up the church. 4, I would ask the Presidential Debate Commission to have this year a segment on human rights and religious freedom. I mean, they talk about a lot of issues. Ask them now to have a segment on this issue so it comes out to the world. Also, I think there should be a program comparable to the Fulbright Scholars to fund scholars to study and work on human rights and religious freedom. Let's call it the Reagan the Reagan-Carter Foundation or fellowships. God bless President. Did you see the picture of Jimmy Carter the other day with his wife? Jimmy Carter went back to the same house he came from. He originally didn't have electricity and running water. Let's name it after President Reagan, who, as Nina was right, I mean, Reagan and Carter, but have a fellowship that we, like the Fulbright, that we fund these things. Also, to bring it domestically, have a 1-800 number in all the churches and synagogues and mosques, so that if somebody is being discriminated against, they can call that number and get a lawyer, because school boards, I come from Fairfax, Loudoun County, school boards and some companies are discriminated against people because of their faith. So have a 1-800 number that somebody can call to get a lawyer to help them. Lastly, I think you should be making contributions and getting wealthy individuals to contribute money to ADF, to Beckett, to First Liberty, to the Christian Legal Society. Forgive me for the ones I left out, but to all of them, so they need to be able to hire the very best lawyers coming out of the very best law firms. And lastly, I think you have to really make sure. The NAACP did that during the Civil Rights Movement. There was a telephone number to call. But I think to work together to get all these groups to have a coordinating committee, so that when a call comes in that somebody, you remember when the guy from Marriott was being discriminated against and fired, I think. Did he get fired for saying something about the Dalai Lama in Tibet? He could call a 1-800 number and get a lawyer who would know that they're adequately funded to kind of fight that case. Closing, Ken Starr, and God bless him. Ken Starr was, maybe I wouldn't have run for Congress if it had. I lost twice, and Ken Starr and Alice urged me to run again. You often don't run three times. I read Ken Starr's latest book, God bless it. He says if you bring a case, you almost never lose, although it takes a long time. It takes 5 years. So to adequately fund ADF, Beckett, First Liberty, all these groups, so they know that they have the resources that when they get the call to kind of do it and hire the very best people they can. I think that in a new legislation would change things dramatically for religious freedom and human rights for all, for every different group here in the city and in the country and in the world.
Thank you, Frank. Let me exercise the prerogative of the chair to make 2 further recommendations, and then we'll close. I'd like to suggest that to optimize the implementation of IRFA, we need to, as a group, insist on mission alignment and mission integrity between the IRF Act, the IRF Office, and USERF. That mission alignment and mission integrity is written within the Act itself, and the Office and USERF are simply to carry forward advancing religious freedom. Finally, I'd like to say it personally. I'm encouraged to hear the history of the movement of the church involved in this. And I think we must find a way to raise up the church again and to find another Colson, another Henry, and leaders to point the way. These 2 have done that. We thank them today. Please join me in expressing that thanks.
Frank, thanks so much for everything you've done. Really.
Well, good afternoon, and welcome back to this day commemorating the 30th anniversary of the Religious Freedom Restoration Act and the 25th anniversary of the International Religious Freedom Act. This afternoon, we're going to focus our attention on the latter, and I'm delighted that we have a distinguished panel. Before we do that, though, we're going to hear about the importance of the International Religious Freedom Act where it came from, what it's about, what its legacy is, from Tom Farr, co-founder and president emeritus of the Religious Freedom Institute. Now, I know that Tom is a friend to many of you who are in the room, but for our video audience and for the future, let me just mention how he came to this position to be one of the true champions for global religious freedom. Tom Farr serves as president emeritus and as co-founder of the Religious Freedom Institute, a leading authority on international and domestic religious freedom. Tom spent 28 years in public service in the U.S. Army and then as a Foreign Service officer. He became the first director of the Office of International Religious Freedom in the U.S. Department of State following the passage of IRFA in 1998. He subsequently directed the Witherspoon Institute's International Religious Freedom Task Force. He was a member of the Chicago World Affairs Council's Task Force on Religion and U.S. Foreign Policy. He taught at the National Defense University and served on the Secretary of State's International Religious Freedom Working Group. For a decade, he was professor of practice at Georgetown University within its Berkeley Center for Religion, Peace, and World Affairs, where we first met. And it was there that he and colleagues launched the Religious Freedom Project that over time became the independent Religious Freedom Institute. His many published works include World of Faith and Freedom, Why International Religious Liberty is Vital to American National Security, published by Oxford University Press. And this book has had a profound impact on legislation and U.S. foreign policy. Would you help me welcome Tom Farr?
I'm looking to see if Frank Wolf is still here. I don't see him. I don't usually wear a green tie, but I'm wearing it today. If you've noticed, Frank Wolf always wears green ties. He's my hero, and I just wanted to pay this small tribute to him. Nina is also one of my heroes, but I can't wear what she wears. Thank you, Eric. Kudos to you for assembling this incredible cast of veterans of IRFA, and thanks for inviting me to address them and everyone else here today. It's really an honor to do that. Eric has asked me to frame this afternoon's discussion, so I'm going to offer my reflections on 25 years of U.S. IRF policy. Eric said I have a lot of friends here. I hope I still have them when I'm finished. My overall argument is that notwithstanding the superb work of the ambassadors, the commission, and their respective staffs, and other supporters and advocates of IRF, the promise of IRFA remains largely unfulfilled, I should say. America has, alone among the nations of the world, recognized religious freedom as the birthright of every human being. The claim that religious freedom belongs to everyone has benefited our society and amply justifies IRFA's quest to advance this foundational right in a world that desperately needs it. Before I give my views on why that has not happened, or not yet, let's briefly recap IRFA's core policy goal and the structures it created to achieve it. IRFA requires the President, Department of State, and I quote, to condemn violations of religious freedom and to promote and to assist other governments in the promotion of the fundamental right to freedom of religion, unquote. To carry out this policy, the statute created an office at state headed by an ambassador at large. I had the honor to serve under the first two of them, whose job is, quote, to advance the right of religious freedom around the world, unquote. IRFA also requires the department to train Foreign Service officers on the value of religious freedom, issue an annual report on religious freedom, and designate countries of particular concern. We've talked about that already today. The law also created an independent commission to provide policy recommendations, several representatives of the commission here. We've now had 25 years of that policy in action on the ground, under 5 presidents, 2 Democrats, 3 Republicans, 6 ambassadors, and scores of commissioners. IRFA was passed in 1998, as Nina and Frank were talking about, mainly because of the dramatic increase in religious persecution after the end of the Cold War. Many religious groups in America believed the State Department was not paying sufficient attention to that problem. So in the mid-90s, a coalition of American Christians, Jews, and other religious communities began to lobby for a law that mandated that the State Department pay attention. Unfortunately, but importantly, the State Department did not want a religious freedom law. John Shattuck, State's Assistant Secretary for Democracy, Human Rights, and Labor, told Congress that the department believed the law would create a damaging hierarchy of human rights, with religious freedom at the top of the hierarchy, marginalizing the rights below. Secretary Madeleine Albright elaborated this hierarchy claim in a 1997 speech at Catholic University. Now, this hierarchy concept clearly reflected the views of our diplomatic corps at the time, but a variety of circumstances, including the support of influential Democrats like David Saperstein, led Mr. Clinton to sign IRFA anyway. But the hierarchy claim has not only survived these 25 years, it has lingered, and recently it has grown. After the passage of IRFA, other more bureaucratic forms of objection emerged at the State Department. For example, the department resisted adding a report on religious freedom to its existing human rights report. It opposed mandatory training of Foreign Service officers and sought to retain its existing voluntary course, which was ill-attended. Under Republican Secretary of State Colin Powell, the department tried to circumvent the requirement for a separate IRF ambassador by double-hatting the position with that of the Assistant Secretary for Human Rights, Democracy, and Labor. Fortunately, these objections were overcome with the help of Congress, and especially people like Congressman Frank Wolf and Commissioner Nina Shea and others on the IRF Commission. The position of ambassador survived and has been filled for 25 years by 6 highly talented men and women. The annual report has survived as well and has become the global standard for describing the status of religious freedom around the world. State eventually initiated mandatory training for FSOs, both in DC and abroad. The Commission has held hearings, traveled widely, and issued its own reports and recommendations. Other nations stimulated by IRFA have developed their own policies, including the UK, Canada, and the European Union. With an idea that originated with Knox Thames, who is here, there he is, Ambassador Sam Brownback spearheaded 2 major IRF ministerials at the State Department and established an international IRF alliance. IRFA-inspired civil society groups like the IRF Roundtable have ensured the engagement of a diversity of American religious communities. In recent years, the Roundtable has also run important interreligious dialogues abroad. So these and other meritorious efforts are very encouraging. Why then my suggestion that the promise of IRFA has been unfulfilled? The most authoritative empirical evidence comes from the Pew Research Center, which has already been mentioned. Since 2007, Pew has issued an annual survey measuring the status of religious freedom in every country in the world. Over time, that status, up to today, has worsened in every region and most key countries of the world. Severe persecution continues in most of the nations where it was present in 1998. Alarmingly, the status of religious freedom has, according to Pew, also declined in Western Europe and the United States of America. Now, we certainly can't conclude that U.S. IRF diplomacy is responsible for the decline of religious freedom, nor the vast human suffering that it represents. Indeed, a signal success of our diplomacy has been to relieve human suffering in particular cases, such as helping Iraqi Yazidis flee ISIS or freeing Pastor Andrew Bunson from an unjust prison sentence in Turkey. But it seems self-evident, to me at least, that rescuing victims in isolated cases, as wonderful as it is, and the condemnation of persecution in annual reports can contribute to, but cannot alone achieve, IRFA's goal of advancing religious freedom on the ground. IRFA also authorizes, as Nina has talked about, and Frank too, punitive sanctions against those severe violators, such as suspension of aid, but those actions have been extremely rare, almost non-existent. In part, this reflects a judgment that religious persecution, while regrettable, doesn't threaten U.S. national interests. That judgment, in my view, is badly mistaken, but even a more effective application of punitive sanctions is by itself unlikely, in my view, to advance religious freedom. Most nations that lack religious freedom perceive U.S. policy as a Trojan horse designed to undermine their culture, their religion, their stability. In my view, U.S. policy's got to counter that perception, but for the most part, is failing to do so. So what more is needed? There's clear evidence from empirical studies that more religious freedom not only means more human rights, which of course is the core of what we're talking about, but also more practical, real-world benefits for any society. For example, religious freedom undermines religion-based terrorism and violence. It contributes to economic growth. Over time, it can lead to more social and political stability and benefit the majority religion as well as the minorities. America itself has experienced these benefits. Our founders saw the protection of religion and its free exercise, both privately and in public life, as an inalienable right given by God to every human being. James Madison wrote that every human conscience has the duty and therefore the right to seek uncoerced the truth about God. Our founders believed that religious freedom must never be denied to anyone, especially by government with its extraordinary powers. They knew that governments exercising their power in this way are on a path to authoritarianism and worse. Protecting the right of religious freedom for everyone also yielded many practical benefits for America, many of them contributions to economic growth through religiously motivated hard work and entrepreneurial energy, the strengthening of our national unity by immigrants from every faith, every ethnicity, every race, the most dynamic and compassionate civil society in the history of mankind, the establishment of religious schools and educational norms that compete with and strengthen our failing system of public education. The practical benefits of free exercise of religion are many in this great country. Now, America's diplomats are experts in the history, politics, and interests of the societies where they're posted. They should also be experts in providing evidence of the practical benefits of religious freedom, fashioned to their respective societies, culture, and as appropriate drawing on the American experience. Some of our ambassadors and diplomats have indeed engaged in this kind of diplomacy, and U.S. civil society groups inspired by IRFA, like the Religious Freedom Institute and Alliance Defending Freedom, have provided to other nations evidence of religious freedom's practical benefits for them. The U.S. diplomatic establishment as a whole, I'm sorry to say, resists this approach. But the United States can't advance religious freedom on the ground if our diplomatic culture is skeptical about the validity of this right and its capacious benefits for human and social flourishing and well-being. Success requires consistency, confidence, and a sense of urgency, supported by all of our foreign affairs agencies, not just Foggy Bottom, but USAID, DOD, the White House, and the National Security Council. Unfortunately, such a commitment is at present, in my view, highly unlikely. The root of the problem showed itself in the late 1990s with that State Department claim that IRFA is contrary to American interests because it implements an illegitimate hierarchy of human rights. This idea not only meant the rejection of the American understanding of religious freedom as an inalienable right. It also signaled a growing skepticism about religion itself, especially traditional religion, and its public exercise. Many diplomats believed then, and they still do, that the First Amendment conveys only a right to worship and separates religion from public life. That's both mistaken and harmful to IRF policy. Religious freedom in America exists because public religion is important to America. That's why religious freedom has never been merely a right to private worship. As I've noted, the founders guaranteed the right of free exercise of religion in private and in public. They understood this right not as perched on top of a hierarchy that diminished other rights, but their most secure guardian. That view was commonplace in America for 2 centuries. We can even see it in President Clinton's remarkable 1993 remarks when he signed the Religious Freedom Restoration Act. I understand Greg mentioned this morning. I'm going to quote from the president's remarks. Our founders cared a lot about religion. If you've heard this, memorize it, if you've heard it before. Clinton, our founders cared a lot about religion. They knew that religion helps to give our people the character without which a democracy cannot survive. They knew that there needed to be a space of freedom between government and people of faith that otherwise government might usurp. It's high time, he said, we had an open and honest reaffirmation of the role of American citizens of faith, not so that we can agree, but so that we can argue and discourse and seek the truth and seek to heal this troubled land, unquote. This vigorous endorsement of religion reflected the traditional view of free exercise as a public right, a limit on the power of government, and an agent of character and virtue. With the founders, Clinton was declaring that free exercise encourages a search for truth that can unify and heal. Those views were, to say the least, inconsistent with the hierarchy claim that religious freedom threatens human rights and doesn't warrant a law requiring its advocacy in U.S. diplomacy. Unfortunately, the hierarchy claim has now sunk its roots even deeper into U.S. diplomatic thinking. In a 2021 speech, Secretary of State Blinken employed that claim to reject, officially on behalf of this administration, a report commissioned by his predecessor, Secretary Pompeo, that called for a return to the principle of inalienable rights in U.S. foreign policy. Here's how Secretary Blinken rejected inalienable rights, and I quote, "All people are entitled to human rights, no matter where they're born, what they believe, whom they love, or any other characteristic. All human rights are co-equal. There is no hierarchy that makes some rights more important than others," unquote. But if inalienable rights do not exist, and all human rights are co-equal, then those with political power can simply manufacture their own rights and coerce others to affirm them. That is the path taken by authoritarian regimes, and unfortunately, it's also the path taken by the current administration. It has concluded that if religious freedom means the rejection of what it asserts to be LGBT rights, then religious freedom must be suppressed at home and abroad. And that suppression is well underway. At home, the so-called Equality Act would punish those who publicly embrace the sanctity of human life, marriage, and immutable male-female distinctions. Stunningly, that law, the Equality Act, would also deny these people the protections of the Religious Freedom Restoration Act. In its foreign policy, the administration is threatening the withdrawal of U.S. aid to societies that do not accept its regime of newly constructed human rights. Thus, are IRFRA's goals undermined. The objection to religious freedom in the hierarchy argument, hardened by the official U.S. abandonment of inalienable rights, certainly helps to explain why our IRF policy, despite the hard work of its advocates, has not succeeded in advancing religious freedom on the ground. It's hard to sell a product in which you do not believe. Tragically, in my view, Americans no longer agree on what it means to be human, or on what human beings need to be happy, to be equal, to be virtuous, to be free. But happily, many Americans continue to embrace the founding, the founding claim that every human is created by God, and for that reason is a seeker of truth and a bearer of rights that must not be alienated by government, especially the inalienable right of religious freedom. No U.S. administration should arrogate to itself the authority or the power to punish those who continue to embrace that claim, either at home or abroad. To do so is not only to undermine the promise of IRFA and its benefits to our nation and the world, it is also to repudiate what is arguably America's most valuable gift to the world, the truth claim that religious freedom for everyone is necessary for everyone. Conveying that truth in our foreign policy is a goal worthy of our nation and the world of which we are a part. Thank you.
Thank you. This is a great opportunity for me. I'm Susan Yoshihara, President and founder of the American Council on Women, Peace, and Security. And it is my honor to moderate this rockstar panel. So the first thing I'm going to do is introduce them quickly, and then we're going to move on to their talk. I'm going to introduce ladies first. Nadine Manza is the president of International Religious Freedom Secretariat and former chair of USERF. And I was watching one of your videos talk about that, about women. I think that was a really important panel that you had. Next to her, Nathaniel Hurd, whom I know from my days working in the pro-life field. He is now North America Director and Senior Fellow for Public Policy at the Religious Freedom Institute. Knox and I just met. Knox Thames is Pepperdine University's Senior Fellow, and he's directing a new program on global faith and inclusive societies here in the Washington, D.C. campus. So you wonder why, as a women, peace, and security expert here at a religious freedom conference, and I want to thank Eric for inviting me just to give a brief pitch. Religious freedom and women, peace, and security have a lot in common. They're both laws. Women, Peace, and Security Act of 2017 is implemented by DOD, state, USAID, and DHS. And the purpose is very similar to IRFA because it is about protecting rights and is about finding peace and stability in other countries, which is obviously a national security interest. And three reasons I think that we need to start merging our efforts and to catalyze one another and maybe to be more fulfilled, as Tom Farr talked about. And one is that we find that persecuted women have a double persecution. If you look at Uyghur women, Yazidi women, Catholic nuns killed in Yemen, they're killed because they're women and they're killed because of their faith. And so I think it's time we understand the nexus of that, really, in reality, right? We could help one another. The second reason is because, little known fact in WPS, most of the peace builders in WPS, our champions, are women of faith. You look at Lema Bowie in 2011, bringing peace, helping to bring peace in Liberia, obviously a lot to do with her faith. And I think we need to spend more time talking about faith in WPS. And finally, it's international. 105 nations have WPS action plans, 10 national UN Security Council resolutions, and as you all know well, this is about engaging on the ground with our partners and it's about understanding context and working with local partners. And I think that we need a lot more understanding of religious freedom in WPS, and I think that WPS has a lot to offer religious freedom as well. So we are starting on the other end, and we're going to go in order. Please, if you have a question at the end, make it a question and come up to one of the microphones and make it brief enough that everybody has a chance to ask questions from our august panel. Over to you, Nathaniel.
Thanks, Susan. The executive branch has an addiction problem. It's a bipartisan addiction problem. For 25 years, presidents from both parties have abused the waiver authority that IRFA gave to them. I'll unpack this as I speak, but in short, IRFA requires the president to take action against countries after they have been designated as countries of particular concern. And for 25 years, presidents of both political parties have abused that waiver authority. As Tom mentioned just a moment ago, sanctions alone are insufficient, but they are essential. And they are essential for us to make a determination about whether the act, the IRFA Act, has been effective. On the broader topic of waivers, IRFA does not grant the executive branch, it does not grant the president waivers in making determinations and designations related to countries of particular concern. The law requires that the president makes determinations based solely on the facts of whether, and this is the law of the statute, the government of that country has engaged in or tolerated particularly severe violations of religious freedom over the past year. This term, particularly severe violations of religious freedom, it's throughout the Act, and I think it's worth unpacking that. So again, back to the language of the statute. IRFA defines a particularly severe violation of religious freedom as systematic, ongoing, egregious violations of religious freedom, including violations such as torture, or cruel, inhuman, or degrading treatment or punishment, prolonged detention without charges, causing the disappearance of persons by the abduction or clandestine detention of those persons, or other flagrant denial of the right to life, liberty, or the security of persons. We're really talking about the worst of the worst violations. When the president, who has always throughout the history of IRFA delegated this authority down to the Secretary of State, but the language of the statute is the president, so you'll hear me continuing to refer to the president. When the president designates a country as a CPC, IRFA requires the president to take one of 15 actions that are laid out in the statute or commensurate action, and to impose visa penalties, visa sanctions on the government officials that have perpetrated these violations and their family members. Think of this section of IRFA as the do something section. Do something, anything, but do something. So these presidential actions range from a private démarche, and I'll say a bit more about that in just a second, all the way up to prohibiting, this is the words of the statute, prohibiting the United States government from procuring or entering into any contract for the procurement of any goods or services from the foreign government entities or officials found or determined by the president to be responsible for violations. So going back to the sort of the bottom end of the spectrum here, the least that an administration can do, a private démarche, what exactly does that mean? So according to the Foreign Service Manual, this is a quote, "A démarche is a formal diplomatic representation of one government's official position, views, or wishes on a given subject to an appropriate official in another government or international organization. Démarches generally seek to persuade, inform, or gather information from a foreign government. Governments may also use a démarche to protest or object to actions by a foreign government, end quote. Now, the act does include waiver authority, and there are 4 reasons that the president can give in waiving these otherwise required presidential actions. The first is national interest. The second is to further the purposes of IRFA. So a practical example would be if the president observes that a government is making progress in the area of curbing religious freedom violations, then the administration can waive sanctions. The president can waive sanctions after the United States enters into a binding agreement with the foreign government, or the president can refer to existing sanctions. So under some other statute or authority, if the United States has imposed sanctions on this country, the president does have the latitude to say, well, we already have sanctions imposed on this country. We're not going to double up, double dip, if you will. So since 1999, when the first CPC designations were made, all the way up through 2022, the CPC designation has been applied 145 times against 17 countries, 145 times against 17 countries. And I'll quickly go through the list. So Burma, since 1999, China, since 1999, Cuba in 2022, Eritrea from 2004 through 2022, Iran since 99, Iraq in 2001 and 2003, Nicaragua, which Congressman Wolf referred to earlier this past year, Nigeria once in 2020, but it then was taken off, North Korea since 01, Pakistan since 18, Russia since 21, Saudi Arabia since 04, Sudan, 1999 through 2018, Turkmenistan in Central Asia since 2014, Uzbekistan 2006 through 2017, and then Vietnam through 2004 through 2006. So of those 145 times against 17 countries, the president has applied new sanctions against only 1 country, and it was 3 times. It was Eritrea in 2004, 2005, and 2006. New sanctions against 1 CPC 3 times. Not even a private démarche, so just a private objection or raising of concern that no one else knows about, or some kind of commensurate action. The bottom line is that by applying the waiver, almost without exception, the executive branch has fundamentally undermined and undercut the effectiveness of IRFA, and it undercuts our diplomacy that is being done by to advance religious freedom. If a country, whether it's Saudi Arabia or any other country, if we're not even willing to privately engage with them about this as a private démarche, the message is very clear. We don't care. We do not care. The message is very, very clear. The problem has been so bad that in 2016, when the Frank Wolf International Religious Freedom Act, sponsored by Congressman Chris Smith, was passed, it included a sense of Congress. And the sense of Congress said this: it is the sense of Congress that ongoing and persistent waivers for any country designated as a country of particular concern for religious freedom, for engaging in or tolerating particularly severe violations of religious freedom, do not fulfill the purposes of this act. That's how seriously Congress has taken this problem. So I want to close with some recommendations. I have some recommendations for Congress and also some recommendations for the President and the executive branch. The first recommendation for Congress is a Government Accountability Office, so GAO, audit of the implementation of IRFA, focusing particularly on the application of waivers. A GAO audit, a good GAO audit, should always include extensive consultation with civic groups, with civil society groups, not just with the executive branch. And it should also ascertain which parts of the executive branch have been driving this relentless application of waivers. When you look at an agency like the State Department, for example, the Office of International Religious Freedom, which does heroic work under very difficult circumstances, simply does not have the power and the clout and the heft that, for example, the regional bureaus do within the State Department. So the question is, where exactly, if we look over time, where is the push, where is the drive for the application of these waivers coming from? Is it coming from the regional bureaus? Is it coming from the National Security Council? Where exactly is it coming from? And I think a GAO audit could help uncover some of that. Nina earlier alluded to the history of the development of IRFA and this debate and discussion about whether to require sanctions without waiver authority. They ultimately decided not to because, as she noted, there was a concern about the fudging of the reporting. I think given the history that I've just laid out, the time has come for Congress to reduce and consider eliminating the waiver authority that it initially gave to the executive branch, obviously consistent with the Constitution, separation of powers, and statutory precedent. Congress should also conduct full public oversight until and unless we're at a point where waiver authority is eliminated. Congress should conduct full public oversight whenever the executive branch exercises its waiver authority in the application of IRFA. This is not something that should just be seen by committee staff. This is not something that should be seen in the shadows. It's something that should be out there in the light, in public hearings, and Congress needs to bring to bear all of its awesome oversight authority to bear. A last recommendation for Congress. The IRFA statute it's comprehensive, but there is also latitude for legislation that complements IRFA but doesn't amend IRFA. And I'll give you a practical example. I spent about 7 years as a staffer at the U.S. Helsinki Commission, the Commission for Security and Cooperation in Europe. I was a professional staffer there, nonpartisan professional staffer. And there was a problem that arose that IRFA just did not seem to have anticipated. And it was embodied in Ukraine. You could argue Georgia earlier, but certainly in Ukraine. IRFA only authorizes the president to consider religious freedom violations within the borders of a country for which a government is responsible. In other words, its own country. So in looking at Russia, it only authorizes the president to consider religious freedom violations within Russia itself. Where here you had a situation in which Russia had invaded another country, a sovereign country. Religious freedom violations were being perpetrated by Russian troops in some areas. This is prior to the second invasion of Ukraine. But it was also responsible in areas that Russia was either occupying, so Crimea, or controlling through proxies under binding international law, the Geneva Conventions and beyond. It was also responsible for religious freedom violations there. And so the Ukraine Religious Freedom Support Act would have explicitly authorized and required the president to consider violations in areas of Ukraine that Russia was responsible for in making that determination. These violations were happening. Clearly, the territory was not in control of the government of Ukraine. Clearly, the Russian government was responsible. So there was a piece of legislation. It did not amend the underlying statute, but it came alongside and was complementary to it. The recommendations for the president and the executive branch recognize that you have an addiction and then take steps to address it. There's nothing inevitable about these application of waivers. And I think the administration, any administration, needs to recognize that this is a problem. It has fundamentally undermined our efforts to advance religious freedom around the world. If there are particular parts of the executive branch that have been driving this, curb it. If it's this office or this bureau or this department, make sure that you're addressing that. And then on a regular basis, remind the offices that are involved in determinations, designations, et cetera, what the law requires and what the law intends, so that the executive branch is fulfilling both the law, the letter and the spirit of the International Religious Freedom Act. Thank you.
Wow, that was terrific. Thank you. Really gives me a lot to build on. First, I want to thank Religious Freedom Institute, Eric, Dr. Farr, the whole team for putting this day together. Such an important discussion. I'm really excited to hear all the other remarks, and thanks to the panelists and moderator for being a part of this today. As you've already heard, we've all agreed that IRFA has been a huge benefit for U.S. foreign policy, especially important with the creation, of course, of the State Department's Office of International Religious Freedom and USCIRF, where I was able to serve for 2 terms, ending my last year as chair. But even during my last year, 4 years, during the 4 years at USCIRF, I did see religious freedom continue to be elevated in our foreign policy and in the State Department. When I first joined in 2018, I remember the religious freedom file was always given to the lowest level person in each of the embassies, either abroad or here in the U.S. In fact, I remember one foreign service officer in one country asking us what a Baha'i was in a country where Baha'is were banned. But during those 4 years, I saw that file move up to the point that usually it was a middle to higher level person that was handling the religious freedom file. And even one ambassador to the U.S. was telling me the story how it used to be the lowest or the newest person in his office, and now he holds the file for religious freedom himself. So there has been, an elevating of foreign policy, and certainly it started, with the ACT, but it has continued. I find the exception to be during the most important U.S. foreign policy decisions, often those including war and religious and ethnic conflict. And so first, thank you for that framing on the CPCs. That really does help put this in context. But I did want to just note that it's important to acknowledge that religious freedom conditions globally are continuing to deteriorate. The last 5 years, reports from USCIRF have showed worsening conditions each year. And this past year, both USCIRF and the International Religious Freedom Report also, both rollouts confirm that a troubling trajectory. And it's also worth noting that while the US and Europe seem to be becoming less religious, according to the Pew Research Center that I know have been quoted a few times, the Middle East and Africa are becoming more religious. And they also have higher birth rates than less religious countries. So religion is going to continue to matter and must be understood carefully while determining the best way forward for US foreign policy. So in my interaction with the State Department, folks, even ones that are very well-versed on religious freedom to those that aren't, most would agree with this statement: religious freedom is necessary for a lasting peace. If true, a couple of facts must be acknowledged and challenged. First, why is religious freedom so often missing from the important foreign policy discussions at the highest levels? The impact of policy on religious freedom conditions and religious freedom minority communities is still often siloed from foreign policy decisions. It's kind of a separate discussion at the kids' table. So how do we get religious freedom at the grown-up table? Second, U.S. foreign policy is often looking for a short-term win, especially in a presidential cycle. And of course, we know Iran, China, Russia, all these other countries have these 25+ year plans, and we're like 2 years, 2 years, 2 years, 2 years. How can we better prioritize the long-term view of foreign policy decisions and their impact on peace and stability? And third, in diplomacy, the priority seems to be, or often seems to be, keeping nation states happy over policies that could actually lead to a lasting peace. Think Turkey and NATO. Again, how can we emphasize the lasting consequences of foreign policy decisions over the short-term wins? So I'm going to give you some examples. China was on the cover of USURF's very first annual report in 1999, and as you heard, has been on the CPC list. Yet there was this belief that if the US and the international community helped them become more economically prosperous, they would become better at human rights and religious freedom. Obviously, that was not the case. What if instead we had linked our support to improving conditions for religious communities? How many missed opportunities were there that led to the current situation with maybe up to 3 million Uyghurs being in concentration camps and pretty much every religious community being oppressed? In Nigeria, as you heard, the administration refuses to acknowledge religion plays a role in the horrific violence that's going on there. And of course, the Lasas administration took them off the CPC list. Of course, ethnicity and religion are often intermixed. These are very complicated situations, very complex. But taking actions that improve religious freedom conditions, regardless of why you think there's instability and conflict, is always a good thing. To exclude religious freedom from the discussions is irrational if the goal is a lasting peace. In India, we are seeing deteriorating human rights conditions that UN Special Rapporteur on Minority Issues, Fernand de Vorenez, said was massive, systematic, and dangerous during the USURF hearing last week on advancing religious freedom within the US-India bilateral relationship. He said, quote, "India risks becoming one of the world's main generators of instability, atrocities, and violence because of the massive scale of gravity and the violations and abuses targeting mainly religious and other minorities such as Muslims, Christians, Sikhs, and others. It's not just individual or local, it is systematic and a reflection of religious nationalism." It's impossible to continue to ignore the escalating violence in India and what that means for the country and for the region. Is an economic agreement and an elaborate state visit appropriate with these horrific conditions? How long does the administration ignore the religious freedom violations as Genocide Watch and the Holocaust Museum's Early Warning Project raised the alarm? In Syria, because religious freedom was not at the table, while major foreign policy decisions were being made at the start of the civil war, the US supported the Syrian opposition that ended up being Turkish-led with Islamists on the ground in northern Syria, committing horrific crimes against religious minority communities, as confirmed in reports by the United Nations, Human Rights Watch, Amnesty, and lots of others. Some of the Islamist militias have even been sanctioned by the US government over the past few years. This is a complete disconnect with the Syrian opposition leadership in the US and globally, who are often exceptional people forced into this pipeline as it was the only US-approved opposition to Assad. So many of them and their families were the victims of Assad's unbelievable violence against his own people. So we failed them. Had the bar been set with religious freedom being a necessary outcome, things on the ground perhaps would not have moved so far away from where they started. Then the Syrian opposition could have been a legitimate alternative to Assad. USURF has made recommendations to the US government to support religious freedom in northeast Syria, where the autonomous administration in northeast Syria has created these exceptional conditions with religious freedom. While many are familiar with the Syrian Democratic Forces defeating the ISIS caliphate, most are not aware how they filled really those governance and security voids that were created with governance that the local people actually set up and run that includes all religions and ethnicities, with half the leaders being women. How is this not ever included in discussions on Syria, even a part of US policy for a future Syria? It's almost like 1/3 of Syria is invisible because a priority is keeping a nation state happy that borders Syria, which of course is the opposite of a policy that could bring a lasting peace. And by the way, Syria is not designated as a CPC on the special watch list. As you heard, Nigeria, Afghanistan, India, and USURF recommends all of those. But as you heard, we do need to acknowledge the US government did put Cuba, Nicaragua, CAR, and Vietnam on the CPC list last year, which was significant. And as we've talked about a lot today, that I'm going to add on is the waivers for CPC. One of the key parts of IRFA is these having some sort of punitive sanctions when you are a country of particular concern. And I'm not going to read them because you did such a nice job with that. So we talked about the countries that don't have them and how I love that addiction. I was saying that's one of the rare bipartisan agreements is to give violators a pass on religious freedom, but being addicted, I love that too. It's makes that same case. So, so with religious freedom conditions continuing to deteriorate globally, we have to admit that the old way of doing things is simply not enough. So while these are not failings of IRFA, they are, like Dr. Farr had said, really the unfulfilled IRFA, the lack of implementing IRFA effectively. And I'd also like to note that the IRFA office, along with the U.S. Ambassador at Large for International Religious Freedom, have been excellent advocates, as you heard, over the last couple decades, for these things. And even the examples I mentioned, they were often not included in those conversations, or if they were, they weren't listened to. So I want to make that clear. So here are some of my recommendations, but I loved all of yours, so we should have a list of all these recommendations. First, the administration should follow their own commitment to put human rights at the center of foreign policy by making sure religious freedom is a part of every important foreign policy decision. That alone would take care of a lot of the examples that I shared. Second, the president should appoint the special advisor that is on the international religious freedom, that's on the NSC, that was also created at the time of USIRF and the Office of International Religious Freedom. Of course, President Trump had an advisor for a few years, but we haven't seen that position filled. And binding agreements, as you mentioned, are listed as appropriate for CPC countries, but are pretty much never used. IRFA says, when appropriate, make every reasonable effort to conclude a binding agreement concerning the cessation of such violations in countries with which the United States has diplomatic relations. So imagine if we had binding agreements with all these CPC countries. Imagine Pakistan, Saudi Arabia, Tajikistan, what this would mean. And also, I think having a waiver gives the president a pass that he may not even want to take. Because what do you do? Like, no one else is going to get sanctions by giving them to you because I hate you more than the rest? He's not going to do that. So in some respects, he's never going to do it unless he has to, because then it's like, not my fault. So in some respects, Congress passing a bill like this might get signed, and it might make it so the president doesn't have to be the bad guy, because remember, diplomacy is about keeping nation states happy, so they don't fit together very well. I would say prioritize cooperative engagement with foreign governments to improve conditions when willing, as positive incentives are always better than the negative ones. I use the example of Uzbekistan and Kazakhstan, and I know these are countries that have been imperfect, but Uzbekistan was boiling people in oil when I came to USIRF. So they've had tremendous advances, although there still are significant challenges. But they engaged in a roadmap process, where the State Department would host with them, with civil society, USIRF, and everyone came, and the UN Rapporteur on Religious Freedom, and put together actions with a timeline. And that way of approaching how to improve your conditions, imagine if we did that with Pakistan, what that could look like with the blasphemy laws, the apostasy laws. So in using those tools, like with India, what if we went to India and said, listen, we have to designate you as a CPC because, frankly, you fit the CPC, but we would rather do a roadmap with you. And I like the idea of what Frank Wolf had said about 3 years being a CPC and there's a binding agreement, because then everyone has an incentive to do a roadmap to get off the CPC list, because then they're going to get sanctions. So some of these kind of ways of making it so you're not trying to make the president be the bad guy, because it doesn't matter if you're a Republican or a Democrat, none of them are going to do that unless we make them. And lastly, the U.S. should be empowering and working strategically with civil society, which can do things, frankly, they cannot do. As many of you in the room are part of civil society. And like I mentioned, being a part of these roadmaps with countries, and also, encouraging organizations. I know Institute for Global Engagement we've worked with have been on the ground with some of these countries working in cooperative engagement. It's been super effective. And, of course, part of the reason I joined IRF Secretariat was because the effectiveness that I saw of the IRF roundtables on the ground in countries globally when I traveled, and, encouraging that kind of work. I know that Ambassador Sam Brownback, was as a U.S. government official, so key in empowering civil society to come to the table, to meet every week as part of the IRF Roundtable, to work together with government to improve policies for the U.S. government, to raise issues happening with other governments, to put pressure where pressure was needed, and to continue to do that. We appreciate Rashad Hussain continuing to engage with IRF Roundtable and encourage civil society as well. So in closing, I think IRFA has been a huge benefit in many ways, but needs to be implemented more effectively, or as Dr. Farr had said as well. And of course, if religious freedom is necessary for a lasting peace, then it needs to be at the table, and we need to be considering the impact of all U.S. foreign policy decisions on that. So thanks so much.
We're in a fight. We're in a fight for freedom, a contest of ideas around the right of individuals to form their own ideas, their own convictions. The United States has been in this battle for 25 years, advocating for religious freedom for all. It's a distinctive about who we are as a people and a great reflection of our values. And I'm proud of that as an American. I think we should all be very proud of that. And I've been proud to represent our country in this work. However, not enough countries share this commitment, and we know that so many more are actively opposed to it. But today we should honor those who did the hard work, the miraculous work of bringing IRFA about. We should celebrate what's been accomplished. The act is truly remarkable, and I think this room is remarkable, seeing people of different backgrounds, political persuasions, religious beliefs join together in joint advocacy. Of course, there'll be disagreements at times over tactics and areas of emphasis, but with a family as diverse as this, that's to be expected. But we should also remember that rooms like this aren't normal, especially in our fracturing times. This is encouraging, so we should celebrate what's been accomplished and the men and women it has saved. But we also have to look forward, continually striving to regenerate, innovate, and advocate. And I think those should be the priorities for the next 25 years, as we can't rely on mechanisms created in the last century to meet 21st century persecution. So we must continually recommit to promoting this right for all, and remember the bright spots over the past decades and learn the lessons that they provide, but also continuing to look ahead. There are steps that people and governments of goodwill can take to ensure lasting impact. We need not give up and walk away because of the enormity of the challenge, nor should we tear up the entire system. Modest fixes combined with a recommitment to consequential diplomacy can reinvigorate global efforts. So first, regenerate. We must continually reinforce and renew mechanisms created decades ago. We must continue to shine a light on abuses. The tried and true approach of naming and shaming can work. And while it's important, we also need to know that just describing the problems through reports and blacklists will not be enough alone. They won't turn the tide by themselves. So we need to actively engage persecution by bringing the full force and influence of the United States to bear, along with our partners, to spur positive change. It can work. I've seen it work. But the problem, as Nathaniel referenced, is we just don't do it enough. We don't use these tools enough. But we also need to regenerate bipartisan support. IRFA's passage was a tremendous success, enjoying near unanimous support from both parties, initiatives led by Republicans and signed into law by a Democratic president. Yet we know that such political backing is a shadow of what existed in 1998. The horrors of ISIS momentarily brought the issue back to the forefront, but a sustained effort needs sustained support. We can't wait for a crisis to spur political interest, so it's incumbent upon us, the voters, to let our elected officials know that promoting religious freedom for everyone matters. And with elections on the horizons here, I would also say we need to refrain from pulling our domestic partisan debates about religious liberty into the international effort. We must zealously guard the international work, which is often life and death, from our increasingly heated debates at home. Of course, we've got to sort through these challenging domestic issues that reflect our diverse society, but there are generally higher-level discussions about the finer points of individual liberties balanced against competing civil rights. I remember I was just writing about the torching of 20 churches in Pakistan and the destruction of 15 Ahmadi Muslim places of worship. We've got to guard the distinction between the domestic and the international, and I think that can help regenerate bipartisan support. Next, innovate. We've got to modernize our approach. Religious persecution may be as old as human history, but modern tools of oppression require new thinking. So while we continue to fully use the tools created in the 20th century, it's essential that we develop new approaches for the 21st century. The perpetrators of religious persecution do not rest, and neither should we. Now, many have grown frustrated, including myself, with the inability or unwillingness of policymakers to levy religious freedom sanctions on governments. I thought it was really interesting to see the rapidity of sanctions placed on Russia before and after the invasion of Ukraine, and it shows what's possible when there's political will. And so if we take our values seriously, if the words of IRFA truly mean what they say, then consequences must flow when violations occur. Otherwise, we undermine our credibility and we destroy deterrence. Certainly, some persecutors may price in sanctions into their policy calculations, but other nations will take note. China watchers are certain that Beijing is paying close attention to how the West responded to Russia's invasion. And so consistently backing up our concerns with actions can create deterrence for would-be abusers. It's preventative. But I know that nothing less than actions will convince persecutors. Rhetoric alone will not work. And I think this is where the Global Magnitsky Act has been such a breakthrough in this regard, giving the United States a scalpel to target individual foreign officials to freeze their bank accounts. And even when the sanctions can't touch the individual, the second and third tier impacts can ricochet through financial systems, hurting their cronies and supporters, while avoiding broader collateral damage. I've heard how people in China have actually avoided an act of persecution because they didn't want to be on this list. That's power, that's deterrence. So we need more ideas like this. I was recently in London with my family, and we were touring Westminster Abbey, that beautiful cathedral, that place of Christian worship for 1,000 years or more. The cathedral, if you've been through it, you see graves of eminent scholars, poets, leaders, and scientists. And of course, while looking up at the beauty of it, I happened to look down right before I stepped on the grave of the British physicist, Sir Ernest Rutherford. Now, I'm actually a fan of Sir Ernest because he was leading the charge to split the atom. And he had this famous quote, which I think applies to us. He challenged his scientists by saying, "We haven't got the money, so we've got to think. We haven't got the money, so we have to think." The oppressors have more resources than we do, so we have to think. We've got to innovate. We've got to come up with the new tools that can meet this challenge. And lastly, we've got to advocate. We've got to speak out. We've got to shine a light. We must press for change when individuals face persecution because of their religion or belief. The United States, and frankly every nation, should forthrightly voice concerns to friend and foe alike. Now, these engagements will look different between allies and adversaries, but a steadfast and consistent message of religious freedom should be a guiding star and can be a guiding star in these turbulent times. In other words, holistically promoting religious freedom abroad and defending the persecuted reflects the best of our values and is in our hardcore national security interests. Too often, as I know from working inside the State Department, other priorities will distract policymakers, resulting in religious freedom dropping down the priority list. The tyranny of the urgent can actually prevent the United States from responding to actual tyranny. So our advocacy must also be pointed at our own officials, continuing to insist that we maintain our prominent voice, advocacy at home and abroad. So in conclusion, people of goodwill everywhere and anywhere can help. But we also know the United States cannot and should not do this alone. There's a limit to U.S. power and influence, and this is where joint advocacy can be such a force multiplier, sharing resource burdens and combining political capital. Collective advocacy, highlighting abusive governments from nations that cross religious, political, and geographic differences can be uniquely powerful. Likewise, civil society organizations and religious groups advocating for religious freedom for all can make a difference, like with the IRF Secretariat. Of course, while it's natural and good to advocate for your own, if you don't, who will? We know that the most stable future for persecuted co-religionists occur when everyone can enjoy freedom of thought, conscience, religion, and belief, and that's got to be the goal. So together we can be a force for positive change. We know the world can become a better place when we embrace religious diversity and protect the rights of all. And so while we celebrate the past quarter century, we must not let our self-applause trick us into believing the battle has been won. It continues. Millions of people suffer right now around the world for their beliefs. So what we do matters. What we do next matters. The The United States must continue to lead because we are the indispensable nation in the fight for human rights. But in doing this, we should remember those who have paid a much higher price than any of us hopefully ever will, and have it inspire us to redouble our efforts. Thank you.
Well done. You kept us on time. We've got 10 minutes left for questions. So if you have a question, there is a microphone with your name on it. Do we know where there are the microphones right there? And I'm not even going to take moderator's prerogative because I know we have questions for this group. All right. Please. Anyone? Yep, over here.
Testing? Okay. I'm Nathaniel Krennick, intern at Family Research Council. So I had a question sort of about like optics or tactical approach, as kind of was mentioned earlier. So regarding, I suppose, a very nuanced, specific case, like if we're regarding the Saudis, so say like an example, I think this was several years ago, Sheikh Nimr al-Nimr, it was like a Shiite cleric, and essentially was beheaded by Saudi authorities, as were, I think, many of his followers. Alleged to be a peaceful activist, but the Iranians clearly were took a lot of stake in this, and could accuse the Saudis of civil rights abuses and whatnot. But so what my question is regarding is, just the approach in which, how do you deal with one country without totally giving way to another or upsetting them, and in a diplomatic measure taken against that country? How do you I suppose have priorities, right? And so
Very good. Yep.
Yeah.
How do you have priorities? And do you have that? Do you want anyone in mind, or anyone want to take that question? Nadine.
I guess that goes to the point of I was making. Is what's our goal? Is our goal a lasting peace? Is our goal peace in the Middle East, or our goal is just keeping everyone happy? For the longest time, the policy in Syria was de-escalate, enduring defeat of ISIS, and humanitarian goods. Well, that's not policy, that's tactics. Because it's almost like trying to keep everyone happy, but never creating an environment where there can be a lasting peace. That just means everyone will be quiet. You've kept everyone happy long enough to hand it to the next president, the next administration, who's still going to have the same walking on eggshells. And I think we need some leadership, but I think we need to empower the administration, whichever Republican or Democrat. Like you said, this is bipartisan in terms of having these kind of issues, with laws that make it easier for them to stand up to countries, so they just don't look like the bad guy. Because right now they look like the bad guy. If they're going to take on Saudi after not taking Saudi on for all these years, then they're going to probably cut off communication with our administration, and now we've got a problem. So yeah, I think we need to have tougher laws so that our administration is forced to take actions against them in those situations. And yeah, it is complicated. I mean, whenever we're dealing with Shias in the Middle East, you always are they representing Iran? And so you have to think through that. So I'd really have to be specific on that situation. But I do think we need to be looking at these things differently. We need to empower the government to be able to be stronger without having to be blamed for it.
One other thing I would just add is that on the question of upsetting, there are country-to-country relationships, but then there are also personal relationships. And I think one of the biggest challenges, Tom mentioned earlier, some of the challenges for the diplomatic corps is that you're a diplomat, you engage with your interlocutors from another country, you develop relationships with them, and look, no one wants to be disliked. We all have this very human compulsion to be liked, to be affirmed, to be respected. But at the end of the day, if you were to ask, before they become diplomats, if you ask most people who enter into the Foreign Service, why did you become a diplomat? The answer is not, so I can avoid upsetting people. The bottom line for members of the Foreign Service, as well as other people that are representing the United States abroad, is what are America's interests? and somewhat expansively and broadly defined, and what is the foreign policy of the current administration, and reference to the Constitution. There are a lot of factors that go into this. But at the end of the day, that has to be the driver, and there are going to be times where we have to make policy decisions that may upset one's interlocutors or may upset another country, but there are overriding interests at stake there.
I would just add, I think the United States, we're the world's largest economy, we're the world's strongest military, and we use our leverage very poorly. So the question was, would this upset them? I think really the question should be, wouldn't they be worried that it upsets us? And if our values were really, truly integrated into our foreign policy, then there'd be consequences for when partners upset us. And I think this goes across administrations. We don't leverage our influence effectively, especially on our values, and it's a detriment to our credibility.
Excellent. We have time for one more question. Yes, ma'am. There's a microphone here.
Hi, my name is Avery Bolsowitz, and I work for the Beckett Fund. A main question that I have is that American domestic affairs has kind of become a Tower of Babel, where it's not just we're unwilling to hear each other out, it seems like we no longer understand one another. So how do you guys propose that we can both come together and not be separated by an aisle, but we can be centralized under one central point on foreign policy?
Okay, she threw you a softball right there at the end. Who wants to take this one on?
I've written about this issue where I think looking to focus on violent persecution abroad can be a rallying point. I wrote an article for USA Today about when I was at the State Department, I would see very similar situations for Christian converts, atheists, and members of the LGBT community in the Middle East. And those are three communities that do not interact. Their advocates do not interact. And here in the US, they're often opposed to each other. But the drivers of persecution for each of those communities are basically the same kind of mentality, legal, social. And could that be a starting point to at least build a common approach based on human dignity? We don't have to agree on everything, but we can agree that people shouldn't be jailed or murdered for what they believe or how they love. Could that be a starting point that could then reverberate back to our domestic debates and maybe lower the temperature a bit?
Yeah, I mean, just extending that a little further and picking up on some of Lewis's comments earlier today. I mean, I think ultimately it's focusing on what makes us human. One of the things that we talk a lot about at the Religious Freedom Institute is that being religious is fundamentally human, the desire. I mean, we have these big existential questions. We look for answers outside of ourselves to some other source for meaning and a path on how to live. So I think keeping the focus on what it is that makes us human, because at the end of the day, I mean, a lot of this, the violence against religious people, violence of other kinds as well, it's wrapped up in dehumanization. It's reducing, it's setting aside the fact that this is a fellow human person with a personality and a story and an inherent human dignity, and reducing them to something else. So I think just really keeping the focus on what is human. But that said, I mean, a lot is made about polarization in the United States and polarization abroad. I'm of the view that to some extent it's overstated in so much as there are certain things that are true, there are certain things that are good, and those are things that are worth fighting for. And when you do that, you're always going to upset people. There are always going to be people that are made angry by that, but it doesn't mean that you shouldn't do that. You should still be pursuing those things, even if there are people that are put off by it.
I was going to say at USURF, it was really I had a wonderful 4 years. Thankfully, the team, Erin was the executive director the whole time, so it was a really wonderful experience. And it really was the most bipartisan place in Congress. And there's a New York Times article, if you haven't read it, that you should Google about Tony Perkins, the president of FRC, and Anarima Bhargava, a George Soros fellow, becoming pretty much best friends. That's fair. And they even went to the border together to see the border crisis. And these are two people you probably would never interact with each other except they were sitting on this USURF, and we had an LGBT report that came through, and that, you know, the two farthest people in the polls kind of got together a weekend and rewrote it. And we were able to get that out. And so I think bringing the people together, it doesn't always have to be to talk about religious freedom. Sometimes our kind of the multi-faith work we do in some of these countries could be something that's not religious related, but then people get to know each other and find out the humanity of each other, and that they don't have horns, and they could actually work together. And so I do think we need a lot more concerted efforts to bring communities together, to know one another, and be able to work together. And that's really what the IRFA roundtables globally are founded on. I mean, we just did one in the World Parliament of Religions in August, and it was so interesting because they do a lot of interfaith work. So you think they'd be used to this, but they weren't used to the multi-faith work, where a Christian spoke a woman from India about the horrific violence in Manipur her own community had experienced. And then at first everyone is like, well, this is happening, and why isn't this in the news? Because of course it's not in the news. And then, you know, a Muslim from Ahmadiyya starts speaking, and then they're standing with the Christian, and afterwards these people that have been doing interfaith work for years come up to me like, what was that? Because now you have all these religions standing for each other, like you mentioned. It's so powerful when one stands for the other, and they're all standing for each other, and getting to know each other and finding out that they all share that same humanity. And then they're a more powerful group when they're advocating together. And so, you know, I certainly think that model in the United States is definitely needed.
I can't think of a better note to end on from that difficult question. This panel certainly did a great job answering it. So please help me to thank this panel and get ready for the next one.
The final session for this afternoon. Why IRFA is vital for the U.S. and for the world. I'm honored to be with these three outstanding panelists today, friends and leaders that I look up to in every aspect of their service. On our panel today, we have Ambassador Sam Brownback. Sam Brownback served us as Ambassador at Large for International Religious Freedom from February 2018 to January 2021. He served as Governor of Kansas from 2011 to 2018. Prior to that, he represented his home state in the United States Senate and the House of Representatives. While a member of the Senate, he worked actively on the issue of religious freedom in multiple countries and was a key sponsor of the International Religious Freedom Act of 1998. Ambassador Brownback supported its enactment, served under its authority, implemented its provisions, and now advocates for its advancement. Ambassador Brownback currently serves as co-chair of the International Religious Freedom Summit and is a senior fellow at Global Christian Relief. Nuri Turkel is an attorney, foreign policy expert, and advocate working in the intersection of law, business, and government and human rights. He formerly served as chair of the U.S. Commission on International Religious Freedom after being appointed as commissioner by Speaker Nancy Pelosi in May of 2020. He has testified before Congress about Uyghur internment camps, and his policy recommendations have been incorporated into related U.S. law and pending bills. As a senior fellow at the Hudson Institute, he works on U.S. foreign policy and national security issues. Turkel was included in Time Magazine's 100 Most Influential People in the World in 2020 and received the inaugural Notre Dame Prize for Religious Liberty in 2021. He holds a JD and MA in International Relations from American University. His memoir, No Escape, The Story of China's Genocide of the Uyghurs, was published in 2022. Kelsey Zorzi serves as Director of Advocacy for Global Religious Freedom with ADF International. She leads efforts to address and counter global persecution against Christians and other religious minorities. Based in Washington, D.C., Kelsey engages with a multinational network of attorneys, government officials, and international bodies to coordinate efforts aimed at challenging legal barriers to religious freedom and reasserting religious freedom as foundational to the international human rights framework. In 2018, she was elected president of the United Nations NGO Committee on Freedom of Religion or Belief. She earned her JD at the George Washington University Law School, where she participated in the GW Oxford International Human Rights Law Forum. Her work has appeared in several publications, including The Washington Post, Wall Street Journal, The Hill, Real Clear Politics. She's admitted to the state bars of New York, New Jersey, and Connecticut. I've asked each panelist to make brief opening remarks, around 3 to 5 minutes each. Let's go to Kelsey Zorzi first. Kelsey, you spent 6.5 years addressing the issue of international religious freedom at the United Nations. One of your first acts when Ambassador Brownback was appointed was to bring him to New York to speak before the UN about strengthening global policy to stop religious persecution and protect the persecuted. In your opening remarks, would you please address how IRFA informed and empowered your work at the UN, and then how it informs your work now addressing religious freedom concerns, mostly in MENA and Asia? Kelsey.
First, I'd just like to say thank you so much to RFI for the invitation and for organizing this really important meeting and discussion on the 25th and 30th anniversaries of IRFA and RFRA. It's an absolute honor and privilege of mine to be on this panel with Ambassador Brownback and Commissioner Turkel, both of whom I so greatly respect, and our work has relied on their offices to such a great extent. As David mentioned, we do a lot of persecution work from the legal side in countries where religious minorities' rights are stripped for various reasons. And a main focus of ours is on violations of the right to choose and change one's religion, violations to do with speaking about sharing one's faith, and violations to worship in community with others. And so our persecution work largely focuses on countries in Africa, the Middle East, and Asia, where some of those violations are the most severe. And the way we do this work is we partner with allies on the ground, and we work in countries where legal remedies are viable. So we really launched that initiative of our global religious freedom litigation and advocacy work focused on severe persecution in 2018, which is the same time that Ambassador Brownback was sworn in. And prior to that, as David mentioned, I was at the United Nations for 6.5 years, also doing religious freedom work there in New York through the Third Committee of the General Assembly. And one thing that I would say really changed in 2018, especially when Ambassador Brownback assumed his role and then later came to the United Nations in the beginning of 2019, is that it was so difficult to get traction at the United Nations on issues related to religious freedom. You would often find that there'd be one country that would maybe say something just as a silo, no one was listening, but most of the time we would approach one country, another country, and they'd say, we'll sign on to that if you find one other. So it was like a chicken or the egg problem again and again and again, where no one wanted to sort of stick their neck out and take a stand on what's been referred to as the orphaned human right at the United Nations. I often tell the story of the press room at the United Nations after the special rapporteurs give their reports. And you have all of the different issues that are being advocated for at the UN, and you have media outside after they deliver the report. And the special rapporteur on freedom of religion or belief would often say, I come to the UN, I deliver my report, I go to the press room, I'm waiting for media, and there's no one there. There are no questions, there's no journalists, no one cares, no one's listening. And I think, and I'll talk about this a bit later, but through the invention of the IRFA, which was the brainchild of Ambassador Brownback, which is the International Religious Freedom or Belief Alliance, we now have a multilateral forum that's really promoting religious freedom around the world, governments from all over, when the UN was not really taking on that role in the appropriate way. And so, I think that the IRF Act, which is what we're talking about today, really laid the framework for creating something like an alliance of countries around the world to shoulder this issue where institutions like the United Nations have largely failed, from my perspective. I'll end there.
Thank you, Kelsey. Nuri, let's shift to your opening remarks, and particularly, how did IRFA direct your work as chair of the U.S. Commission on International Religious Freedom, and still direct your work today as a commissioner?
Thank you very much, David. I'm so glad to be here, and thank you for bringing us all together on this important occasion. It's a privilege to serve with you, David, at Notre Dame Law School Religious Liberty Initiative as the board members in the last 2 years. It's an honor to share a stage with my good friend, Ambassador Sam Brownback and Kelsey. And thank you very much for all your work, specifically Ambassador Brownback, sounding the alarm early on when no one is paying attention to the Uyghur crisis, that the administration you served correctly labeled as genocide and crimes against humanity. I also want to use this opportunity to recognize USERV's former chair, Nadine Mienz. I was an audience, and also the staff team. We always say that the commissioners cannot do our work without the support of our team, professional staff team. I came to this work from a human rights background, as David mentioned earlier. As somebody who was born in a re-education camp during the height of China's Cultural Revolution, and watching how the Communist Party treated religious community as enemy, state enemy, and witnessing the Chinese hostility, the Communist Party's hostility towards religion, particularly the Western religion or foreign religion, as they describe it, Islam and Christianity. When I was appointed to USERV, I had a few things in mind. One, using the platform to elevate the cause, as then Speaker Pelosi specifically intended to put me in this position. And then two, lend my voice to those who are underrepresented. And then three, to see if there's anything within the mandate that USERV could and should have done to advance the religious freedom around the world. As you know, that USERV essentially have three key objectives. One is monitoring and reporting. Every year by May 1st, we have to publish a report that we primarily cover 27 countries for where systematic, egregious, ongoing religious persecution exists. And then we also make a policy recommendations to the President, Secretary of State, and Congress, making sure, as Kelsey pointed out, that the foreign policy issues should include and should be centering around the value-based approach, which is to stick to our strengths, our values and freedom, religious freedom. That is the first human rights for American people. And then the last piece that is very relevant to what I do as a commissioner, former chair, is to engage with civil society representatives, to engage with lawmakers, policymakers, and the representatives from the like-minded governments. I travel around the world. I don't know how many countries that I have been. I lost track of it already. So one of the key messages that I always use my foreign travels engagement with policymakers to get across is that we are too late when we act when the atrocity crimes already commenced. And it's difficult to address, difficult to stop, and difficult to hold those bad actors to account. And then the other piece is that the United States is the only country, the first country to establish essentially 3 offices with the intent to promote and protect religious freedom under the mandate of IRFA. And other countries also should follow suit. And then at the same time, I also advocate that the countries should treat religious freedom as part of their national security concern. Oftentimes, when we work in the space of religious freedom, people can ignore, if not push the issue to the back burner. And then once it becomes a bigger foreign policy, national security crisis, and then we will scratch our heads in trying to find a solution. And this brings us to another point, which is within the mandate of IRFA, with the support of former and current commissions and staff members at USERF, we have advocated legislative and executive actions in response to the upending of Hong Kong democracy in Hong Kong, ongoing religious persecution of Tibetan community, the ongoing genocide and crimes against humanity in the Uyghur homeland. As a result, U.S. Congress passed 2 pieces of legislation, one in 2020, the Uyghur Human Rights Policy Act, commonly known as the UHRP Act, that mandates the executive branch to deploy sanctions tools and hold those government officials to account. It also requires the State Department to publish a report on the human rights situation involving the Uyghurs. And then also directs the law enforcement to hold those government officials, entities engaging in transnational repression in our own country here in the United States. The most significant legislative action that the U.S. government has taken to address the ongoing Uyghur genocide arguably is the Uyghur Forced Labor Prevention Act, which is received bipartisan support, passed and signed into law in December 2021. This particular law has been so effective to the extent as the Chinese government accuses the United States that it affected the health of this manufacturer-based economy. Because this law addressed the intent to address the ongoing and modern-day slavery, where 83 global brands have been implicated. We're adding all the significant number of suppliers. We're talking about a big chunk of the Chinese economy. This tool is very important. It has been enforced since last June. It was a bipartisan bill. It is so significant. It also got under the skin of the Chinese leadership. When this law signed into law in December 2021, the Chinese sanctioned me and several other USERF commissioners in retaliation. And then several months later, we also been sanctioned by Putin. I don't know why, but USERF has been also in the radar screen of Putin. So essentially, USERF commissioners have been retaliated against for us protecting human rights, religious freedom by 2 of the world's worst human rights abusers. The UFLPA is one key legislative mandate, I believe, that came to existence as a result of the foundation laid by IRFA. It has been so widely talked. If you go to even the law firm websites, they have a business advisory. The previous administration and current administration issued business advisory telling the global businesses that the ongoing persecution of ethno-religious groups in China and facilitating, enabling the modern-day slavery have created legal, reputational, and investment risk. And this law has also compelled, mandated, or forced the executive branch to use global Magnitsky sanctions. Ambassador Brownback was an advocate for this legal tool to be used. As of today, 10 global mag sanctions were announced against the Chinese entities and individuals, 2 major entities, 8 senior Chinese officials. That was the first time that U.S. government used the global Magnitsky sanction against the Chinese, sitting Chinese officials. And also, Department of Commerce, Department of Homeland Security, in the spirit of various legislative mandate, have imposed export control on literally every big Chinese tech firms. That includes the Huawei, ZTE, Hikvision. That also imposed export sanction on entities that have an ongoing business relationship with the police department and the Uyghur homeland. So these 2 pieces of legislation and the number of executive actions could not happen, I think it's fair to say, without the foundation laid by IRFA.
Nuri, thank you. And you point up what I think is really a very important fact, that if it would not have been for the foundation laid by IRFA in the 98 Act, it would have been much more difficult to pass these other laws, like you mentioned. Others come to mind, the Global Fragility Act, for example, the Iraq and Syria Genocide Relief and Accountability Act. All of these in some way were an extension of the foundation that was laid with IRFA. Ambassador Brownback, you seem to bring to your office a vision that was unprecedented, and I want to thank you for that. Kelsey mentioned your influence in the creation of IRFA, the International Religious Freedom, Belief, and Alliance. You, of course, took the lead in creating the IRF Ministerial, and today the IRF Summit. It seems as though you had a vision for extending the impact of IRFA through building programs and institutions. What led you to do that, and how did IRFA empower you to do that?
Well, the Act created the position that you could do those things from. So without the Act and the creation of the position, you really can't do that. And glory be to God, it's divine. There's inspiration, and He puts people at the right spot. And it's, I happen to be at the right spot at a time that those things could happen. I do want to, before I launch too far, thank Eric Peterson and you guys, Eric Patterson, I said Peterson, I'm sorry, Eric, for RFI and putting this all together. Just really appreciate that. And I want to recognize Knox Thames, whose vision was the ministerial. Knox kind of put that idea out there, and I was the new ambassador. And one of the things you learn in elective office is to try to grab great ideas when they come up, and you go, oh, that's a great idea. Mike Pompeo was Secretary of State, and I'd worked with him. We were fellow Kansans, and said, let's do it. It's the largest human rights gathering State Department has ever held. That's a big statement, to have something like that. But what you found was once you kind of opened this situation up, or as Mike Pompeo's wife had said, Susan Pompeo, it was like we overturned this rock and found all this terrible stuff going on, is really what happened. And it's true, you've just had all this religious persecution going on around the world. And just before, like Kelsey's pointed out, the UN kind of, I'm not interested. Or, it's just kind of not on my agenda. I guess if we had called it sustainability, maybe if we'd called it sustainability and religious freedom, we could have gotten something done. I don't know. We couldn't get them to do anything. They wouldn't do anything. They didn't recognize it. It was an orphan human right. But now it's gaining momentum. But I don't want to I don't want to conclude at that point, because what I've seen recently is while this movement has grown, let's say we've grown 3x, the problem has grown 10x. That's the issue right now. Right now as we sit here, you've got Armenian Christians fleeing Nagorno-Karabakh. 120,000 were there 2 weeks ago. There maybe are 20,000 there today. And the rest that are left may all be killed or run out, we don't know. But this is happening right now in front of us. And you've got really situations over there. India, who has been difficult to deal with, has gotten much more problematic to deal with. In Manipur state, there was 300 churches that have been burned. And you had an assassination of a Sikh leader in Canada associated with the Indian government. Now, I've not seen the information on this other than what I've read in the media, but these are big charges laid by one prime minister to another. So you got to think there's substantial issues that are there. And that's why we've just got to barrel forward, guys, and we've got to grow the topic more, and we've got to make it a major foreign policy issue for both Republicans and Democrats. If you ever want to think you're going to stop genocides in the world, you have to begin with religious freedom for everybody, because genocides almost always happen to religious minorities. That's who they happen to. And that's what's setting up in various places around the world. So there's a lot of people really to congratulate in this room, and I think there's been a lot of movement and growth. The problem's just morphed and gotten bigger, and we've got to get bigger. And frankly, I think we've just got to get to be one of the top foreign policy issues in both security and policy-wise, in diplomacy and in security. I think religious freedom has got to grow into a top 5 topic that whenever our Secretary of State or Secretary of Defense travels somewhere, one of the 5 topics they're going to talk about is religious freedom, religious persecution. We've just got to get there. That's what it's going to take.
Sam, thank you for your vision. Thank you for that call to action. Tom Farr, in his opening remarks today, spoke of IRFA as an unrealized potential, unfulfilled potential. And no doubt that's in part because it's been met with certain obstacles or impediments with regard to its implementation. So I want us to think together for just a moment about those impediments to IRFA. What are the impediments preventing IRFA from being prioritized and fully implemented as a mandate for U.S. foreign policy? And Nuri, let's turn to you first. We've spoken just briefly about the importance of coordinating U.S. policy on human rights with other policy initiatives and not disentangling those. I want you to talk a little bit about the importance of that and how that can be an impediment to the success of IRFA moving forward.
Through my work with USCIRF and even before I joined USCIRF, a few things have been quite frustrating. One, the level of attention and not everyone, but some policymakers in the executive branch treating religious freedom, human rights a secondary issue, not treating it as the same way that other economic and trade issues taking its rightful place. Even today, we talked about that UFLPA. It's a law. It's supposed to be implemented to the fullest extent. But because of the renewable energy interest of the United States and because of the need to import solar panels to the United States, the law provided 2 years exemption. So that it is making it difficult to fully implement because the American people needs to buy cheap solar panels as opposed to protecting the human lives. So that kind of, giving a kind of a subtle way of letting bad actors to continue, and this is a genocide. It's the Chinese Communist Party's genocide against Uyghur people has a very strong economic teeth into it. It's a race-based modern-day slavery. Every workable individuals at certain age group had to go to perform slave labor to meet that quota. And I think our policymakers know that. And then the second frustration is, because of our geopolitical interests, we look the other way when things, as Ambassador Brownback mentioned, is so obvious, so concerning. We're kind of making the similar type of mistake that we made in 2002 when we delinked human rights from trade in our dealings with India today. I don't think that that's the right approach. And then finally, there's one interesting scenario last fall where UN Human Rights Council was debating a motion to discuss the Commission's report on the Uyghur genocide. We only secured 17 votes. The Chinese secured 19 votes. It's very telling that, from what I heard, Xi Jinping was on the phone pressuring the governments to take the Chinese side. We could not even secure a vote from countries like South Korea, Mexico, Ukraine. So that shows that the religious freedom, human rights issues, to Ambassador Brownback's and Secretary Pompeo's credit, the previous administration was treating it differently than the current. I don't want to sound partisan, but it is what it is. So we have to give these issues its rightful place in our diplomatic engagement. And I think it's really it's a good time for us to look back and learn from the lessons in our dealing with the communist China, and today dealing with Taiwan, India, Vietnam, as we're trying to de-risk the global supply chain. I think the human rights concern should be relinked with our trade and economic interests.
Ambassador Brownback, during your time at the State Department, did you find this to be frustrating, a delinking of human rights and religious freedom from trade discussions, from defense, national security, and other policy concerns for the United States?
I didn't find it frustrating. I just found it a reality. It's just, and unfortunately, having been around a while in different places, and earlier in my career as a White House fellow in the Trade Rep's office, just historically and by nature, trade negotiators want nothing else on the agenda. Because trade's tough enough, and now you're going to load something else on here. Well, I don't want that on here, and so they're going to fight any way they can to keep it off. And I just find what you have to do is you just got to push your way up there, and you've got to make your topic relevant. If you want to grow your economy, you've got to have religious freedom. You've got to make it safe for people that aren't exactly like you, or they're not going to come. You're not going to grow. If you want to have security in your own country, you're going to have to make it safe for everybody, including people that aren't like you, or else they're not going to stay there. You're going to have battles. And so I found in most of the arguments, you've got to make it in a way that's relevant to somebody else or usable. And I would think, frankly, that one of the big cards we have to play right now is in this global confrontation with China and this new Cold War setting that we're in with China. Religious freedom is a classical issue that we want to raise, to push, because of its help here at home and help abroad. Religious freedom for us is a cornerstone human right. For the Chinese Communist Party, it is an existential threat. There could be no more polarized difference on any topic hardly in the world than religious freedom. This is an existential threat to the Chinese Communist Party. They are at war with faith. And we see it as a foundational issue. Now, here's how that plays out then. Africa is a continent in play that both major powers are fighting for. We should go to Africa and say, what do you guys think of religion? And most of Africa is very religious. You align with China, and they are going to put a boot on top of religion, on top of faith, any faith. And just look what they're doing in their own country or their acolytes. Us, we see it as your freedom to choose and as a cornerstone human right. I mean, use it. And then, this is a final point, but when Reagan really went after communism and's talking about it traveling across America, one of the key things he talked about was atheistic communist Russia, Soviet Union at the time, not allowing Jews to immigrate to Israel, not allowing the evangelicals to practice their faith. And why is Reagan talking about this? I mean, it's important to him, but it's also about the heart of America. You can't move the American people strictly on an economic or a security argument. You've got to appeal to their heart. And this appeals to people's heart. This is not fair, what they are doing to their own people. And he appealed to that, and it also delegitimized their government. So it helps us at home, and it helps us really argue our case abroad. That's why I think we ought to elevate this, particularly in this time of this burgeoning Cold War with China.
Thank you, Sam. Kelsey, I want to turn to you, and I want to ask specifically, are we using the tools available to us under IRFA and tools that extend the mandate of IRFA? And I'm thinking specifically, let me give you one example. I'm thinking specifically of Executive Order 13926, which was issued in June of 2020, entitled Advancing International Religious Freedom. Again, like some legislation, a tool that was issued that extends the powers and the framing and the strategy of IRFA. Are we using those tools effectively today?
So I think some tools have been used quite well. And, you know, just to go back to Ambassador Brownback's illustration of the ministerial that he organized, he was sworn in February of 2018, and it was by July of that same year that he had organized the largest human rights conference, and it was on this issue. And I just think that the IRF Act, it creates this framework that we have. It creates many tools, a whole menu of tools, actually. But what we really need is people who are champions who will then light a fire under this engine that's there for us in the legislation. And we really have seen that through the Office of the Ambassador at Large for International and Religious Freedom. And what we've seen, too, is that as the tools, some are expanded. We mentioned the Alliance, which is now a group of 42 countries working together on this issue. And that really transforms the landscape, because when you want to get a case, and if you want governments to be speaking about a case of persecution, rather than going one by one to 42 governments, you can now take it to one alliance. They can speak together with one voice. I think that Ambassador Brownback also did an incredible job of keeping the issue nonpartisan. But as we add more people, and that's really happened, as he mentioned, it's grown threefold, if not more, in terms of who's involved. So civil society has grown, the number of governments working on this issue has grown, it's remained nonpartisan. One thing that we're seeing is that we have all of these tools that are laid out, but we have this issue of, say, defining what religious freedom violations even mean. And so there's been a big push around the world to talk about the abuse of religious groups or religious ideology or freedom from religion, ways to sort of say religious freedom should be about how religion's actually bad and we need to get religion out of society. So we see that as some of these tools expand, there are more issues that we're then facing at times. But in terms of the executive order that you mentioned, David, that's certainly one way forward. It's a good model. So we have in the actual legislation the ability to do visa bans. Those are not being done enough. The ability to issue sanctions, that's rarely happened. Demarches, public condemnation, canceling state visits, suspending U.S. aid. denying credit loans. There are trade implications that could be utilized. These are very underutilized. And the reason they're underutilized is because this is not a top 5 issue in foreign policy. It's much lower. And so for the priority issues, these tools are used. For religious freedom, they're so often not. And the executive order from 2020 really tried to put some meat on some of these tools and say, you know, ambassadors around the world, you have to prioritize this issue. So if you're in a U.S. mission in the Middle East, you have to train your staff. You have to have bilateral meetings on this issue. You have to make it one of your priorities. It also designated $50,000 per year to go to issues around international religious freedom. We saw, you know, even in the case of Vietnam, you know, some of that pressure from that executive order led to the U.S. missions in Vietnam taking a look at some of the religious freedom problems, going out and meeting with the persecuted religious communities, ensuring that the reporting was accurate, and actually, you know, implementing some of the things that are in the act, but that were further enforced through this executive order. The executive order also re-highlighted these economic tools that we already have in the act. And so I think, you know, this is one executive order, but it's actually a really great model for us who are working in this space to continue reminding everybody what's in the IRFA Act, what tools are available, how we can build on those tools and do more with them. And so I think future executive orders or future legislation, like Nuri was mentioning, to build on what we have is really needed.
Thank you, Kelsey. And by the way, that executive order is still current, correct? Nuri, I want to circle back to you. We've talked a little bit about perhaps the problem of emerging technologies in the role of facilitating oppression worldwide. Could you address that a little bit as an impediment to the implementation of IRFA?
The one real danger to religious liberty and religious freedom, human rights in general, is the emerging technology, particularly the AI algorithm. When you look back, the way that the Chinese Communist Party's early action to round it up, it was based on two things. One, criminalizing the religion. That includes 48 behaviors that was encoded in something called de-extremification measure. Some of the Central Asian governments that are member of the Shanghai Cooperation Organization followed that definition, what constitutes extremism or terrorism or separatism. So the Chinese use something as simple as growing beard, wearing religious clothing, adhering to certain lifestyle, including encouraging your children to marry someone from your own ethnic and religious group. So they criminalized 48 behaviors, and then they used algorithm to create this mass arrest list. Something called China Cable that was leaked out, top Chinese official document that International Consortium for Investigative Journalism documented and verified. It shows that in one village, in 10 days, the AI-supported algorithm ordered the police to round up 20,000 people. Of that, the police were only able to identify 16,000. And then under the pressure that they added another 1,000. In just 10 days alone in the summer of 2017, 17,000 people's lives are shattered. And this is largely because of the technology. And even to this day, a lot of people don't know a particular individual, a family member, relative, somebody from your childhood friends end up being in a camp. It's because it's done by the technology machine. So today, because of this testing Uyghur lives as a laboratory and it's been successful, the Chinese government using the same technology initially developed in the inland Chinese cities and then use it in the Uyghurs to refine it and now exporting. Secretary Blinken noted in his China speech last May, 80 countries already in the process of adopting, importing the Chinese surveillance technology. That includes not only the countries that Yusuf covers, the countries that State Department's Earth Office cover for religious freedom violations. That also includes countries like Canada, Germany, New Zealand, and free Western governments. The danger with this new emerging technology provides can be focused on two things. One, ethno-religious groups are already very vulnerable to certain governments and law enforcement, so they will expose them to further a retaliation or control. And then the other two is that using this technology, the governments that are borrowing the pages from the CCP's playbook will justify their repressive policies under the guise of national security. So when they raise that concern, no one can even challenge them. Today, 75 countries use AI technology. Of that, 60 are linked to China's technology. Of that 60, 50 are provided by Huawei. The United States government already identified several Chinese high-tech firms, BGI and the Chinese Military Medical Academy, for developing tools to optimize population, like using female bodies to detect if any pregnant mothers have mental health issues. If there's any sign, they can prevent the baby being born. And then two, they developed this tool that the Commerce Department noted in the a press release in December 2021 that the Chinese Military Medical Academy already developed brain control weaponry to monitor, control behavior, thought process of ethno-religious groups, including Uyghurs and Tibetans. I worry that this will become a new normal, and this would be music to the ears of some authoritarian countries ruled by authoritarian dictators that have been ruthlessly oppressing their own people. This will make it easier for them to advance their political objectives.
Wow.
David, can I jump in here on this? Because I think this is a really key point for where we are today. You know, if you're an authoritarian regime and you've implemented then this sort of spy technology, this virtual police state, it makes it that much more difficult for the people to get out from underneath it. And I've heard the attendance in Chinese churches is way down simply by the government putting cameras outside the church to see who's walking in. And people, I don't want to be photographed and labeled this way. This is really, to me, a key point of something we need to really sound the alarm about and push back against.
Thank you. Let's turn to one final question here from the table, and then we'll open it up to the group. Let's think about solutions for a moment. Ambassador Brownback, you, I think, have rightly said, if we are to more successfully implement the mandate of IRFA, we've got to elevate religious freedom to a top 5 policy initiative. How do we do that? What tools do we use to do that? And I want to ask you first, but then I want to ask Kelsey and Nuri to weigh in on that question as well.
I think we probably have to present it as a top 5 solution to global problems. It's a top 5 problem. It's also a top 5 global solution. Everybody says never again on genocides. We always say that, and we keep getting them. Why do we keep getting genocides? It's always almost always a religious minority. How do we protect religious minorities? Freedom of religion. So if you want to stop this, we got to do that. You want to grow your economies. The world moves now. People don't stay in one place. You've got to provide a welcoming, opening atmosphere, and so this is a key economic development tool. And then, to me, Africa is really one we ought to focus in on because it's a continent in play. China's playing hard for it, has tied up a bunch of the resources there. I don't think we've played as hard as we should, and it is setting up now for a holy war between Christianity and Islam. This thing has started in a lot of places, and it's going to be spurred on by militant Islamists, and there'll be responses that'll take place. And we don't want that. You don't want a continent in flame. And if we want to stop those things, religious freedom and protection of religious minorities is central again to prevent this from taking place. So I think we say, we're the solution to your big problems that you have. And then it's also, I think, a hard issue for the American public. This is something that the heart of the country cares about, and that's where I come from. But you know, they don't like this stuff happening to people, whatever their faith is. They don't like it. And they'll respond, and they'll move.
Certainly agree with all of that. And I would say that, you know, when it comes to everyone working together, there's a big role for civil society to play. There's a big role for USCIRF to play. I don't know if we mentioned, but it's USCIRF that provides all of the recommendations for the countries of particular concern to the U.S. State Department and does a lot of the reporting work that many civil society groups in the State Department rely on to figure out what's going on around the world. And so, you know, in terms of elevating this issue, it definitely relies on the grassroots folks who are exposing the situation, getting the information to the right people, using tools like media to make sure that the American public is aware of what's going on. And then we have this incredible bipartisan commission that was created by the Act that's intended to hold the State Department accountable and to make sure that our leaders really are utilizing a lot of the tools that are available. And I think it's helpful too to point to some of the incredible ways that the pressure that can be put on countries that have violations can be so successful. A few years ago, there was a situation where churches were systematically being closed in India, and it was a situation that some of our allies in India were working on through the court system, and it was going to take many months, if not years, to open these churches through the courts. And a team from the International Religious Freedom Office went and met with the government officials in India, and they had a meeting, and they pulled out a list in the beginning of their meeting, and they said, here are the dozens of churches that have been closed. Here are all the names. Here are all the locations. Before we get started, before we talk about other things, we'd really like to just address this and make sure that these churches will be reopened. And within a few weeks to a month, all the churches were reopened. And so I think a lot of our government officials don't realize that this type of pressure actually can be incredibly effective. And I think the more that they can see that maybe in practice, they'll take on some of those opportunities to really elevate it as a foreign policy priority.
Well, thank you. I have a few additional points to add to those excellent recommendations that Ambassador Brownback and Kelsey made. One is, I work for USCIRF and I represent USCIRF. And it's an important organization that we like to be described as a truth teller because of our independent status from the U.S. government agencies, where our sometimes, publicly can criticize or call our government out when our government is not doing the right thing. But the USCIRF's one of the USCIRF's main challenges today is the lack of resources. The staff is overworked. We have to deal with this reauthorization and the budget cut. If the United States government, American people wants to take this even more seriously, then additional funding, adequate resources should be allocated to the USCIRF's operations. And then the second thing is that, as I alluded earlier, I think we should not be shy away from highlighting, emphasizing, even pushing, twisting arms when it comes to religious freedom issues. When you look back, through my work, I learned that the Bill of Rights laid the foundation for the UN Declaration of Human Rights, and Bill of Rights specifically mentions religious freedom as a first human right. So these kind of things need to be told. I travel, I meet with people. Every time when I mention the listeners, the policymakers, legislators, the ordinary people are fascinated. So these kind of, the very foundational concerns, the value, strength, should be highlighted in our public messaging. The existing public messaging strategy is not working. And then also we need to implement adequately the existing laws. And then also we need to create new laws to deal with the challenges that we're facing as a result of emerging technologies. The European Union is far better protecting personal data privacy. They just penalized TikTok with 345 million euros for misusing children's data. Why do we not have anything like it? There was a very active discussion about how to regulate social media companies. I'm glad that the high-tech executives showed up on the Hill recently, agreed that the AI sector should be regulated. We need to see new laws. And finally, going back to the UFLPA, we have to close the loopholes. There's something called de minimis that exempts products valued under $800. Don't go through inspection. We're receiving 2.5 million packages to 3 million packages, products that are part of that forced labor practices in China. Still people buying that in the United States. So we got to stop doing it as a consumers. We also need to be bold and put in place new regulators. Naming, shaming business entities, as I have been doing along with colleagues and supporters, did not really work. So we need to make it difficult for them on a legislative front to stop making all of us complicit in the atrocity crimes.
Let's open the floor. We have time for 3 or 4 questions. I see someone right to the left here.
Yeah, I just want to know if a government forbids proselytizing, is this a violation of religious freedom? Well,
under the UN Charter, I would say absolutely not.
no.
Yeah, and the Article 18 says you have a right to practice your own faith and to change your faith. So that's specifically in the wording of it. And if you have a right to change your faith, then you have a right to hear from people that may want to present a different option to you. But let these guys that are work it more.
Yeah, I would say there's a general consensus in international human rights law and according to the comments that are used to help interpret the language that included in the right to religious freedom is the right to share your religious beliefs with others. And a lot of countries are getting really tricky in banning proselytizing because they're saying, well, you can't forcefully convert people. And they're saying that any kind action, this is happening in India, any kind action while you're telling about your faith is a forceful conversion, an inducement, which is criminal. And so we're seeing situations in India where there will be a vacation Bible school for children, maybe who don't come from a faith background, and the children are given, say, pencils when they leave, and the police are saying, well, you're inducing them to convert because you gave them the pencils. And so this is a right that we are working really hard to protect, and it is actually in the text of international law clearly protected, but a lot of these laws around conversion are sort of, in a very sneaky way, trying to ban conversion by saying everything is induced or forceful conversion.
Your soul for a pencil.
Great panel, thank you. It seems to me that looking forward, and I'm not an expert, I've only talked to about 300 people in the last year, interviewed them on this topic. And so you've got the name and shame game, top-down legislation. What seems to be missing is we're not even educating our own public. We do tell stories, we do raise awareness, but we're not educating in those stories. So therefore, culturally, USAID, they've just released something that they've been working on 10 years. It took a decade for them to get religion into their humanitarian new program, pilot program. And part of that was inculcating their own culture. Our Foreign Service, they get one course on religious freedom. You know, you become a diplomat. I'm not saying we need to give them cover. I will tell you on the IRF Roundtable that has 100 countries that come together, 80% of the US attendees don't understand the IRF Act in the background. So there's no context. So my question is, what do we need to do to realize for people to rise up from the bottom, the grassroots, and to empower them is also us giving them some framework, some context, knowing what tools are available, what are the avenues, in addition to the horror stories. And I see very few people focusing. We care about Wahhabism in Saudi Arabia in their textbooks, but we're not even educating our own citizens on these principles. And those people grow up and they fill the diplomatic corps and the State Department and the faith roles. So I'm with you in where you want to go. I just feel like that's a big piece missing. It seems to be so pragmatic that nobody is even thinking it's important.
Yeah, and to me, the movement's got to go grassroots. I think we've got a pretty good model out there in the anti-human trafficking movement. I think that movement's done a nice job of going grassroots. And so I travel a lot of different places, and you'll see a billboard up against human trafficking. This movement's got to get down there. And how do you do that across the country? I think you start traveling across the country. The IRF Roundtable, I just participated in one of their grassroots efforts recently in Florida. I just did one in Dallas and Colorado Springs recently, and doing it, just bringing people together, saying, okay, here's the problem, and kind of here's how you can start networking in your community to work on it. This is a beautifully diverse global country. We've got people from every nation, from every religion in this country. They haven't, in many cases, lost contact back home, but now they're rooted here. And just, like Nuri can help, really testify and bring voice to what's happening to the Uyghurs in a way that I can't. You got people all over the country that can do that. And I just think we've just really got to start taking it out of Washington and across the country. And that started, I think we've got to ramp it up pretty fast.
Hello. So I was really inspired by the previous question. So one thing that came to mind for a lot of that grassroots activism is what about college clubs, things like that could really advocate. I mean, a lot of I think it's 50% of diplomats or something like that come from Georgetown, American, Johns Hopkins. So just getting, organizations like that. I don't know, there's probably some that already exist, right? But I think just really a lot of emphasis on that. Maybe that's a policy recommendation sort of for the domestic level, but not quite governmental, but just something to throw out there though, just kind of spitballing. Thanks.
Sounds like a good project for you. And maybe you can sign up some other people in the room to help you too, but you get one club started in 3 of those colleges and we hit a good part of the terrain.
I will say too, if anyone is interested, ADF International puts on legal trainings for law students and university students, and they happen regularly every year. And so we do train on issues like RFRA and IRFA and some of the tools that are available and what religious freedom means. So I'm happy to chat with anyone afterwards who might have an interest or know someone who has an interest in those programs.
I also think we've got to convince and talk to people about religion is not a problem. It's a solution, and it's a nature of the human species. 80% of the people in the world claim a faith of some type. 80%. So the vast majority of people in the world have something in them that they've searched for and that they've grasped a hold of, and that's what they're clinging to. And what a beautiful thing. The search for the divine, the search for the eternal. And I think we've got to start putting ourselves out there as a solution, and whereas I think in a lot of diplomacy, religion is seen as a problem. So it's harmful to good diplomacy. And we've treated it that way for a long time. It's a problem to be avoided, and you're avoiding 80% of the people and you hope to get a decent solution? That sounds like it'll work really well.
One final question.
Hi, thank you all for this panel. It's been really interesting and great. My question is, a lot of the discussion today or this afternoon in the international space has been talking about using the bulwark, the weight of U.S.'s stature in the world to make this point that this is a good national security move, this is good for your population for all various reasons, but all from the standpoint of the U.S.'s position in the world. And I think in the last decade or so, we've seen pushback to kind of the U.S.'s position in the world. You guys are the ones constantly telling us how to do things. You're the previous, you and Western Europe are the colonial powers. And that's part of this shift to looking at Russia, China, other entities for resources and for support because they don't want to have this attachment or reliance on the West. So kind of in reaction to that, has there been efforts to, I don't know if it would be develop voices within the particular communities that you're working in to have it not be coming out of our mouth, so to speak, but coming from grassroots locally, to be a voice that somebody's going to look at and not be viewing as the baggage of the Western power, but and Western interventionism and meddling, but to be something more local uprising, so to speak. I'm just wondering how much you guys see that aspect being part of the problem.
I'm happy to jump in. I think that's a really important point. And I would say in my work, when it comes to legal cases around the world, we are told by our partners on the ground in many countries that in certain cases it would be much more helpful to hear from certain parts of the world and not necessarily the US or the West. And I think many of you probably heard from Nadine on the previous panel. She's been overseeing a lot of these roundtables around the world. And these used to be, many years ago, just these small little meetings here. A few members of civil society would come and share some stories and talk. And when Ambassador Brownback came into office, he's like, I'm going to attend these every week. And so all of a sudden, we had people swarming here. They wanted to meet you, Ambassador. They wanted you to hear from them. They wanted to share their stories with a U.S. government official there. But that roundtable exploded and is still, I think, such a great group. It's now virtual, so people can attend from around the world. But they have created roundtables all around the world so that there are roundtables, say, in the Middle East, and there are groups of people who are meeting there, who are from there, who are speaking out from the region where these issues are happening. And I think that has been really effective. We've also mentioned a few times this alliance of 42 countries. And so now, because of the IRFA Act, the U.S. really does have a unique position on this issue. No other country has a piece of legislation like the IRFA Act. No other country. The United Kingdom currently is looking into perhaps proposing one, but it doesn't exist yet. And so because of the IRFA Act, we have this really special position, but Ambassador Brownback's team had this incredible idea of sort of globalizing it, sort of exporting it to other countries and saying they should, let's get them on board. Let's not have this just be a U.S. issue. Let's have lots of countries take ownership over this. And that has happened, and it's a growing alliance. of countries from different regions around the world. And I think it is really powerful for countries like China to see, oh, it's not just the US speaking out against us. It's 42 countries and growing that are saying something.
Well, as moderator, let me make 2 closing remarks. First, I love the idea about education. I think that's really where the solution is to be found. And I want to mention that, other than the family and the church, education is the gateway to changing culture. And culture is the key to this movement. I want to mention, if you're a college student and you're here today, the Religious Freedom Institute, we host college seminars in different places across the country. 3-day and 4-day seminars for college students to come and to study and dialogue and discuss the first principles, foundational principles about religious freedom. We've done that 4 years straight here in DC. We do it in Philadelphia, 2 years in London with students from the US and the UK, in northern Iraq and Kurdistan this year, next year, and in other places across the US. We'll do it and launch in 2024. We believe education is vital to this movement, and we'd want you to be a part. If you know a college student, have a son or daughter, we'd love to have them participate. Finally, I just want to thank our panelists. Tremendous people, experts, and we are so grateful for your commitment and your vision. Thank you so much.
Well, just a few closing remarks before we end the day. Again, I'm so thankful to this panel, to my friends here, and to the other panelists who we heard from earlier in the day. And it's at these events, I don't know about you, but I wonder, am I supposed to feel discouraged because the world is full of wonderful people, but so many are facing this type of persecution? Or am I supposed to feel encouraged that there are energetic people fighting the fight? And I think back to 1983, 40 years ago this year, Ronald Reagan gave a speech to the National Association of Evangelicals, and it was largely driven by an understanding of religion in American public life. But we know the speech as the evil empire speech because he pointed at the Soviet Union and called it an evil empire and a source of evil in the modern world. And as I think back to this 40th anniversary of that speech, a couple of things come to mind as we start to leave today. The first one is that Reagan said, in our own society, religion is foundational to who we are and to our history. And our panels this morning, the RFRA panels in particular, identified that generation after generation in the United States have recognized the power of our religious foundations and religious diversity, and that has to be protected by religious freedom by each generation. And then he pivoted in his talk, and he talked about why the Soviet Union was evil. One reason that it was evil is because it repressed the natural religious impulse of its citizens and its neighbors. And the second reason that it was evil is because the communist elite believed that human institutions like the family were false social constructs that could be reconstructed or broken apart, and that the human nature, our own person, was malleable, and that communist elites could reconstruct essential human nature. And that's wrong, and it's evil. But Reagan didn't end with doom and gloom. Remember, this is the speech where he said, America must keep alight the torch of freedom, not just for ourselves, but for millions of others around the world. In 1983, it seemed pretty dark if you think back to the time, but just 6 years later, it all started to crumble. The Berlin Wall fell, the Soviet Union started to disintegrate, and that huge anti-faith, anti-religious freedom bloc that denied fundamental human dignity that we talked about today, it was gone. And so I leave today, by my list, I have 28 different policy recommendations that we've heard from people. You probably have a similar list, and they're all concrete, actionable things that our government and our non-governmental sector and we as citizens can do. So I personally lean towards the encouraged. I'm encouraged because we have warriors out there fighting for this here in the U.S. and abroad. So as we close, I hope that you'll join us in that fight. If you're a student, that you go through one of the programs or prepare to join it. If you're a citizen, that you'll hold our representatives accountable for making this, keeping these principles, part of our foreign and domestic policy framework. And perhaps you have a calling in this space. Any of these people would love to tell you how you could get involved, particularly those of you who are interns thinking about the next step or students thinking about the next step. There's quite a few of you here. There's a role for you in fighting for religious freedom in this country and abroad. Thank you very much.